Every day in the USA, people find themselves in court.
May 28, 2025. I'm David A. Rickey, District Judge. I will note for purposes of today's docket, Darren Deviney, Butler County Attorney, appears for the state of Kansas and the interest of that office. First case that I have on the list this afternoon is State of Kansas versus Jeffrey Allen Jones. There's an individual seated at the jail Zoom location. Are you Jeffrey Allen Jones?
Yes, sir.
This is case number 2024 TR 2733. I see an order of bench warrant bond forfeiture. According to the paperwork, you were to have appeared on April 23, 2025, and you did not do so. Mr. Jones, why is that?
I had the date written down wrong in my calendar on my phone.
Bummer.
Yeah.
And now you're in custody. On a no bond hold out of traffic court. The next, let me see, Mr. Jones, the charges that are currently before the court apparently are driving while your license is suspended or canceled, a Class B non-person misdemeanor, punishable by up to 6 months in the county jail and up to a $1,000 fine with a $100 minimum fine, or both the jail and the fine. How do you plead to that charge?
Guilty.
All right.
Just turn it off if it's because my speaker was working.
Right. If there's somebody on this meeting who isn't being called, they need to stay muted until their case is called. All right. Before I can accept your plea of guilty, Mr. Jones, you'd have to be willing to waive legal counsel in the case. You do have the right to an attorney and their advice in this case. And if you can't afford one, the court can appoint one for you. Are you sure you want to enter a guilty plea?
Not guilty then.
All right, then I'll enter a plea of not guilty then. We will set a future court date. Can you afford to hire your own lawyer?
Not right now. I can't.
Are you
I'm not
working?
even sure. I'm not even sure I still have a job.
Okay. I will appoint Darren Patterson to represent you and set your case for August 4, 2025 at 8:00 a.m. Again, that's August the 4th at 8:00 in the morning. Judge Webster's Court. That'll be a Zoom docket.
Okay.
You must fully participate at that time.
Okay.
All right, Mr. Jones, we need to discuss your status. Do you have other holds on you besides this case?
No, I do not, sir.
Okay. Well, what I'm worried is that you're going to write the date and time down wrong again on your calendar, and then you're not going to show up next time.
No, he gave it to me right here.
That doesn't mean that you're going to refer to it and show up for court now, does it?
Oh, it does. I don't like being in here.
Okay, I get that. How long have you been in there, Mr. Jones?
A week.
Have you?
Yes.
What do you mean a week? What day did you go in?
Last Thursday.
You didn't make an appearance on Friday?
I was told when they booked me, I was supposed to appear on Friday. I got called down here and they said I wasn't on the docket, so they sent me back to my cell. And then I wasn't called yesterday.
All right. Mr. Jones, where are you currently residing?
Columbus, Kansas.
Okay. Does Columbus, Kansas have addresses?
Yes, 319 North Pennsylvania.
Okay. In Columbus, Kansas.
Yes.
All right. I think a valuable lesson may have been learned today, Mr. Jones, about showing up for court when you're supposed to.
Yes, sir.
And you've got that date and time on a
Yes,
paper
sir.
before you?
Yes, yes, I do, sir.
State, take a position regarding bond here, Mr. Deviney.
Your Honor, his prior bond was a $1,000 OR bond initially. That, as you said, escalated to a no bond hold fairly quickly. And I'd say, given the fact that he's already done potentially about 5 days in custody on this case, I think a $1,000 cash or surety would be appropriate, but to make sure he attends his next court appearance. But I think that we need to revise the no bond hold status.
I agree. Court will set bond at $1,000 cash or professional surety required. With the assistance of a bondsman, you should be able to obtain your release, Mr. Jones.
Thank you, sir.
1,000 cash or surety, but don't forget about that court date.
I will not, sir.
Okay. Anything else at this time we need to address, Mr. Devaney?
Not that I know of, Your Honor.
All right. Then the Jones matter will be in recess at this time. We'll move on to another matter.
Thank you, sir.
Are you Daniel Snyder?
Yes, I am.
All right. This is State of Kansas versus Daniel O. Snyder. Is Okay, are you Luke Nelson?
Yes, sir.
This is State of Kansas versus Luke Alexander Nelson, case number 2025, CR 224. Darren Devaney appears for the State of Kansas. Luke Nelson appears from the jail Zoom location. Docket notes from Judge Crumb's court indicate that there was a court appearance apparently scheduled for May the 14th of 2025. Defendant failed to appear. Defendant apparently was on the first appearance docket the Monday before and advised to appear on the 14th. Defendant was not in custody. The court issued a bench warrant with a $3,500 cash or surety bond. You apparently were picked up on a warrant, Mr. Nelson.
Yes, sir.
Why didn't you just appear on the 14th when you were told to?
I was not aware. I was at St. Joe's Ascension Hospital for 4 days, and I did not have my phone. It was in the possession of the police. They had found it one day, and somebody had turned it in. And I didn't hear about it till the day I got back from the hospital, and I immediately tried to call the courthouse to try to set a date. They were not able to do so. I even went to the police station itself to try to turn myself in and set a date. And all they did was give me the first page of the police report. And I've tried since then, and nobody gave me any information until my grandma called me and told me, hey, the sheriff's just stopped by here. They're on the way to pick you up. And I met them outside, and here I am. But yeah, unfortunately, I just wasn't aware of the first one due to being at St. Joe's.
There, you do have a bond established by Judge Crumb at $3,500 cash or surety. The charges pending are interference with law enforcement, a level 9 non-person felony in case number 25 CR 224. And count 2 is criminal trespass, a class B non-person misdemeanor. Count 3, criminal damage to property, a class B misdemeanor. The felony is involved, so the proper scheduling would be on Judge Crumb's felony preliminary hearing docket. And that would be June 16, 2025 at 2:30 p.m. That will be the next scheduled court date in Judge Crumb's court for you, Mr. Nelson. June 16, 2:30 p.m.
Judge, I show this as Satterfield's case.
That's correct. That is correct. All right. Then I'm going to reset your date, Mr. Nelson. Judge Crumb did the first appearance. However, this is Judge Satterfield's assigned case. Judge Satterfield's docket would be July the 14th at 2:30. July 14, 2:30 p.m. That is the next court date. The thing that troubles me, Mr. Nelson, you act like you didn't have information, but the docket notes indicate that on the 14th of May, you were advised to appear, well, excuse me, you were advised to appear on the 14th. Apparently told that the Monday before. You're saying that's when you were in the hospital?
Yes, sir. I've my grandparents have my the notes from the hospital. I still have my packet from the hospital. Uh, yeah, there was a few days where I was where the issues had arisen, and I sustained a bunch of injuries throughout that time and was having some difficulties. So I went to St. Joe's, and I was there for 4 days recovering. And yeah, as soon as I got back home is when I heard about it. Because up to that point, I had no phone, no contact with anybody that I knew. Uh, yeah, it was a rough week, but I've managed to recover my phone and my wallet since then, and all that stuff. But yeah, I was not aware of the date till I got back from the hospital.
Shavini, this court was far less concerned about a June 16 court date. However, noting that it's Judge Satterfield's case and it's not going to be heard until July the 14th, court's concern arises. Your recommendation regarding bond status here.
Well, Your Honor, we're looking at, felony charge and 2 misdemeanors. Not fully aware of every detail of the case, certainly, but I still think a $3,500 cash or surety bond seems to be reasonable given the fact that the felony charge is interference with law enforcement.
Mr. Nelson?
That seems reasonable to me. So yeah, I just got to get a hold of my grandparents because I was supposed to be moving into the Second Chance house today. And I had a meeting with the South Central Mental Health Facility tomorrow to get me into a program with them. I've been going to AA every day and doing this proper steps to try to correct everything that has been going on. So yeah, I will try to get that bond paid off as fast as possible. So yeah, I can actually
All right.
show you guys that I'm doing what I'm doing.
All lead bond, we're set at $3,500 cash or professional surety required. You're not to have any contact with the victim or her property or the witnesses that are endorsed in the case as conditions of that bond, and of course appear for all scheduled court dates, Mr. Nelson.
Yes, sir.
Okay, now, can you afford to hire your own lawyer?
It's entirely up to my grandma. I cannot personally, but my grandma was going to help me with this whole process.
All right, then I'm going to appoint James Watts at this point. You can replace Mr. Watts with your own lawyer of your choosing at any point.
Yes, sir.
But for now, James Watts is appointed to represent Mr. Nelson. $3,500 cash or professional surety bond remains. Court date with Judge Satterfield, July 14th, 2:30 p.m. You must appear at the Butler County Judicial Center in El Dorado, Kansas on that date.
Yes, sir.
For your next court appearance, Mr. Nelson. Okay?
Yes, sir.
All right. That should conclude the business in the Nelson case at this time. We'll move on to another matter. All right. Paula Smith.
Yes.
This is State of Kansas versus Paula Smith. It's case number 2023 CR 387. Darren Devaney again appearing for the state. Ms. Smith from the jail Zoom location. I have a warrant to show cause alleging probation violation, failing to obtain suitable employment, failing to report as directed, failing to attend MRT, failing to make any payments toward the case, and failing to do. All right, I want to take up Richard Paul next. That person could fully join, including unmuting themselves.
Hello, Your Honor.
You're Richard Paul.
Yes.
This is State of Kansas versus Richard Hal Paul III. It is case number 2025 TR 845. Darren Devaney appears for the State of Kansas, and Richard Paul III appears on his own Zoom. This is a summons case. Do you have a copy of your charges before you, Mr. Paul?
Yes, I
Well,
did.
all right. Count one alleges driving under the influence charged in the alternative is a Class B non-person misdemeanor. This is punishable by up to a $1,000 fine and up to 6 months in the county jail. How do you plead to this charge?
Am I able to plead no contest or not guilty without a lawyer present?
If you want to talk to a lawyer, you need to plead not guilty.
Not guilty.
Court will accept the plea of not guilty. Are you going to hire your own lawyer?
No, I can't afford one.
Are you working currently, Mr. Paul?
Yes.
Okay, where do you work?
I work at bowling alley. It is the Holiday Bowl, 310 State Street in Augusta.
How much money do you make at that job?
I make $15 an hour.
Okay. All right. Okay, when it comes to your ability to hire a lawyer, you're probably in a 7-10 split situation here, Mr. Paul. So I'm going to go ahead and appoint a lawyer to represent your interest in the case. Darren Patterson will be appointed.
Okay.
We're going to set your case for next appearance August 4, 2025, 8 o'clock in the morning. That is 8 o'clock a.m. Mr. Paul, that'll be a Zoom docket. You'll need to make sure that you personally participate in that docket. August the 4th, 8 o'clock a.m., Judge Webster's Court.
Okay, how do I get hold of Darren Pat? Yes, sir.
Okay, I need to address something else first, Mr. Devaney.
Okay.
Mr. Devaney, what bond are you recommending here?
Your Honor, it looks like we had a first appearance back in March. We didn't have the reports at that point, but I believe he had to post a $1,500 cash or surety bond back on March 5th. He was, of course, released from that bond, and then we summoned him in here today. He's, as I said, previously posted a bond, but he does appear voluntarily. So I think a $1,500 OR bond would be appropriate today.
All right. Now, I don't have an executed bond in this file, so I have no doubt that what you're telling the court is 100% correct. I just can't verify it. I was hoping we could maintain him under that original bond, but if he was released from it, court will set a new bond at $1,500 OR. All right, you live in Mulvane, Mr. Paul?
Yes.
Okay. I think we're going to put you in a breakout room with Court Security 2, unless Court Security 2 can just give you direction as to what you need to do to get that bond posted.
He
Okay.
just needs to come to judicial and sign his bond.
Can you do that today still, Mr. Paul?
I would have to get a ride arranged to do that, so probably not.
Tomorrow?
We
Do
could
it.
have it at the front desk and he can come in tomorrow and sign it.
Okay, and this is in El Dorado, correct?
Correct. Come to the
Okay.
Butler County Judicial Center in El Dorado, come in through the front door to the security desk. They'll have your bond and you can execute it there, then you can go.
Okay.
If you don't take care of that, you're going to have a lot more hassle. All right.
I do have a question for you regarding that. So when I did get arrested and I was released, I had a bail bondsman come in and post bond for me to be released. I paid $150 up front to him. So how do I go about paying him back? Does this have to do with it, or
I don't know about paying him back. Sounds like maybe you've already taken care of that, but the
okay.
information that I was given is that you were released from that bond.
Yes.
So you have to post a new one.
Okay.
Okay. So this is an OR bond. It's an own recognizance bond. You won't have to put up any money.
Okay. I see.
As long as you come in tomorrow and take care of it.
I'm in tomorrow and they'll tell me what to do.
I think that's, yes.
Yeah,
Yeah.
okay. Do I need to bring $1,500 with me tomorrow?
You can if you want to, but you're not gonna need it for anything.
Okay, that's all my questions. Thank you.
Okay. You just make sure you appear in court each and every time on time.
Okay,
All right, or you're gonna forfeit $1,500.
sure, understood. Thank you.
All right. So 1,500 OR with him reporting to the Judicial Center tomorrow in El Dorado to execute that bond. All right. Anything else at this time on him, Mr. Devaney?
No, Your Honor.
Anything else, Mr. Paul?
No, Your Honor.
You can leave the meeting at this time, Mr. Paul.
Thank you.
Okay, I'm looking for Justin Blake Stahlecker.
Your Honor, I'm not sure that the warrant's been executed yet. We attempted to serve. We failed to be able to, we were unable to serve, but we did have a warrant that was filed May 23rd. I was not aware he's on the jail sheet, and I do not anticipate that he is going to attend here today.
All right, then he'll be scheduled for future appearance. Once apparently he's picked up on a warrant. I see a summons in the file, but
The process of preparing the warrant to get that signed, as the address was no good for the defendant.
very well. All right. There's no business to be conducted on that case at this juncture. So we'll move on again to Stephen Marshall Ray. Do we have Stephen Marshall Ray on this meeting? For security location have him?
I do not. I only have one person here, and that's Mr. Davis Whitney.
Okay. I will call then formally State of Kansas versus Stephen Marshall Ray. It's case number 21 CR 326. Baron Devaney appears for the state, but there's no appearance from Stephen Marshall Ray. I do have a bond executed out of Sedgwick County for $2,000 with the court date of May 28th, 2025, 1:15 p.m. So that the defendant apparently had notice of his obligation to appear on this docket and has not done so. This is a serious case. Warrant to show cause apparently involving felony conviction. So the court will order a bond forfeiture and a bench warrant issue for the arrest of the defendant, Stephen Marshall Ray, with him to be held on a no bond hold pending further proceedings in the proper court, which would be Judge Crumb's court. Mr. Devaney, is there anything else that you believe we need to address here on Stephen Marshall Ray?
No, Your Honor.
All right. Moving on then. Salvador Miguel Roberto. Salvador Roberto. Let me look at this one. I see an appearance bond in this file. For May 28, 1:30 p.m., cash bond, Salvador Roberto posted it in the amount of $5,000, which we don't see every day. All right, court
Your Honor.
security. Yes.
That might be that Stephen Ray, because I believe at one time that lady called him Stephen.
Okay. If I can just get him on the meeting with full audio.
I don't understand why I'm not getting audio.
Stephen Ray,
Yeah, unless it's not that worked.
may just
They
need
may
to
have
turn up
been-
their speaker volume, but
Get back in the picture. Excuse me. I don't know. It's not.
Judge,
Oh, no.
am I supposed to click that?
Hold on.
The chat button?
In the
right?
chat, yeah.
Are you still not able to hear us?
What's it saying?
Typing in
Hey, we'll type it.
now, right?
Yeah. Yes.
I can hear.
Oh, really? Yeah. Showing the mic's on.
Stephen Ray,
Why don't you go over to Tyra's office? They can hear us. We're gonna move him over to another office real quick, please.
Judge, I think he actually might be in Sedgwick County Jail. He might be at some halfway house or something. I think now that Sedgwick County's on there, he'll probably come in.
we'll wait.
Ready? Yeah, so you're just gonna, here, you can sit here.
Stephen Ray,
Yes.
okay, I get a response.
Yes, sir. I can hear you.
Okay, Stephen Marshall Ray.
Yes, sir.
All right, this is State of Kansas versus Stephen Marshall Ray, case number 2021 CR 326. Darren Devaney remains appearing on this docket for the Butler County Attorney's Office in the state of Kansas. Now, Stephen Marshall Ray joins the meeting fully by Zoom. Earlier, this court had ordered bond forfeiture and a bench warrant issue for Mr. Ray's arrest due to non-appearance. Mr. Ray, I'm going to set aside that order. We're going to conduct some business here. Okay?
Yes, Your Honor.
All right, Mr. Ray, first of all, I've approved your bond of $2,000 with, I'm not sure who the surety is because I can't read it. Oh, Uncle Bill's bail bonds? Correct?
I thought it was somebody else. I wasn't sure the name though. My mother and my father took care of it, Your Honor.
All right. Anyway, there's a $2,000 apparent surety bond out of Sedgwick County that I'm going to maintain Mr. Ray under now that he's appeared. All right, Mr. Ray, I see before me that this is a probation matter. Allegations are pursuant, this is all from your Sedgwick County ISO, failing to report, failing to obtain and maintain full-time employment, failing to pay your court costs as directed. Further hearing will need to be set before your assigned judge, the Honorable Chad Crum. Judge Crum's next docket for that purpose would be June the 20th, June 20, 2:30 p.m. Now, I'm going to order you to appear at the Butler County Judicial Center in El Dorado, Kansas. No other location. If you want relief from that order, you're going to have to contact Judge Crum's office and he would have to change that order. But for now, you're ordered to appear in person at the Butler County Judicial Center in El Dorado, Kansas for your June 20 at 2:30 p.m. hearing before Judge Crum. Mr. Ray, can you afford to hire you a lawyer to represent you on this?
No, Your Honor.
Okay. You had attorney Gerard Scott before. I see you're in custody. Undoubtedly, your financial situation is strained. So the court's going to reappoint Gerard Scott. Court date we've set. And bond, obviously, you've already posted. Are you still reporting to an officer over there, Mr. Ray?
As today, I was picked up by the residential program.
Okay. Would you anticipate that you would be there continuously between now and the time of your hearing?
Yes, sir.
Okay.
This for 4 months, I'll be here.
Okay. Well, I will certainly cover your court date over here, which is June the 16th at 2:30 p.m. If you need to be over here in person for that, unless Judge Crum authorizes otherwise.
Your Honor, I believe it was June 20th was Judge Crum's warrant to show
Oh,
cause.
I was looking, yeah, you're right. Thank you for that clarification. June 20 at 2:30. I was looking at the wrong list. Okay, I don't want you confused. Mr. Ray, what date do you have down?
I have June 20th at 2:30 p.m.
That is correct, with you being over here at the Butler County Judicial Center in El Dorado, Kansas. Okay, well, I'm glad we got you taken care of today, Mr. Ray.
Thank you, Your
I
Honor.
do appreciate the efforts of Sedgwick County Community Corrections to make sure that you appropriately participated in this hearing. I know there were some issues there regarding technology, but I'm glad they were able to get those solved. So I appreciate their involvement here. All right, any questions about what we've done here today, Mr. Ray?
No, Your Honor.
Anything further at this time from the state? Mr.
No, Your
Smith?
Honor. No, Your
All
Honor.
right. I think that is the last matter to be addressed on this docket. This will conclude the Ray case and the first appearance docket of Butler County at this time, and the meeting may be ended for all.
All right, thank you, Your Honor.
An issue for the arrest of Salvador Roberto, with him to be held on a no bond hold pending further proceedings in the court. That matter now addressed, we'll move on to Keegan Wayne Davis Whitney. He's out at the court security location. This is State of Kansas versus Keegan Wayne Davis Whitney, case number 2025 TR 1218. Darren Devini again appearing for the state. And I think Keegan Wayne Davis Whitney is at the court security Zoom location at the Judicial Center, correct?
Yes, Your Honor.
All right. I see that a bond's already been posted. Charging document indicates count one's charge of driving under the influence, a Class B non-person misdemeanor, and count two, transporting an open container of alcoholic beverage, an unclassified misdemeanor. Class B misdemeanors are generally punishable by up to a $1,000 fine and up to 6 months in the county jail. There'd be a minimum fine of $750 on the DUI. Transporting an open container carries a penalty of up to 30 days in the county jail and a $500 fine or both. Knowing these things, Mr. Whitney, what are your intentions regarding a plea here today?
I was
Do
not
you want to
ready.
talk to a lawyer about this?
Yes, I would like a court-appointed attorney.
I'm going to enter a plea of not guilty then. We're going to set this for further proceedings. Why do you need a court-appointed attorney?
Because I cannot afford one, Your Honor.
Are you working currently?
Yes, Your Honor.
Do you work?
Yes, Your Honor. I work at Kansas Land Tire off of 21st and Amadon in Wichita.
Make pretty good money there, don't you?
$15 an hour.
Do
But
you have other
right
dependents
now,
that you support?
sorry,
Do you have other dependents that you support?
no, sir.
And you don't think you can afford to hire a lawyer to represent you on this DUI case?
No, Your Honor.
All right, I'm going to make a finding of partial indigency. And I will appoint a lawyer, Darren Patterson, to represent him. Court will set the next court date for August 4, 2025, 8:00 a.m. Judge Webster's Zoom court. You must fully participate by audio and visual means at that time. Mr. Davis Whitney,
Honor. Yes, Your Honor. I understand.
despite the fact you have an attorney, you have to personally appear on that meeting.
Yes,
8:00
sir.
a.m.
Yes, Your Honor. I'll be there.
I've approved your bond with second chance bail bonds in the amount of $2,000. Security's appearance here today. I will maintain the defendant under that bond in future proceedings.
Can I ask a question, Your Honor?
Well, you can. I may or may not be able to answer it.
What is the 4th? Is that a Friday?
Probably is a Monday.
Monday.
Mhm.
I hate to ask this, but is there any chance that we could change that to a Friday, because that's my day off of work? And no, that's my day off of work. I'd like to be able to make all my work hours as well as be here for court.
You can talk to your attorney about that, but
All
these
right,
dockets are generally conducted on Monday mornings.
all
Only.
right.
So I
Yes,
think
Your
at
Honor.
this point, the only date I can offer you is a Monday. Anything else would have to be specially scheduled with your attorney and the judge, and I don't know what the likelihood of that would be. So
Yes, Your
for
Honor.
now, I have to set it at 8:00 a.m. on Monday, August the 4th.
Yes,
It's
Your
a
Honor.
fair request. I just don't have any dates before me that I can give you.
All righty, that's understandable.
Okay, so we've got your court date set. Darren Patterson appointed as your lawyer, and your $2,000 second chance bail bond has been approved by the court. Anything
And
else we need to do here, Mr. DeVinny?
No, Your Honor, not for the state.
All right, Mr. Davis Whitney?
It is gonna be here. I have to come back to this court office.
You certainly have that option. You certainly have that
All right.
option to do so.
I'd prefer to come here. I would.
Okay. That
Just
way,
so I
it
can
would-
have,
it wouldn't be a technology issue. So
well, that, and I'd like to have a little bit of time beforehand, to talk to my attorney, if that's okay with you.
you very well may be talking to him from that location by Zoom. You can contact Mr. Patterson prior to court and perhaps get an appointment with him in his office. But yes, you certainly can appear at where you have today to participate from there. And quite frankly, I think Judge Webster would probably prefer that you did.
All right. Yes, Your Honor.
All right, very good, Mr. Davis Whitney. Appreciate your patience today.
Thank you.
before we Get to you. I can go ahead and release you at this time. All right, Mr. DeVinny, to my knowledge, that's all the cases that were scheduled to be on this docket. I've got a Robin Gibbons box that apparently has a person in it. I'm not sure why they're participating in this Zoom meeting. Perhaps that box can come alive and tell me. Okay, is there someone in the Robin?
Every day in the USA, people find themselves in court.
Go.
Looks like the jail has them hooked up.
Just to confirm, I've got 4 on Heather Sproul, the trespasses, and then the CCW on Skylar Weir, right?
Yes. Hello, Miss Sproul. This is Judge Middleton. I'm doing some jail arraignments today. The magistrate is off and Judge Pattison is off. And so I'm here. Heather, we've been chasing you for a few months now. Let's go through these. File 242194OM is a trespass in the city of Sturgis on December 11th, 2024. And you didn't show up several times. I thought I gave you a bus pass on one of these. Anyway, you didn't show up several times and we issued a bench warrant. That was December 11th of 24 was the date. The next one is 2231. That was December 17th, another trespass that you failed to appear on multiple dates. The next one was 25294OM, another trespass from February 14th of 2025. And another one, 25365OM, another trespass. Finally, I just gave up and issued bench warrants on all four of these. And the bond was $450 or $250 per file. You also have that old file from 23 where you and some others stole that $8,000 from that man, his computer, and you still owe money on that. Now, somebody wrote me a note that said you've got other charges. Do you have other charges other than these?
No, only trespassing, no.
Just these trespass?
Yes, sir, yes. It's because I'm homeless and I don't have to live.
I understand, but you can't just keep blowing off the court dates. They give you a ticket, you don't show up. They give you another ticket, you don't show up. They give you another ticket, you don't show up. So we don't get anywhere. With us is Mr. Chief Keith Stickley, the Chief Public Defender. There's no other charges other than these?
Oh,
I didn't see any.
Not that I'm aware of either.
How did you come to get arrested last night, Miss Sproul?
where we were sleeping, they come to tell us to move. Or we're gonna get trespassed again.
So it was
And
another.
He read my name. He read my name. He didn't give me another ticket. He just told me we had to move.
Where were you last night?
Next to Downs. In the woods.
In Sturgis?
Yeah. Dunham's and Farmer's Fleet, back to kind of like behind Arby's or whatever.
All right, well, at this point, I'm gonna show you're gonna plead not guilty on all these. Today is Wednesday. I don't have another pretrial day with the Sturgis City attorneys until next Wednesday. So I'm gonna set these for pretrial for June 4 at 8:30. You also owe a bunch of money. As I said, you and Tim Weller and some others took that $8,000 from that man, which ruined his life. He ended up being homeless again. He had a good job and was doing okay, and you guys pulled a rug out from under him. So maybe by the time I see you, we can deal with that one too, and maybe I can erase some of the jail time for that one. But I'm gonna leave the bonds at $250. Every time I set a bond, or every time I set a hearing, you don't show up. Between these four files, there are probably 15 times you were supposed to be in court and didn't come. Now, sometimes you didn't even know about it,
No, I
but
didn't.
sometimes you did. Every time you got a ticket, it had an appearance date on it. If I let you out, have you got anywhere to go?
I could go to my aunt's house, she, lives on 21307 US 12. It's Bonnie Myers. Is my family.
Who was with you last night?
I was by myself.
So they just picked up you?
Yeah,
No, did anybody else get a ticket?
No, because I was the only one there. George Rosario, my boyfriend, was out getting the money, trying to get, pop bottles.
Did you get another ticket last night?
No, sir.
All right. They probably figure, what's the point? So I don't know. What the city attorney will do is probably resolve all of these, and you shouldn't be just incarcerated because you're homeless. It's a struggle. The people they're on other people's property. They're told not to be there. They come back. At least it's summer now, so you're not gonna freeze to death. But my fear is if I let you out, you're just not gonna show up again. And plus you
If
got
I
that
have
other.
bus tickets, I can. If I get some bus tickets, I could. If I have bus tickets, I could.
All right, well, I'll give you bus tickets when I see you next, but this, I said, is a dozen or more times that you failed to appear. And because you're homeless, you don't have any money, so you haven't made any payments on that electronic funds theft that you pled to in 2023. So bonds all are gonna be $250 a piece. You're gonna get 3 meals a day and a shower and be safe until I see you next. Looks like you dyed your hair. Is that
Yeah.
pink?
No, it's red.
Red? Okay. All right. I'll see you next Wednesday morning. Maybe we can resolve everything you got. But the bonds are $250 a piece.
There ain't nobody can do that.
No, you're good to go. It's not cold. It's not particularly warm. It's gonna rain tonight. But I want to know that you're safe and warm and you're gonna show up. So I'm leaving the bonds as set. Like I said, finally at the end, I just gave up and set a bench warrant in each case. And then I figured sooner or later but these bench warrants have been out since February or thereabouts. Yes, all right, you're good to go. I'll see you next Wednesday. I don't know what else to do with her.
Oh,
There
did you
was
hang up on the
another-
jail, Judge?
What?
Did you hang up on the
No, I
jail?
put him in the waiting room
Oh.
while she leaves. Another man who had been homeless and got a job and saved $8,000 and got an apartment and he let them move in and they just took over and took all of his money and he ended up homeless again. In fact, he may have died. It just completely unraveled his life. I don't know if they can see her or not. I don't have anything. I don't have I just have the booking and bond information in this case. I don't have any file on the guy in our system. I don't have a criminal history. I don't have a praxis.
I'm not sure that the paperwork was even completed, Your Honor, to be honest with you.
Hi, we're done with Miss Sproul. We'd like to swap her off for Skylar Wired. All right, thanks. Bye. Good morning, sir, or good afternoon, sir. Are you Skylar Wired?
Yes, sir.
I'm Judge Middleton. Also here with me is Mr. Keith Stickley. Join us in a minute. He's the chief public defender. You got arrested last night on charge of carrying a concealed weapon. Prosecutors filed a formal complaint by Chief Assistant Josh Robert. They allege that you did carry a pistol, concealed or otherwise, in your automobile, a Ford F-250 big truck. That's a felony. It's punishable by up to 5 years imprisonment and a $2,500 fine. You and another gentleman were at the parking lot of the Hidden Marsh Sanctuary last night at about 3:30 in the morning, which is a weird place to be at that time. The police encountered when they recovered a pistol from your vehicle. So this is a felony, and I need to get the case on track, but I also need to set your bond. So I'm going to show you plead not guilty. I'm going to set a pre-exam conference for June 10th at 8:30. Yes, and a preliminary examination if needed for June 17th at 1. Now, as far as I could tell, I didn't see that you had any criminal history. Are you on probation, parole, or bond anywhere?
No, I am not. No,
Have you been convicted of anything else?
No, sir. No, I have not.
Do you have a valid driver's license?
Permit?
Do you have a valid driver's license?
I have a permit. And there was a person in the vehicle who had a valid driver's license.
Yeah, there was another adult in the car, so I guess. All right. Are you employed?
Yes, sir.
Where's that?
I work at Walmart Auto Care Center.
You work at Walmart, did you say?
Yeah, in the Auto Care Center.
Okay. How long you been there?
I've been there since the beginning of this year because I was working at a factory.
All right. You live on Broadway Street?
Yes, sir.
Who do you live with?
My mom.
What's her name?
Her name's Teresa.
All right. So are you missing work right now?
No, but I will be if I'm still here Friday.
All Do you take any medication?
Yes, I'm supposed to. I've been trying to get into CMH, but they've been denying me. And I was subscribed to medications at one point when I was a kid, yes.
But not taking them. All right, well, I really want to ask some questions like what were you guys doing there at 3:30 in the morning, but I'm not allowed to ask stuff like that at this kind of a hearing. I also want to know what you're doing with a loaded gun in your car, but the way I see this, you got no criminal history. There's no indication that any drugs or alcohol were involved. They didn't show that you've been drinking. The park closes at dusk.
Yeah, I did not know until the police officer notified me. We weren't allowed to be there until then.
Well, that isn't a place to go walking in the dark. But you live locally with your mother. You got no criminal record whatsoever. There was no assault or threatening behavior. You were essentially cooperative with the police. You were driving within your license restrictions and you're employed. So that lends me to think that a PR bond would be appropriate. If I understand it, this gun was registered, but you don't have a CCW permit. I'm going to set a PR bond at $2,500. There are certain conditions of that bond. No drugs and no alcohol. Curfew of what time do you get out of work?
I get out of work at around 8 to 9 o'clock, depending on how busy we are, but usually it's 8.
I'm going to do 11 p.m. curfew. Nothing good happens at 3:30 in the morning to 5 a.m. No weapons. Must not possess any firearms or dangerous weapons or reside where they are present. You don't have a CCW permit, so I don't have you relinquish it, but they have your gun. No assaultive or threatening behavior. Now, you can't use drugs or alcohol while you're on this bond, but I'd like you to try to make appointment with CMH. Yes, sir?
So I will notify you that with marijuana being legal, when I was at my house a long time ago, it would still be in, it would still be in my system. So how would that work? Because I know
All right,
last at least.
don't worry about it. Marijuana is legal for 26-year-olds to use, but while you're on this bond, you can't use it anymore.
Oh, okay.
So,
I was just wondering.
no, you're allowed to smoke it if you're an adult or use it in other circumstances. I think there's more to the picture here. I think there's some mental health issues here that I'd like to know more about. We're going to get an attorney and explore some of that. I'd like you to try to make an appointment with CMH. But we'll explore that as we go further with this. Now, let me repeat, this is a felony. It's punishable by up to 5 years in prison and a fine of up to $2,500. You don't want to go over to prison for 5 years, and it's not very likely that you will. But we have this phenomenon where we have young men carrying loaded firearms around in their trucks. Makes me uncomfortable. Within the last 6 weeks, we've had 4 cases where they took the guns out and played Grand Theft Auto, blamming away at each other. So we got people shooting at each other. In fact, shooting. A couple people are actually shot. So we'll see. So I'm going to get you a lawyer. No drugs, no alcohol, no firearms. You have a curfew. You're going to be in by 11 o'clock at night. And I'd like you to make an appointment with community mental health. Anyway, we will address this further on June 10th. Now, you got a couple things going for you. You got a place to live. You're with your mother. You work very close where you live, and you got a job. You got no criminal history. So don't do any more dumb stuff before we sort this out.
Could get a hold of them.
All right. So, yeah, back in the old days, we used to remember other people's phone number. I can barely remember my own phone number. But they're all on your cell phone. I don't see any reason why they need to seize your cell phone.
Well, I tried to call them and it didn't go through because I called one of my sisters earlier before I got to talk with you to notify them I was here. And they did not answer because in fact it was had to be paid for and there was no payment on the phone call.
Hopefully they'll
available.
give you your phone back and you can call somebody to come pick you up. Anyway, your next visit here is June 10th at 8:30. We're gonna give you paperwork with your lawyer's name and number on it. I want you to call your lawyer and discuss this with them prior to your next court date. And I want you to see if you can actually get an appointment with CMH. And you can tell them the judge told you to go check in with them. All right, Mr. Wire, do you have
I
any
have
questions?
Yes, I have one last question. Since you said I have to be in at 11 a.m., is it available
11
that I also?
p.m.
Oh, yeah,
11 at
yeah,
night.
my bad. Sorry, 11 p.m. Yeah. Would it be possible, because I have two sisters that also live in Three Rivers that I stay with sometimes? Would it be possible if I'm allowed to stay with them too? I do know Sergeant Starks does
Yeah.
know both of them. So if need be,
Yeah,
I
you
can.
can, as long as you show up for court and you get your mail at that address, yeah, you can stay with your sisters. Now, it doesn't mean you got to stay in the house. You can be outside.
Well, I know, I just know that you're notifying me that I have to by 11 p.m. be at a property that is safe for me.
Yes.
Which is picked up my house, or that's why I was asking if like my grandma.
Or your sister's house or a friend's house. I just don't want you out and about late at night.
All right, okay, yeah, that's all I was wondering is about that, because I've never had
All
to
right,
do this.
hopefully you'll get out. I'm gonna give the paperwork to the clerk. She'll process it and you can get out before 5 o'clock. All right, good
okay.
luck.
Thank you so much, sir. You have a wonderful day.
Yeah, I think there's more to that story, Mr. Stickley. We'll get him a lawyer and figure out what's going on here.
Sounds good.
All right, I'll see you tomorrow. Thank you.
Yep. Bye.
All right, that completes our day.
Strike the motion for default.
Okay. Ms. Tideman, I assume no objection.
No objection.
Okay, we'll go ahead and strike number 4. Thank you both. Let's take number 5, Annette Jackson and Ms. Quinata. I have Ms. Radecki there. I believe I saw Ms. Quinata log on. Are you with us?
Yes.
Okay. So I was just handed, while I was on my 1 o'clock docket, Ms. Quinata's, it says affidavit concerning court proceedings. And then I also got a declaration of Annette Jackson. Have the parties exchanged this information with each other, or am I the only one who has seen it?
So, I have received Ms. Kanata's declaration. The filing today, I attempted to send to Ms. Kanata on the email that I previously served her on, but it appears to be deactivated or no longer in service. I got a message that it bounced back. So I have unsuccessfully sent that to her, but in essence, it's just the mortgage statement that Ms. Jackson got from Freedom Mortgage stating that the balance was not paid off, in fact.
Okay.
I have that declaration and my new, if I can just give her my new email address, Microsoft had messed up my account, so they're all combined. So I'm not receiving any emails at all. But I have another email, tanya.quinata@yahoo.
And I'm not sure if you, the court would like to, call this in a little bit. I can email that to her right now. It's a pretty brief document, just so she has the opportunity to.
Let's do that. So I'm going to recall this case. I'll have Ms. Radecki email that document to you because it does have a mortgage statement with a current date. Looks like it claims to be from May 19, 2025, which would purport to show that it is not paid off. And that really is, as you know from our prior hearing, I'm not going to relitigate today my decision on the writ of ejectment. What I'm here to decide today only is the amount of bond, if any, that Ms. Jackson would need to post. And as you will recall, in order for me to make that decision, I wanted to know if Ms. Quinata had paid significant sums of money towards that home, in which case I would be more likely to set a bond than if not. So that's what we're going to decide today, Ms. Quinata. I know some of your filings reference some other issues, but solely in front of me today is what have you paid towards the house?
99A, which I have communication with Freedom Mortgage. And so I have that email, but I wasn't able to submit it because I just got it back. And they said that they wouldn't be able to send me a receipt of received until around the 6th of June.
Okay. What I'm going to have you do is check your email. Ms.
Okay.
is going to send you the statement from Ms. Jackson that includes the mortgage statement. And then I will recall this case and we'll make a decision, okay?
Okay, and so I do have communication with them. I didn't submit it because I just received it because my email was messed up. So how do I go about like showing that we have communication about the payment?
What payment?
To Freedom Mortgage.
Why don't you forward it to Ms. Radecki?
Okay,
Okay.
I can do that.
All right.
Thank you, Your Honor.
Okay. Well, I don't know out of my remaining three, which will be shorter or longer than others. So maybe I'll just go in order now. Number 1-19-2-007-6608, Ogden v. Lapierre. And I believe I have Ms. Casimir and Ms. Long. Make sure I didn't typo. There we go.
Got it. Thank you.
All right. Thank you both.
All right, thank you, Your Honor.
And then before we go to the summary judgment, let me just see if Ms. Radecki and Ms. Quinata are available yet for your matter.
I'm ready, Your Honor.
Okay. Ms. Quinata, are you available for this case? Are you ready?
I believe so.
You believe so? Okay. I'm going to go ahead and handle this. So you've had a chance to review Ms. Jackson's declaration.
I have.
Okay. So I guess Ms. Radecki, I'll have you go first regarding any non-request for bond based on the facts that I asked for some more information on, and then I'll go to Ms. Quinata.
Okay. So, Your Honor, we are requesting no bond in conjunction with the writ for ejectment for the preliminary injunction. Reason being, Ms. Quinata last week indicated to the court that she paid off the balance of the mortgage in excess of $400,000. She indicated that she did this action sometime in the end of April 2025. My client, Annette Jackson, who's the owner of the property located at 124 Truth Street, she contacted Freedom Mortgage, who is the lender for the home, after the court hearing, and got a current balance as of May 19th, 2025. We have included that in her declaration, and she represents that that is an accurate depiction of the mortgage statement. The only change is that the loan number has been redacted, but otherwise it is a true copy of what Freedom Mortgage has given her. It indicates that there is an active balance of over $400,000 still. And this is information given straight from the lender, which obviously starkly contrasts what Ms. Quinata is telling the court last week and this week. So we would just request that the court take that into consideration, the fact that she has not paid off any balance. There's no proof to that. And in fact, the proof is to the contrary, the fact that there's still the full outstanding balance. There's a current amount due of $27,872.61. So we would just request that the court take that into consideration and not issue a bond for this matter, given that information.
Ms. Quinata, what would you like the court to know?
Well, just like Ms. Radetti said, the account number has changed. And the reason being the account number has changed is because it's mine now. I paid that off. It wasn't my fault that they lost the 1099-A to give me a receipt. So that's kind of what had happened. I had mailed it in, I mailed everything in together. They lost the 1099. After court that day, I called them and I asked them, they said they lost that portion of it, so they can't give me a receipt until they receive it. So I sent it to them. But if you notice, like, just like she said, they changed the account number because it's no longer under Miss Jackson. It's under my name.
So the difficulty I have is under for the statement with the date of May 19th, and it says payment due June 1, 2025. It still has Ellie Easer and Annette Jackson on the mortgage statement, not you.
They probably do owe something, but I'm on a completely different account. And I don't think I should be held liable because they had misplaced it. They can't even give me a receipt for the payment because they misplaced that one form. So I did file with the IRS, the 1099-A. And if you want to, I mean, I don't know how that works. I've never did it before, but I can actually probably go online and print out the IRS form that they received it. So I'm not exactly sure where you want to go with this, but it's my son and myself. And I did everything that I was supposed to do. I went to the auditor's office. I asked them exactly what I was supposed to do. I brought them in everything. They're the ones that handed me the quit deed claim and had me fill out all the forms correctly. And that's according to Cowlitz County rules. Is like whatever the auditor says is what they say. So I did exactly what they said. The house is now under my name also. And so I don't know, I'm not quite understanding why there's gonna be a bond and all of this other stuff. I believe that this is a completely different matter. I think that it has nothing to do with the bond. The bond is actually supposed to be, hang on, I'm trying to go back within memory, but a bond is actually supposed to not transfer the house. A bond is supposed to be to secure the house or yeah. Let me pull it up real quick. I'm sorry. Sorry about that. But the bond is actually supposed to be. You pull this up here. It doesn't. It's supposed to just a bond's not supposed to substitute for rightful financial stakes, but it already establishes it. So I get that, but I've also put a lot of money in the house. I had to fix the furnace. There was a lot of stuff that was the I had to fix the walls, the doors, the doorknobs. I've had to change the locks. I mean, I do the maintenance on the house. I do all of the landscaping, and I do all of those things. And I've been there almost 3 years, and I'm with a minor child. So I'm not exactly sure how it is fair, more or less, to say that you're going to remove me and my son to put Miss Jackson in there when there hasn't even been anything prior to no notice except for an ejection. Oh, okay. Whoa, what's going on here? Because my belief was I just filed everything with Freedom Mortgage and the IRS. Okay, then that was it because it comes out of my trust. Cool. I never had to worry about that before because I paid off my cars like that, and that's just how it works. So I was super confused when they said they lost that form. So I don't think I should be held responsible or liable and be removed from my home because Freedom Mortgage has lost their part, their portion of the 1099.
Ms. Radecki, anything further?
Just a few things, Your Honor. I mean, ultimately, the facts are pretty clear. We have Ms. Kanata and also let me correct myself from earlier. I said that the payment was made in April. I was mistaken. That's the date that the deed was filed. That Elazar Jackson, my client's ex-husband, conveyed the property to Ms. Kanata, even though he clearly did not have legal title to the property. So we have that. We also have Ms. Kanata stating that she was a tenant again, and I know we're not relitigating. This is just solely related to the bond, but just for the record, I want to clarify. She indicates that she was a tenant, and then also simultaneously indicates that she's paid off over $400,000, but miraculously, there's no proof of this anywhere. And in fact, like I said, my client contacted Freedom Mortgage directly as she is a party to the loan currently. There's been no modification or change of the loan number. The loan number has merely just been redacted by myself to submit to the court. And so we have no proof that she's made any sort of payment whatsoever. She has words, and she has a 1099-A. She sent the email that she sent me it appeared to be an email draft. There was no email address. And ultimately we have no proof that she's made any type of monetary payment whatsoever, and the proof states otherwise.
Can you forward me what she sent to you?
Yes.
And like I had said earlier, my email account with Outlook is really messed up. And so I am having to scroll up. And that was actually a scanned email that I printed out from the printer. So it's not even, that's all I have right now. But if you call Freedom Mortgage, the reason why there's two different account numbers is because one belongs to Miss Jackson and the other account number belongs to me. And so either way, there's no receipt. Is the government not a valid person to file a receipt with? I filed that with the IRS. So you're saying that my receipt with the 1099-A is false.
The 1099 I reviewed was handwritten. It was not prepared professionally by an organization.
It doesn't have to be. I actually have a trust that I go through all the time.
It goes to the credibility of what I'm reviewing in light of my concerns I already have about what has been told to different agencies as you applied for ownership of a home, that the court had already issued an order on giving ownership and possession to Ms. Jackson. That's the point I'm making today. So I'm going to take a look at this email that you sent to Ms. Radecki.
And you don't apologize for nothing. What email should I send this to?
Send it to my last name, KARMYJ at cowlitswa.gov, I think. Yeah. Okay.
Okay. Okay, I just sent the email and I CC'd Miss Kanata in it as well.
All right, give me just a minute to get that in our email system. There we go. Okay. Resubmission, 1099 Dear Freedom Mortgage. Per my conversation, I understand that you need me to resubmit a 1099-A. Please find the duplicate copy attached for your records. Should there be anything more? This just looks like a screenshot.
That's what I said. All of my emails are stuck in Outlook, so I don't have anything, any communication logs or anything. I've been trying to communicate with Microsoft and Intel, and I have a whole bunch of logs that say basically I'm not able to get into my email, and so it's like kind of my answers. It's like I know it sounds like when it rains it pours, but it really did.
So here's my ruling. I'm gonna sign the order on preliminary injunction per my prior ruling last week. I don't find that there's any basis based on credible evidence that a preliminary injunction is not appropriate. I have concerns about the things that are being told to the court by Ms. Quinata, but I assume she has paid some amounts of money towards the home over the period of time she's been in it. So I am going to require a minimum bond of $5,000. That'll be the value of the bond. Pretty standard minimum amount that we would require. Again, I don't, if I had credible evidence that she had paid off a $400,000 mortgage, I would be requesting a much higher bond. I don't see that. What I have in front of me very specifically is a note as of May 19th, 2025, that over $400,000 is still due and owing on this home. So that is my finding. I have signed that order, and I think that concludes that case. Is there anything else the parties need from me today?
Yeah, I just feel like the bond shouldn't take, because I am co-owner. And so, and it doesn't matter how you feel or anything like that, or anybody else feels. I filed it exactly the way Cowlitz County wanted me to file it. I don't know what's going on. I do know a little bit, but I don't try not to get into Elazar and Annette Jackson's information or their dispute. I'm not part of that case. And so I believe that it should not be a substitute for rightful financial stakes. I feel like this is an abuse of discretion, that you're not allowing me to at least print out the IRS form that says that it's filed with them. I understand you gave me a week. I did not know that they had lost that or portion of and it's my fault. I didn't verify. Okay, I get that.
I'm basing my decision on the preliminary injunction and the bond amount based on the credible evidence in front of me currently. The case for the underlying possession of the property remains. So this is a preliminary injunction. You are certainly free to do two things. One, you have review rights of my decision today. You certainly can file for that. You have appeal rights, and you certainly have a right to prove your case when this specific action goes to finality. So I'm going to go ahead and conclude the hearing today, but you have several avenues you can pursue when and if you have additional information for the court. Okay, I'm going to go ahead and conclude this matter. Thank you both.
Your Honor.
And then that will take us back to the Anderson, Napier, Folger, etc. matter. Let me just get back into that case. Thank you, folks, for your patience. All right.
Thank you, Your Honor.
Okay. Well, I don't know out of my remaining three which will be shorter or longer than others. So maybe I'll just go in order now. number 1-19-2-00-76608, Ogden v. Lapierre, and I believe I have Ms. Casimir and Ms. Long.
Good afternoon, Your Honor.
Good afternoon. Okay, let me just get into your digital file, and I do see for now, if I'm not mistaken, that there is a trial set to start next week, depending on whether this gets resolved by summary judgment. Is that correct?
Yes, except
Okay.
for Tuesday, to start on Tuesday.
Okay. Okay, so Ms. Casimir, I'll have you go ahead.
And in the interest of keeping this brief, has Your Honor had the chance to read all the filings, including our reply?
I did, and that does include all the declarations that were filed in support of the motion for summary judgment, the response, and the reply.
Okay, so I'll keep it brief. This is an action for adverse possession. The plaintiffs have made a claim for adverse possession of a portion of property that abuts a creek, which separates their property from the defendant's property. Essentially, plaintiffs have owned their property since 1974, and the defendants purchased their property in 2018. We provided the trail of title. Our period of adverse possession is 1984 to 1994. During that time, the owners of defendant's property were and I don't know how to say this, the Seduths and Jesse and Penelope Newberg. Plaintiffs filed their complaint alleging adverse possession and practical location of boundary. The plaintiffs provided their own declarations indicating their use of the property, that they've stored things. Their children provided declarations that they built a tree house, they played along the creek, that their parents maintain the creek. They have a pet graveyard in the adverse possession area. All of these uses are open, they're notorious, they're obvious, and the declarations are clear that these uses continued throughout the statutory period. Further, the creek serves as a well-defined boundary physically designated on the ground, and it was mutually recognized and acquiesced to by the plaintiffs and the defendant's predecessors for the 10-year period from 1984 to 1994. The defendant's response focuses essentially on exclusivity. The plaintiff's declarations indicated that any entrance onto the disputed area by defendant's predecessors was permissive, or simply a neighborly accommodation. To overcome that on summary judgment, the defendants would need to provide specific facts or specific information to create an issue of material fact. The issue of material fact there would be whether that use was permissive or not. The declarations of, and we discussed this in our reply, of, I apologize, I don't remember their names. The declarations of Mr. Newberg and Mr. Campbell simply indicate that they entered on the property, that they weed whacked and helped their dad with certain things on the property. They don't indicate that this use was not permissive. They don't indicate that their father owned the property. They don't indicate that they didn't have permission. To overcome it, we would need a showing from them that this use was not permissive, but plaintiffs have indicated it was permissive. So we don't believe that they've provided any information that overcomes or creates an issue of material fact as to the exclusive use of the plaintiffs, because all they've indicated is that they entered on the property, and plaintiffs have indicated that if they did, it was permissive and it was a neighborly accommodation. Further, Robert Newberg's declaration, he purchased the defendant's property in 1998. It's outside of our statutory period. He indicates he asserted his ownership in that time period, but that plaintiff did not comply with that. That's irrelevant to this. It's outside our statutory period. The plaintiffs are not required to hold the adverse possession area adversely up until the time that they bring their claim. They simply have to meet their 10-year period, and they can bring their claim at any time after that. which is what happened here. So we'd ask that anything outside of the 10-year period not be considered. It's not relevant. Plaintiffs met their burden upon the 10th year of their adverse possession. As far as the latches or estoppel arguments, adverse possession case law is very well established. Plaintiffs can meet the elements of adverse possession. They can divest that title as an owner would who had received title by deed. They can deed the property to someone else without quieting title. Original title passes to them on their 10th year. They're not required to hold it adversely continuously up until the time they bring an action. So the plaintiffs met their adverse possession claim in 1994, and they stopped holding the area adversely because they owned the area at that time. And any entrance by the defendants or their predecessors was permissive. And so we believe that the plaintiffs have met their burden. And I'll leave it at that unless Your Honor has questions.
Okay, thank you. Ms. Long, go ahead.
Thank you, Your Honor. If I were going to make arguments today, they would literally just be repeating what my clients provided to the court in terms of an objection to this case. The only thing I can add is that if it just seems like the law, the law of adverse possession is essentially designed to it's a tool that the court can use to realign property interests where it's clear that one party has essentially acquiesced and given over their property rights to somebody else. In a case like this, where one party waits 25 plus years to bring a claim for adverse possession, and the people that could respond to that are deceased, and there's a lot of intervening activity between the parties that seems to underlie or undermine the plaintiff's claim for adverse possession, it seems like that can't be a scenario where an adverse possession claim can succeed. So my clients are asking that this case proceed to trial next week.
Ms. Kassemeyer, any rebuttal?
Adverse possession case law does provide that original title passes on the 10th year. At that point, the prior title holders can adversely possess the property back. That would require an additional 10 years. And that can continue. And Nickel v. Southview specifically states that that an owner that acquires by adverse possession cannot be divested of title short by what would be required for someone who acquired by deed. The length of time here is, I think, contemplated by adverse possession law that's well established in Washington.
And so I did review this and the declarations and the briefing of parties and looked up some of the cases cited by the parties. And this to me, well, first of all, I don't think this is appropriate for summary judgment. And the reasoning is that this is going to come down to credibility of the witnesses who give testimony. And that really needs to be decided by a trier of fact. I mean, I can't say as a matter of law that adverse possession has occurred for that period, because what I have in front of me, and this is going to be the same evidence I assume a bench or jury will hear, is he said, she said. And that, so when faced with that evidence, especially when we're asking a trier of fact to look back 30 years, people's ability to remember or recall or recollect all go to their credibility. And that's not something I can judge on a summary judgment standard. So I am going to deny the motion for summary judgment. I do find that there are disputed issues of material fact regarding the elements for adverse possession for the period in question back in the 90s. And I'm going to go ahead and have you all be ready for trial next week.
Your Honor.
I'm not sure if I have a specific order. If not, I guess, Ms. Long, do you want to prepare an order, or I can do a bench order and with the specific findings that I think there are issues of material fact, especially as it relates to a trier of fact needing to determine credibility of witnesses.
I can draft that. I'm literally gonna just write in it what you just said about issues of fact, especially regarding assessing credibility of witnesses. I'll list the documents that the court reviewed in making this decision and circulate it.
Great. That would be very helpful. I appreciate that. Okay, anything you want me to address for your trial next week? Is there anything you all need? I think you already had your readiness.
I don't think so.
I don't think so.
Okay, all right, thank you both. Now, let me check in if Ms. Radecki and Ms. Juanada are ready yet on their matter.
I am not.
Not yet. Okay, I'll call one more case and then come back to you all. Okay. All right, so I have number 22220089708 that joins with number 3. I know that we're talking about attorney fees. Let me check in if Ms. Radecki and Ms. Juanada are ready yet on their matter.
I am not.
Not yet. Okay, I'll call one more case and then come back to you all. Okay. All right, so I have number 22220089708 that joins with number 3. I know that we're talking about attorney fees and I believe summary judgment as well. Let me turn it over to the parties.
I don't know which one Your Honor would like to address first.
I don't think the fee argument's going to be that long. Since you've already heard it 2 times before, if you wanted to take that first, I suspect the summary judgment would go a little bit longer.
Let's go ahead and deal with attorney fees then.
Mr. Wise?
Yes, Your Honor. At your request, I submitted an amended affidavit of fees following last week's hearing. In the amended affidavit, it largely mirrors my previous, I should say, declaration. But I did make some changes to the spreadsheet on fees and only included my time for actually working on and arguing the motion for dismissal of Hazel Fall. So the attorney fees from my firm that I included in the spreadsheet and then the affidavit total, pardon me, I'm trying to find that here. Got a lot of open windows.
I have 2,464 in paragraph 9, and then I have Beresford Booth 2,281.50.
Yes, that's correct. So I don't have anything to add other than what's within my amended declaration there.
I appreciate that. Mr. Nelson, your position on the amended attorney fee request.
Well, Your Honor, I think that goes into my initial opposition to attorney fees. And the first issue, Your Honor, is whether there's any basis for the award. You denied fees under the adverse possession statute, which is 728.083. You've indicated that my client's position was not frivolous, so there's no fees under 44.185. And there has to be either a statute or a contract or some, I guess, equitable basis for fees to be entered. So then we're left with, well, is there an equitable basis for fees to be entered? And you've indicated that Ms. Falls should have dismissed her claim once she sold her property. And I brought to the court's attention that I attempted to get a dismissal of her claim starting in January of 2025, but Mr. Wise insisted that my client pay $50,000 for that dismissal. There's no reason to think that he would not continue to demand attorney fees if I offered to dismiss after the property was sold. And so there really was no place for my client to go in order to dismiss this case. And if you look at the equities, as a result of Ms. Fall's opposition, the fees initially were requested were $50,000, and then they were around $6,500, and now today they're at $4,750. It seems the equities mitigate in favor of Ms. Fall in protecting her position. But if the court does find that fees are to be awarded, then I don't think they should begin prior to March of 2025 for Mr. Wise. We will accept that he incurred $2,222 in fees, even though some of those dealt with the attorney fee issue, not just the dismissal issue. We don't think any of the Beresford fees should be covered. First of all, they shouldn't start until March of 2025, and every entry after March of 25 indicates that it deals with fees. Fees were denied. The Beresford firm should not be rewarded with you awarding fees to them on an issue that never prevailed. So at most, Your Honor, the award should be $2,222.
Mr. Weiss, you want to be heard on those objections?
No, Your Honor, I understand where Mr. Nelson's coming from. My position would just simply be that the day the property sold was the day the case there should have been an order of dismissal entered with the court. That didn't happen, and so we had to file a motion for dismissal, and that resulted in time and wasted money, and so we're seeking compensation, or rather my clients are seeking compensation for that time and wasted money, both incurred by my firm and the Beresford firm.
Okay. So here's my ruling on the fees issue. And number one, I understand, Mr. Nelson, your request for some clarification on the basis for the fees. And so I'm going to clarify my ruling on this. So I did find that this was not a frivolous action when it was brought. However, there were no facts to support Ms. Fowle's claim at the point that she sold the home. I don't like to use the word frivolous. I think that might be a bit of an overstep. But what I do find is that at the time she sold her home and could no longer assert that claim, her claim was meritless. And so that is under the basis that I am moving forward with fees from the date the home was sold. I understand Mr. Nelson's argument that there was an attempt to dismiss, and I understand sometimes there are requests for fees and costs when those things happen. But I think certainly Ms. Fowle could have moved for this court to decide a contested motion to dismiss at that time. So I am going to award the fees as proposed by Mr. Weiss for his firm. I do agree, though, in looking at the Beresford booth, I am going to reduce the amount pretty significantly because it does look like a lot of that was strategizing with current counsel, Mr. Wise, on this exact issue. So what I'm going to do is there is I'm going to award the 2/26/2025 one that's $175.50 telephone conference for how to resolve claims in light of her sale of the property. I will approve the March 25, 2025 entry for $117 review motion to dismiss Fowle's claims and to award fees. I will approve the March 25th amount for $175.50 as it pertains to the motion for summary judgment regarding Fowle. And then it looks like the remaining charges relate to the fee petition. So it'll just be those 3 entries for Beresford booth that I'll be approving.
Your Honor, would you mind, I apologize to interrupt, would you mind restating those dates again?
Yes. So, 2/26/2025 in the amount of $175.50. 3/25/25 in the amount of $117. And then 3/25/25 in the amount of $175.50.
Thank you.
And I do believe, although it's not right in front of me, maybe I don't have a new order. I think I have the original.
Your Honor, there's a blank in the original order for the amount of the fees. I come up with 2,932. I don't know if Mr. Wise has checked that.
What was the number you came up with again, Mr. Nelson?
2,932.
Yeah, that's what I got.
I don't know, Mr. Webbs, if you still have access to your original order from May 19th. I have it. It has the proposed language and the court stamps on it. I'm wondering if you'd be able to make a couple changes and forward that to the court.
I'm sure I can.
And you can just take off the word proposed in the header and the footer.
Sure.
And email that to my legal assistant. I did want to make one other change. Number 4, I am going to exchange the word frivolous for meritless. Just to stay in line with my preference for how I rule on these things.
Understood.
And then if you want to break out the 2 different law firm payments, I'm fine with that. Or if you want to lump it all together, that's fine.
For my purposes on my end, I probably need to separate them.
Okay.
But yeah, I will amend it accordingly.
Okay. Anything else we need to do on the fee matter?
If Mr. Wise emails me the revised order, I can sign off on it.
Okay.
Your Honor, can I email that to you or your judicial assistant?
Yes. So once Mr. Nelson signs off on, once it has both your signatures, feel free to forward it to Kelly Holter. And I can put in the chat her email. Make sure I didn't typo. There we go.
Got it. Thank you.
All right. Thank you both.
All right. Thank you, Your Honor.
And then before we go to the summary judgment, let me just see if Ms. Radecki and Ms. Quinata are available yet for your matter.
I'm ready, Your Honor.
Okay. Ms. Quinata, are you available for this case? Are you ready?
Believe so.
You believe so? Okay. I'm going to go ahead and handle this. So you've had a chance to review Ms. Jack. Okay, I'm going to go ahead and conclude this matter. Thank you both.
Your Honor.
And then that will take us back to the Anderson, Napier, Folger, etc. matter. Let me just get back into that case. Thank you, folks, for your patience. Okay, I do know there was a motion to strike filed. Do we want to deal with that first before we jump into the merits, or the parties in agreement on that issue, or where are we at?
I'm happy to address it first. I doubt we're in agreement on it.
Yeah, we're not in agreement, and I think it is appropriate to address it first.
Okay, go ahead.
Thank you. So plaintiffs filed their motion, defendants filed their response, and in their response, they indicate that they don't oppose the main request of the motion. But they ask for an award of fees based on the frivolous statute. And to support that, and to support their response to the summary judgment motion, and their request for fees, and for taxes, they enter evidence of settlement negotiations. This is clearly a violation of ER 408. Evidence of settlement negotiations is not admissible to prove liability in an action. It's a long-standing rule, and the purpose is to promote negotiations and preserve judicial economy. The rule does provide exclusions when it's offered for another purpose. We provided a list of those exclusions. None of those apply here. Defendants don't oppose the motion. They ask for taxes, but they offer evidence of settlement negotiations saying, well, we tried to settle this and they didn't settle it, so they owe our fees for the last 2 years. And that's just clearly inappropriate and not allowed by the Washington court rules. It's common practice here. It's common practice in every court I've practiced in, that you cannot enter negotiations or evidence of settlement negotiations to prove liability for anything in an action. So we're asking that any reference to the settlement negotiations between the parties not be considered and be stricken.
Okay. Go ahead, Mr. Wise.
Yeah, Your Honor. Plaintiff's counsel is totally misconstruing ER 408. ER 408 says that offers of settlement can't be used to admit liability or can't be admissible later in front of a trier of fact to show liability. That's not what we're doing here. They can be used for other purposes. It clearly contemplates a situation where there's a liability dispute or maybe even a value dispute. This isn't really either of those. We're not disputing over value, and we're not even really disputing liability. In fact, what we admitted that this offer of settlement for was to show, hey, this is plowed ground. We've offered this very thing, and now 2 years later, you're seeking to get that from the court. So it is admissible if offered for another purpose, such as negating a contention of undue delay. And I'm reading that from ER 408. Negating a contention of undue delay. We're saying they unreasonably brought this. They have unduly delayed it. We certainly, the defendants, the Folger and Wolf defendants, have not delayed it. Not only that, they offered this very thing 2 years ago. I don't want to get into the merits of that right now, but it's clearly admissible for some other purpose besides proving liability or fault or the amount of damages. This isn't like an auto accident case where both parties said they blew a red light and you make an offer to settle, and then that's being admitted to show, hey, look, this shows they ran the red light. This is a real property dispute on adverse possession. Instead, what we're saying is we agreed 2 years ago that, yeah, you acquired title by adverse possession. So this is really concession insofar as it can be analogous to liability. This is a concession of liability that we are waiving, because that's the other thing. This can be waived by the party who offered it. I'm not trying to offer a statement or an offer of settlement made by plaintiffs against plaintiffs to show they did something. Instead, I'm saying, hey, my client, defendants, offered this thing. So even if this is perhaps inadmissible under certain circumstances to show liability or damages, I believe it's a waivable essentially communication, because it affects my clients. They wouldn't necessarily be able to offer it against me. But I think the opposite is not true.
Yeah. So what I'm going to do, I will allow it. Again, it's not being admitted to prove liability in any regards. It's being offered to, I guess, as part of an argument for fees and the merits of a case. So I'm going to go ahead and allow it. So let's move on to, so the summary judgment, as I understand it, is not opposed. What is opposed, though, is Well, let me ask first, is the request for the taxes opposed?
Well, that's their request. So
Right. So I'm asking.
Yes, it's opposed.
To oppose it.
Yeah.
Sorry, can you repeat that? I didn't quite.
Yes. Sorry, Your Honor. Yes, we do oppose it.
Okay, okay. And obviously I know that you are objecting to the fee request. So Ms. Kazmaier, go ahead first and then I'll hear from Mr. Wise.
So I'll start with the taxes. RCW 7.28083 states that a party who prevails in an adverse possession may be required to reimburse such holder for part or all of any taxes levied on the real property, which are proven by competent evidence to have been paid by the holder or purchaser. The only evidence that they provided is their own statement saying, I paid these taxes, and some arbitrary calculations. I don't know where these numbers came from. I don't have a square footage from a surveyor. I don't have anything showing here's the exact square footage of the area. And we don't have anything from the county tax assessor showing what taxes were paid, what portion of the property the taxes were paid on. There's no documentary evidence to support these claims that they've paid taxes for this exact amount, which is the amount of the adverse possession area. They have calculations in there. I don't know where they got those numbers from. I don't think the court can say they know where they got those numbers from. They're just numbers they put in their motion and said, here's our calculation. I don't think that's competent evidence to prove that they've paid these taxes they're asking the court to award. They just simply haven't met the showing that's required. They haven't provided the support. There's no competent evidence, and I think their request for payment of taxes should be denied. The burden's on them per the statute to provide competent evidence. The burden's not on the prevailing party to show that they don't have to pay. If the request for taxes is made, they have to make a showing by competent evidence, and they failed to do so here. As for their fee request, they've again asked the ward to award fees based on the frivolous statute. Again, the frivolous statute requires that the entire action be determined to be frivolous. The court has already found claims in this action not to be frivolous, and so the court should deny this. The action is not frivolous, so so fees cannot be awarded based on this. The specific statute actually provides that the court can order frivolous fees and require the non-prevailing party to pay the prevailing party. In this action, they're not opposing plaintiff's motion, so plaintiff is the prevailing party, and if anything, plaintiff could request fees based on the statute as the prevailing party, but the statute doesn't contemplate defendants asking for fees when they are not the prevailing party in the motion. Their argument actually supports a claim for plaintiff are asking for fees based on this statute, but plaintiffs are not because the action is not frivolous. The entire action has to be found to be frivolous. Plaintiffs are asking for an award of their fees based on the adverse possession statute, which states that the prevailing party in an action asserting title to real property is entitled to reasonable attorney fees. So we're asking that the court deny their claim for damage or for taxes and for fees based on the frivolous statute.
Okay. Mr. Weiss, let me ask you this, and it might be in there. I know this case has been going on for quite some time. So at the point that maybe you and your client, I mean, the settlement discussions are one thing, but at the point that maybe you and your client agreed that you weren't opposing the adverse possession claim by the Andersons, was an amended answer filed taking that defense off the table?
Not to my knowledge, Your Honor. I'll say I was not representing Fulcher and Wolf back then. I've been representing them for approximately a year now.
Okay.
So this was an offer made by co-counsel at Beresford Booth.
Okay. So, I mean, I think, and I don't want to prolong something that doesn't need to be prolonged. I don't see any basis to award attorney fees where the argument is they didn't accept our settlement offer, but the case was in litigation for numerous parties and issues, and the defendant didn't amend their answer. So, I mean, really the plaintiffs could only move forward. If there had been some sort of amended answer that specifically admitted that the Andersons had obtained it by adverse possession and the Andersons still pushed forward, I guess that's a totally different story, but I don't think that's where we're at. So I don't see any basis for attorney fees. I don't think it's frivolous to continue a case where defense hasn't submitted an amended answer, taking the issue off the table. But I'm happy to hear if you want to talk me out of that perspective, but I'm more concerned or more focused on your request for taxes and what the basis is for that. So I'll turn it over to you now.
Sure. I'm going to address this briefly, just in reverse order. Ms. Casemeyer represented all 4 plaintiff property owners at one point in time here. And so 3 of those plaintiff property owners, Smith Cotts, Napier, and Fall, all had adverse possession claims over an easement area. They wanted to resolve them all at once. Anderson's adverse possession claim did not involve the easement area, therefore it was meritorious. And that was acknowledged 2 years ago. And so it was possible, even offered, to settle out the meritorious Anderson claim that didn't involve an easement area while continuing to litigate the Smith Cotts, Fall, and Napier claims, all of which have been dismissed now based on being non-meritorious. So my point is that that was a possible solution then, and so that it doesn't make sense to have continued the other cases only to have them fall flat while not resolving the Anderson cases. Frankly, I think it was a misuse of legal services there, because that one could have been resolved, but it wasn't. And so it's the totality of these that went through. And I said this more than a month ago, Your Honor, when I spoke, but if the plaintiffs are getting picked off one by one, who's left last is the Anderson plaintiffs. They did have a valid claim that we conceded, but they're continuing to litigate it. It isn't reasonable. I'm gonna move on with that.
Okay.
In terms of the taxes in this adverse possession claim, it's ironic that the plaintiff would argue that we're not providing a legal basis for the taxation, that we, the party who is being essentially divested of the real property, are asked to survey and legally describe and ascertain the exact square footage of this property when the plaintiffs haven't done so. Now, at this point, really, in the summary judgment motion, all the defendants are really agreeing to, and all the plaintiffs have really articulated, is that there is some space between the survey boundary line and a fence that exists that should be adversely possessed. The Andersons have not had that area surveyed and the reasonable square footage ascertained. So even though Your Honor is presumably going to grant our summary judgment motion today, because we haven't contested it, we still don't have a legal description of that area, which is in fact necessary to record a transfer of title for that area, or a boundary line adjustment. It's necessary to have a legal description with the square footage, the measurements, all that stuff. And that onus is not on the defendants to do that stuff, because the plaintiff is the one moving for summary judgment motion. Now, if the plaintiff had done their job and had it surveyed, had a legal description, had the square footage calculated of that area, I could take that document and I could say, okay, Commissioner, here is the square footage and here's the taxes. So that's why I say it's ironic that plaintiff's counsel is saying, well, gee, defense hasn't calculated this stuff. That onus is not on us. We're not the ones seeking adverse possession. I'm the one defending against it, and we're conceding that there is an area it's not legally described, whose square footage is not precisely ascertained, that exists there, but we don't know what it is. Now, are my mathematics that I did, I'm not an accountant, I'm not a surveyor, but are my mathematics somewhat crude and rough based on the information we have? Yes, 100%. But it's the best we got. I believe it's appropriate that the Anderson plaintiff should have this property surveyed, legally described, and the square footage ascertained, and then perhaps we could revisit this issue if plaintiff's objection is to my imprecise math. So that's my position on it. But I think that once we do that, it's appropriate to award back taxes for 3 years. Now, this isn't a big sum of money at the end of the day. In fact, when I was doing my crude math, I was a little bit dismayed at how little money it is. I frankly probably more in attorney's fees than calculating what the back taxes are based on a square footage number. But again, I believe that burden falls on the plaintiff or the party seeking to adversely possess the land, so we can figure taxes later.
Did your clients pay the taxes?
I can only say I believe so. I didn't get that from my clients in a declaration, but frankly, they're on this call. The window that's Lexi is Ms. Wolf. But yeah, I believe my clients have lawfully paid their taxes. And I assume, and I'll admit this is assumption, but I assume like most people who are property owners, they pay a mortgage and then the property taxes are built into the mortgage each year with the bank financing it. At least that's how mine are. And I assume that's how my clients are as well.
Okay. Ms. Kassemeyer.
Thank you, Your Honor. Just briefly, if you look at RCW 7.28083, it specifically states that a party who prevails against the holder of record title at the time an action asserting title to real property by adverse possession was filed may be required to reimburse such holder for taxes which are proven by competent evidence to have been paid by such holder or purchaser. That puts the burden specifically on the person saying, I paid these taxes, to prove that they paid those taxes. We have nothing before the court today that proves that they paid those taxes, except the brief that says they paid taxes on this portion of property that's calculated without any support for what those calculations are. And in fact, the plaintiffs did survey the property, which survey was provided in discovery to the defendants 3 years ago. They could have reached out to the surveyor. They could have done a survey themselves. It's common practice here that in an adverse possession action, a survey isn't even completed or portions aren't completed until after trial to avoid incurring costs, and the court will quiet title to a specific area to be more accurately described upon completion of a survey. It's very common, but a survey was done, and the defendants could have said, here's the portion of property, here's proof that they've been paying their taxes for the last 3 years. We have none of that. There's nothing before the court that shows competent evidence that these taxes were paid by them. And the burden is on the defendants. It's on the person asking for those taxes to be reimbursed to show that they have paid those taxes.
So here's what I'm going to do. Number one, I'm obviously, because it's undisputed, granting the motion for summary judgment as to Anderson's. I will allow the prevailing party, the Andersons, to file a fee affidavit request per the statute, again, as the prevailing party. I'm not going to set an amount for that. We can do that on docket after fee affidavits and any briefing and objections are filed. The counterclaims against the Andersons are dismissed. The defendant's request for attorney fees is denied. What I'm going to do with the taxes, I do think that upon a showing of payment of taxes, that is something that the defendants could raise. But I am going to deny without prejudice today the request for taxes I will allow the parties to re-raise it if they choose to do so. Again, I do believe, and I am finding that the statute contemplates that I would need credible evidence from the defendants that they paid the taxes. The other option in that statute is that I require payment of delinquent taxes to the county. So, you know, one of those things is true, and I just don't know which one it is. So sitting here today, I don't think I have enough information to require payment of the taxes. But obviously, that claim can be re-raised by defendants with more information. Anything else? I think that covers everything that was raised by the parties today. Anything else we need to do?
Just to clarify, is Your Honor granting fees in an amount to be determined later, or would you like me to file a motion arguing?
No, I am granting fees as the prevailing party. And then I think the language you included, which I'll keep in the proposed order, is in an amount to be determined upon presentation of fee affidavit.
So I'll file a fee affidavit and note that up.
So Your Honor, just be clear, you're granting those in favor of the Andersons?
Yes, as the prevailing party on adverse possession.
Okay. Are you putting a time limit on that based upon the offer to settle it in May? Or is this something for a future motion?
Yeah, so I would say that when Ms. Casimir submits her fee affidavit, you will respond and tell me what you object to based on those discussions, and we will have that discussion on the record.
Understood.
Okay. Okay, I will fill out this order with just on Exhibit A some additional documents that I relied upon in making the decision, my decision on the taxes, and then I assume I'll see the parties back at some point and we can talk about that fee issue.
Great, thank you, Your Honor.
Okay, thank you all. Okay, anything else we need to do on docket? Okay,
Every day in the USA, people find themselves in court.
Court is on the record in City of Conneaut versus Todd Estes II, case number 25 CRB 131. In this case, Mr. Estes pled not guilty to one count of domestic violence, a first-degree misdemeanor, on May 12, 2025. We conducted a first pretrial conference on May 21st, and today we're scheduled for a second pretrial conference in that case. More immediate is the court is also taking up State of Ohio versus Todd Estes II, case numbers 25 CRA 148 and 25 CRB 149. In these cases, Mr. Estes pled not guilty to one count of burglary, a second-degree felony in the CRA case, and one count of domestic violence, a fourth-degree misdemeanor in the CRB case. These cases are set for a preliminary hearing and pretrial conference today. The court will note for the record that other charges against Mr. Estes of burglary and theft, 25 CRB 150, 25 CRA 150 and 25 CRB 151 were scheduled today for a preliminary hearing and pretrial conference. The law director did file a motion to continue the preliminary hearing and pretrial conference in those cases as a result of a witness's unavailability. The court did grant that continuance and rescheduled those two cases for June 2nd That would be next Monday at 9:00 a.m. Present in the courtroom is Mr. Estes. He is currently incarcerated in the Conneaut City Jail. On the new case is filed against him. He was brought up to appear personally for this hearing. His attorney, Mafid Sayed, is sitting next to Mr. Estes, along with Law Director John Lewis and Patrolman Charles Burlingham sitting at table with Mr. Lewis. I understand that we're running a preliminary hearing, Mr. Lewis?
It will appear that way, Your Honor. Yes, sir.
Okay. Go ahead and call your first. Any argument, counsel?
No, Your Honor.
Wait, at this time, Your Honor.
Okay, call your first witness, Mr. Lewis.
Your Honor, the state of Ohio will call Dakota Mullen.
Mullen, you can step forward, please. Before you're seated, ma'am, can you raise your right hand? Do you solemnly swear or affirm that the testimony you're about to give is the truth, the whole truth, and nothing but the truth, so help you God?
Yes.
Okay, you may be seated. Ms. Mullen, can you ensure that you speak loudly and clearly so that we can make a proper record of this proceeding, okay?
Okay.
Okay, you may begin, Mr. Lewis.
Thank you, Your Honor. Ms. Mullen, would you please state your full name and spell your name for the record?
I'm sorry. I did lose my voice. Dakota Mullen, DAKOTAMULLEN.
And, ma'am, where do you reside?
487 State Street.
For what? Say that again.
487 State Street.
Is that here in Conneaut?
Yes, sir.
Okay. Are you familiar with the defendant, Todd Estes?
Yes.
And how are you familiar with him?
He's my boyfriend.
I want to direct your attention to the 16th of May, 2025. First of all, are you involved in a domestic violence case with Mr. Estes?
Yes.
Or you're the victim and he is the defendant?
Yes.
Yes?
Yes. I'm sorry.
And is there a no contact order to your knowledge in that case?
Yes.
Yes?
Yes.
Okay. I want to direct your attention to May 16th of 2025. Did you encounter Mr. Estes that day?
Yes. Yes.
Yes? And how did you encounter him that day?
He was at my window.
I can't hear you.
I'm sorry. He was at my window. That was the day that the burger, I can't say the word. When he came to my window.
He came to your window?
Oh, I don't know what date that was. I don't remember what happened on the date. Is this for the, like, burglary charge? I'm sorry, I can't say the word. Yes, he came to my window, yeah.
Came to your window?
Yes.
Which window?
The back window.
Of your house?
Yes.
What happened next?
We talked through the window, and he came in. But it was no aggression, nothing like that. I gave him water, and then was walking him out, and that's when I sprayed him.
Your Honor, I can't hear the witness.
I'm sorry.
You have
I
to
can't.
speak up louder, man.
I lost my voice. He came to my window, and I gave him water after I had him give me all the stuff that he had of mine. And when I was escorting him out, that's when I sprayed him.
You sprayed him?
I maced him, yes.
Okay. Well, why did you mace him?
I used to be a CO. I always have mace on me. I used to be a CO. I always have mace on me, especially when they're with what happened. Just in case anything were to happen, I could protect myself.
Oh, let me just to understand what you're saying, you're saying you allowed him to come into your house?
Yes.
You allowed him to?
The window was unlocked, yes. But I,
Did you tell the Conneaut Police Department on
He
May
ca-
16th that he climbed up the side of your house, came in the second story window?
yes,
Okay, so which is true?
he climbed up to the second story and he came in my window, but I was there with water. After I talked to him and made sure he was
And
there.
Did you tell the Conneaut Police Department that he lunged at you?
Yes, he did.
Okay, is that what you told the Conneaut Police Department that day?
Yes, and that is what happened.
And then you maced him, is that what?
Yes, that's when I was escorting him out. And I don't know if it was aggressive or not, but regardless, I maced him because
Let me ask you this, what
fight
happened
or
after
flight.
you maced him?
He left, and I called the police.
Did he have permission to be in your home?
Legally, no, and technically, no.
Did he have permission to be in your home, yes or no?
No,
And you are aware that there is a no contact provision of his bond in the domestic violence case, is that correct?
yes.
So just so we're clear here, your testimony is that on May 16th of this year, Mr. Estes climbed up the side of your house, is that
Yes.
correct?
Yes,
And he came in through a second story window,
yes,
okay? Was he permitted to come into your house that day?
legally, no.
Okay. And he lunged at you?
As I was escorting him out, yes,
So yes.
yes,
And then you maced him.
yes.
And then what happened after that?
He left. He ran, and I called the police.
And you called the police?
Yes,
And did the police come?
yes.
Do you remember who you spoke to that evening? As far as police officer?
Officer Dan and was he right? Him and him.
And did you give a written statement to the police officers?
I just agreed with the questions. I didn't write anything,
Okay.
but
They took a statement from you?
yes,
And you described to them what you just basically described
Yes.
to us, correct? You indicated that Mr. Estes lunged at you, is that correct?
yes,
And then you maced him?
yes,
And then after you maced him, he fled, is that correct?
yes.
I have no further questions at this time, Your Honor. Thank you.
Thank you, Mr. Sayed.
Thank you, Your Honor. Good afternoon, Dakota.
Good afternoon. Sorry, it's hard seeing them like that.
First, how did you get here today?
I was escorted here.
By who?
An officer, they suspended my license.
So the police department came and got you here?
Yes,
How long have you known Todd?
a long time.
Roughly how many years?
I met him when I was 17.
How old are you now?
I'm 24.
So 7 years?
Yeah, oh my god, yeah.
How long have you guys been dating?
Since right after Christmas.
This past Christmas?
Yes,
So 5 months? 6 months now? Almost? You guys are still dating?
yeah.
Yeah, hold on. You don't speak. Go ahead, answer his question. Are you still dating?
Yes,
You two are still together?
as far as I'm aware, yes.
Was your relationship always rocky from the start?
No,
It was good in the beginning?
yes, sir.
So let's talk about, first, the prosecutor brought up the fact that there's an ongoing domestic violence case with Todd. Is that correct?
Yes,
Who else has an ongoing domestic violence case against you?
Objection.
Yeah, sustained.
Let's talk about the incident that happened on May 16th, 2025.
Yes.
Okay? You said Todd climbed up the second story.
Yes.
How did he climb up the second story?
A ladder.
Okay. He brought a ladder with him?
No, my backyard is filled with junk. It's not that hard to get in any window in the house.
Did you know he was coming?
No.
Did you leave the door, did you leave the window open?
No, I opened it.
You opened it for him?
Yes.
You let him in?
After seeing his feet bleeding, him needing water, and he hasn't eaten in days, or I haven't heard from him in days, yeah.
So you let him in?
I unlocked the window after getting my belongings, which included stuff from my car, yes. To give him water and food and clothes that he wanted, that's what he came there for. And I went to go escort him out, and that's...
Okay. So, I'm sorry, I didn't hear. I know you lost your voice.
I'm sorry.
You said he came with your belongings and then he left with his belongings?
He didn't get the chance to get his belongings because I felt safer if he was out back.
Okay.
Well, I grabbed his bag that I already had packed. But we were, I honestly don't remember if we were arguing or what, but I wanted him to stay outside, and I kind of blacked out after that.
But you allowed Mr. Estes to come inside?
Yes. Legally, he was not allowed there, but yes, I did let him in.
So that's what you meant earlier when you said legally, no?
Yes.
But you let him inside?
Yes.
There was no forced entry?
No.
Mr. Estes didn't break the glass to get in? He didn't use a weapon?
He didn't even try to break in a door. He knocked on the window.
Okay.
He was not aggressive at all. He needed help.
He wasn't stealthy? But he wasn't trying to sneak in and catch you by surprise? Okay. He didn't use a deceitful manner to come inside your house, like pretending to be someone outside?
No, he said, please let me get my things. I want to go. Let me get some water. I'm hot. I'm his only home out here. And after I retrieved the things he took from my car, and I felt safe enough to grab his bag, give him water, food, and shoes, and send him on his way, I opened the window.
The shoes you gave him, were they his?
He did not end up getting shoes.
Okay.
When he came in, I said, can we go downstairs so I feel safe when you're outside? I'll grab everything I already have packed and whatnot. And he didn't end up leaving with any of his belongings. But the shoes would have been his, yeah.
The shoes would have, okay, so can we back up a little bit, please?
Yes.
So, Mr. Estes was living with you?
Yes.
How long were you guys living together?
He was since January, early January, first week.
So the beginning of your relationship, you guys were already living together?
Practically, yeah.
Okay, so his stuff was there?
Everything of his is there.
Everything of his was there?
Yes.
So that night on May 16th, and when you let him in, he was just grabbing his stuff? He wanted to grab his stuff?
Yes.
Okay, so he wasn't trying to take anyone else's property? Who else lives with you in this home? What do you thought?
Me, my mother, and my stepdad.
So total 5 people?
4.
Oh, okay, I'm sorry, 4 people.
Yeah.
So 4 people, so when Todd came that night, okay, he didn't give you the impression he was trying to take...
It was still daytime.
Oh, the daytime, okay. He didn't give you the impression he was trying to take anyone else's belongings?
No, he was not aggressive. He was just begging for his things and water. And I seen how roughed up his feet were. He looked a mess and he needed help. And I'm the only person he knows out here that would be willing to help him. And I don't care who it is. If they look like they're dying, I'm going to help them.
Do you still love Todd?
Yes.
You love him right now?
Yeah.
You care for him?
Yes.
That's why you let him in that night?
Yes.
Your Honor, I have no further questions.
Thank you. Any redirect?
Yes, Your Honor, thank you. Ms. Mullen, why didn't you just let Mr. Estes in the front door?
I didn't hear him knocking.
He knocked on the front door?
That's what he said. I've been knocking for a minute out. I don't know how long, but I did not hear it.
Why would someone who was welcome in your home put a ladder up against your house and climb up the side of the house and enter through a second-story window?
Because the doors were locked and I was not answering because I had music playing, so I did not hear him knocking.
So your testimony today is that you let him into the house. Is that correct?
Yes.
When you just testified, when I was questioning you, that he did not have permission to be in your home.
Legally, no, he did not have permission to be in the house. If it was a different circumstance,
So if everything was so nice and lovey-dovey on May 16th, 2025, why did you mace him, and why didn't you call the cops?
I maced him because I was trained as a CO that if anybody lunges at me, I protect myself. And there was, and he needs psychiatric help. I don't know who or what state of mind he was in when he lunged at me, but regardless of who it is, if I feel that I could be in danger, I'm going to protect myself. But he seemed fine upstairs. I don't know why he lunged. I don't know.
So if he had permission to be in your house in this moment, why'd you call the cops?
I called the cops because he lunged at me. But
He lunged at you.
yes,
You didn't tell the cops that he came up the side of your house on a ladder, came in through a window. You didn't tell the officers any of that?
no, I did.
Okay.
That's exactly what
But
happened
you just got done
too.
testifying, Mr. Syed said you let him in the house.
Yes, I said he came into the window. He did not break in the window.
Oh, okay. So you let him in the house?
Through the
Through a
window
second-story window?
that he climbed up, yes. But if it was different circumstances, if he was aggressive at the window, if he had intentions of malicious intent, I would not have let him in.
You didn't hear him knocking on the front door, but you heard
It
him
was-
knocking on a second-story window. Is that your testimony?
Because it's right by my room. It's right by my room, and he was knocking at the back door, I guess, because my stepdad screws the front door shut, so you can't get in there.
Your Honor, I'm going to approach the witness, if I may, and offer her, this is going to be State's Exhibit A. This is a written statement that she provided to law enforcement that night because her testimony is way off base from what this written statement says.
Objection, Your Honor.
Go ahead.
She stated that the police officers wrote the statement for her. She never actually wrote a statement.
Did she testify that?
I believe she did earlier.
Yes.
But that's why I brought it up.
So there's a statement that you have that she signed. Does this have her signature?
There appears to be two different handwritings on here, Your Honor. I would assume one of those handwritings belongs to Ms. Mullen.
Okay. So are you trying to treat this witness as hostile?
I'm sorry, Your Honor.
Are you trying to treat this witness, your witness, as hostile right now?
Yes, Your Honor. She's given testimony here today that is not at all consistent with what
Let me
she said
see your
to law
statement.
enforcement.
Let me see your statement. Here, we'll get it. Go ahead. I'm allowing the prosecution to treat Ms. Mullen as a hostile witness.
What do you have there in your hands, Ms. Mullen?
The statement that was written on the 16th.
Okay, does your handwriting appear on that document?
Yeah, yeah.
What part of that is your handwriting?
The top part.
The first paragraph?
Yes.
Okay. Could you read that for the court?
Todd Estes climbed up the side of my house. He came in my window. As I was walking him out, he lunged at me and I maced him and he ran out the back door.
Anything in there about you let him in the house?
No, I just said he came in the window.
Could you read the rest of the written statement?
Yes.
Please?
I'm sorry, I'm having a hard time reading it. Did Mr. Estes have permission to be in the house? No, which I meant legally. Is Mr. Estes allowed to have contact with you? No contact order? No. Do you want to pursue charges against him? No. Did Mr. Estes... I'm sorry. You can, I can't read the, I'm sorry, I can't read it.
That's fine, that's fine. So anything in that written statement about that you let Mr. Estes into your house? No. Anything in there about giving him his belongings?
No.
And in that statement, you indicated that he did not have permission to be in your home, is that correct?
Yes, because legally he could not.
Sorry?
Yes, because he legally could not be there.
Okay. And you maced him?
Yes,
And you called the cops?
yes. I've seen a switch in his eyes and he needs help, he needs medication. So I don't know what he changed to, but whether it was malicious or not, I'm not taking chances. I maced him, yes.
So just to be clear, you did not tell Officer Burlingham or any other officer that you let him in your house. Is that true?
I can't recall, but on here, no.
So you didn't tell them that?
No.
Okay. What did you tell them?
I told him that he came in my window.
And that he didn't have permission to be there, correct?
Legally, no.
Thank you. No further questions.
Thank you. Yeah, I'll just allow some recross on what Mr. Lewis just asked. Any recross?
Thank you, Your Honor. Dakota. I understand on the witness statement, it says, you never mentioned anything about not letting him in. Your window was open, correct? Or you opened it?
I opened it.
You opened it for Todd?
Yes.
Okay. No further questions, Your Honor.
Thank you. You're excused, Ms. Mullen, but you're not going anywhere because we have a traffic case we have to address with you after this is over. So you can go to the back of the courtroom.
I'll leave it here. I'm sorry.
Okay, anything further, Mr. Lewis?
Yes, Your Honor. The State of Ohio will call Officer Charles Burlingham.
Do you solemnly swear or affirm that the testimony you're about to give is the truth, the whole truth, and nothing but the truth, so help you God?
Yes, sir.
You may be seated. Thank you. You may proceed.
Thank you, Your Honor. Officer Burlingham, please state your full name, spell your name for the record.
Charles Burlingham, Burlingham.
And you're employed by the Conneaut Police Department, correct?
Yes, sir.
How long have you been so employed?
35 years.
And you are a certified peace officer in the state of Ohio, is that correct?
Yes, sir.
I want to draw your attention to May 16th, 2025. Were you on duty that day?
Yes, I was.
And do you recall what shift that might have been?
Night shift, 7 p.m. to 7 a.m.
Okay. And did you respond to a call from Dakota Mullen that evening?
Yes.
And could you describe the nature of that call?
We got a call that Mr. Estes and was at the house and he wasn't supposed to be.
Okay. And what, if anything, did you do in response to the call?
Well, I drove to the scene and I met with Miss Mullins out in the front yard.
Okay. What was her demeanor like?
She was upset, crying.
Okay. Did she say any, strike that. Did she give a written statement? Did she give you a written statement?
Yes.
Okay. Your Honor, if I may show the witness the exhibit. Thank you. This has been marked as State's Exhibit A. Do you recognize that?
Yes, sir.
What is that?
That is the statement I took from Dakota that night.
Is her handwriting, first of all, did you write that entire statement yourself?
No, I did not.
Okay, so she wrote part of that, is that correct?
That is correct.
And then you asked her some follow-up questions, is that a fair statement?
That is yes.
Okay. And does that appear to be a true and accurate copy of the written statement from that night?
Yes.
Other than taking a statement from Ms. Mullen, what, if anything else, did you do as far as investigating the call?
Personally, yes. She told me that he could, I asked her if he could still be inside the house. She said he could. So she went inside and she locked the dogs up. And Patrolman Patriarch and I went inside and checked the house.
Did you see any signs of a ladder, as Ms. Mullen just described, or any sign of forced entry anywhere or anything like that?
Well, the upstairs bedroom, or not bedroom, hallway window was open, and we checked up there. And when we went outside afterwards, because she said he exited out the back door, we went outside and there was a ladder up against the back of the house.
Did Ms. Mullen say anything to you about letting him into the house?
No,
Your impression was that he entered without permission?
that's correct.
Any evidence of mace
There was definitely mace had been sprayed inside the house because it was irritating our throats and making us cough.
You could smell the mace?
Yes,
Did it affect you?
yes,
And you had another officer with you, is that correct?
yes. Patrolman Patriarcho.
Okay. And so you noticed, you could tell that mace, and based on your training and experience, you could tell that mace had been sprayed?
Yes, sir.
Anything further, Officer Burlingame, any further investigation on your part?
No, I went there a couple of times to talk to her again because there was a camera on the back on that night, on the video camera on the house, and I asked her if she, if that worked or recorded anything, and she said I think her mother or father only had access to it. And I stopped there 2 other times to get in touch with her and nobody answered the door.
And just so we're clear, who was the primary caller with regard to this case?
Dakota.
Okay, thank you. No further questions, Your Honor.
Thank you. Cross-examination?
Thank you, Your Honor. Good afternoon, officer.
Good afternoon.
How are you?
Good.
Good. Officer, how long have you been in law enforcement?
35 years.
Long time.
Mm-hmm.
Not even that old. So let's go back to May 16th, 2025. Okay? You respond to a call from Dakota.
Correct.
Correct? What time, roughly?
It was a little bit after 7.
Was it still daylight out?
Yes.
So you could see, you could see.
Mm-hmm.
Okay. You were allowed inside the house.
Correct.
You said Dakota was crying.
Mm-hmm.
She was upset.
Yes.
Officer Burlingham, do you know why we're here today? What Mr. Estes is charged with?
Yes.
Which is?
Burglary.
Okay. He's not charged with lunging at someone for this particular hearing, correct? As far as you know.
Correct.
Okay. So you went inside the house, you spoke with Dakota. How long did that conversation take place?
I don't know, it was like 5 minutes, but it was outside originally.
Outside. And then she let you into the house?
Correct.
And you investigated the home?
We checked for Mr. Estes, yes.
Mr. Estes wasn't there at that time, correct?
Correct.
Then you didn't check for any signs of forced entry?
Well, we were upstairs and that's when we saw the window that she said he came in.
Did you look at the window?
I don't think the window was even there.
I'm sorry?
The window wasn't even there.
There was no window? You just mentioned you went upstairs and you saw there an open window. Did you not?
Well, open frame.
Okay, so there's a window opening, but there's like no glass or anything?
Right.
Okay, so the window couldn't be closed if it wanted to.
I have no idea.
You don't remember?
I have no idea if it can be closed. I mean,
So was the window open?
they can put something in there and close it. I have no idea what they do to.
So that window right there, that's closed, correct?
Correct.
Okay. In the Dakota Mullins residence, was it wide open?
Yes.
Okay. Were there signs of broken glass?
No.
Were there signs of forced entry?
No.
Okay. And then after you concluded that there was no signs of forced entry, what happened? Did you go out looking for Todd?
Correct. We went back downstairs and we went out the back.
Todd was not there.
He was not there.
When you went out the back, was there a lot of junk in the back?
There were some.
Some junk? Okay. No further questions, Your Honor.
Redirect?
No, sir, thank you.
Thank you. Officer, your excuse. Any further evidence, Mr. Lewis?
No further evidence, Your Honor.
Would you like to offer this exhibit, or?
Yes, Your Honor.
So Exhibit A, the statement of Dakota Mullen. Mr. Sayed, any objection?
No objection at this time, Your Honor.
Okay, Plaintiff's Exhibit A will be admitted without objection. Does the plaintiff rest?
Yes, sir.
Okay.
Thank you.
Okay, Mr. Sayed, any evidence?
Your Honor, at this time the defense rests.
Okay. Argument, Mr. Lewis.
Thank you, Your Honor. Clearly, Ms. Mullen is a little bit confused, maybe not sure what she wanted to do with this case. She indicated in the written statement there, states Exhibit A, that she didn't want to press charges. That's fine, but if you don't want to press charges, why do you call the police to your home? Why do you mace the individual that you told officers did not have permission to come into your house and enter through a second-story window? Why would you do these things? She clearly, in her mind, testified that her and Mr. Estes are still in a relationship. She has a bias of trying to protect Mr. Estes from this prosecution. But it's clear, Your Honor, based on her testimony, her written statement, Officer Burlingham's testimony about smelling mace in the house, that the version of events that she gave to officers in that written statement, states Exhibit A, is what is true. Why else would she have called law enforcement on that night if it were not true? There's evidence of a ladder. Officer Burlingham saw the ladder that shows that Mr. Estes entered the home through a second-story window, knocked on a window that was apparently non-existent, and came into the home. Your Honor, the complaint indicates that on or about May 16th, City of Conneaut, Mr. Estes did knowingly, did by force, stealth, or deception rather, trespass in an occupied structure, namely 487 State Street, when another person other than an accomplice was present, namely Dakota Mullins, with the purpose to commit in the structure any criminal offense, to domestic violence. Contrary to Mr. Sayed's argument, he is charged with lunging at her. That is where the domestic violence count comes in under 2919.25C. Your Honor, the victim, alleged victim's own statement makes it clear that the state of Ohio has shown probable cause that Mr. Estes committed a burglary on May 16th in her home at 487 State Street. And the state of Ohio is requesting that the case be bound over to the grand jury for their consideration, and the misdemeanor case would also accompany that. It's clear that Ms. Estes was telling partial truths when she was here on the stand, and that her written statement is in fact a clearer recitation of what actually happened on May 16th. Thank you, Your Honor.
Thank you, Mr. Sage.
Your Honor, this case is about whether Todd Estes and Ms. we understand that Todd and Dakota have a complicated history. I know this, the law director knows this, this court knows this, okay? We're not here to talk about the macing or the lynching. We're here to see if he committed burglary, and if there's probable cause presented by that. There isn't any today. Mr. Lewis wants to paint this picture that Dakota's been lying. She didn't lie. The witness statement is true to what she's been testifying today. The window was open. He came in through the window. She didn't go into detail. Obviously, it's a sheet of paper, which, to the court's attention, I have not seen. But she stated she let him in. She let him have water. She stated there was no force, there was no stealth, there was no deception. We've heard from Officer Burlingham. He investigated the scene. He said there was no force detected. We know that there was a ladder there because Dakota said that there was that her stepdad keeps junk in the back and there was ladders back there. In her own words, I allowed him to come in. That's not trespass. And if there's no trespass, there's no burglary. So at this time, Your Honor, there's not enough probable cause here for this to get bound over. He doesn't meet the requirements of burglary. There was no force, there was no stealth, and there was no deception. Dakota welcomed him in as if he was a guest. She took care of him. She even mentioned, I wanted him to grab his belongings because his belongings were there. They lived together since January. He was returning her belongings, I believe. So for the evidence presented today, including her testimony and the testimony of Officer Burlingham that there was no force, this does not meet the statutory requirements of Revised Code 2911.12. Thank you, Your Honor.
Thank you. Any argument responding, Mr. Lewis?
Well, contrary to what Mr. Syed is saying, there doesn't need to be force. There can be stealth. I don't think it's... I think that the circumstantial evidence, aside from Ms. Mullen's testimony, shows what happened here, Your Honor. She called cops. She called law enforcement. She called 911. That's why they responded. She also maced Mr. Estes, and the officer Burlingham testified that they could still smell the mace in the house. So you've got a ladder leaning up against the window. You've got an individual who was maced, and you've got a young lady who called the police and initially told the police that he entered through a second-story window and that he had no permission to be in the house. And that's what her written statement says. We don't have to show forced entry here, Your Honor. It could be by force, stealth, or deception. Thank you, Your Honor.
Thank you. So one thing I wanted to address is 25 CRB 131. This is the original domestic violence case. He was charged, he pled not guilty, domestic. I ordered as conditions of his bond that he have no contact with Dakota Mullen and remain off the premises at 47 State Street. He entered that plea on May 12th. We conducted a pretrial conference on May 21st, at which time the law director orally withdrew its motion to revoke bond that was filed on May 19th. So I just want to make sure that was orally withdrawn.
It was, Your Honor. At the hearing, Ms. Mullen did not appear for that hearing, if the court would recall, and that's I had no choice but to withdraw my motion at that time.
Okay.
Thank you.
Okay, in looking at Ms. Mullen's written statement, Todd Estes climbed up the side of my house, came in the window, and then something walking out, he lunged at me. I maced him, he ran off the back door. In her written statement, and even in the questions that follow, it doesn't mention about how he entered the second story of the home, whether she let him in or not. I'm sure in calling the police, she probably led the police. That's why they did the investigation, to believe that he probably was there. But at least with respect to consistency of testimony here, between her written statement and her testimony today, there doesn't seem to be inconsistency about how he entered, whether she let him in or whether she knew about it. But her testimony today is that she allowed him to enter to get his clothes. So, yeah, I did order him to stay out in the 25 CRB 131 case, but that cannot be used as a basis for trespass. I'll deal with that here shortly. So not only did Mr. Estes not trespass, but there's no evidence that he entered this property with purpose to commit domestic violence. There's no evidence whatsoever. That was his reason, based on Ms. Mullen, was to get clothes and to get water, and something happened as she was walking him out. I do find, based on the evidence presented after preliminary hearing today, that probable cause has not been established for the offense of burglary in case number 25 CRA 148, and this case, bond will be discharged, and this case will be dismissed. We will schedule 25 CRB 149, that's the domestic violence case, for another pretrial conference on the same date as the other cases, for June 2nd, 2025 at 9 a.m. I am revoking the defendant's bond based on the testimony, whether there's a pending motion or not. In 25 CRB 131, the court's own motion, the defendant clearly violated the court's bond in 25 CRB 131 when I ordered him to have no contact with Dakota Mullen and to remain off the premises at 147 State Street in Conneaut. I did allow him to retrieve his personal belongings at that residence with a police escort only. And that didn't happen. And I guess people don't care what I ordered and guess conditions his bond, so I'm revoking his bond in that case. And he will be held without bond in that case. And this case will as well be set for another pretrial conference for June 2nd at 9 a.m. Okay. I think I've addressed everything. Is there anything further, Mr. Lewis?
No, Your Honor.
Mr. Syed?
No, Your Honor, not this time. Thank you.
Okay. Mr. Mullen or Mr. Estes will be taken back down to jail, where he'll be held until June 2nd. Ms. Mullen, step forward, please.
See you Saturday.
Yeah, we'll see you Saturday. Oh, yes, we'll see you Saturday. Thank you, sir. See you later.
You guys come on.
In 1 second, Ms. Mullen.
Every day in the USA, people find themselves in court.
Michael, Attorney Sanders. Mr. Sanders, if you could please unmute.
Good morning, Your Honor.
Good morning, sir. I see that you have one matter today, Sharice Grant, 5A029418. If you could please begin with any preliminary motion, sir.
Yes, sure. A motion regarding 6.6 affidavit. The court should have a copy of a public record that basically, in summary, has a CV, certification pages 2 and 3, ending in page 4, and then in the middle of the page 4 is the individual certificate for R2322. This format currently at the moment is not complying with Unsworn Declarations Act 550-050 or General Rule 13. There's no date or place or signature anywhere on the first portion that is the declarations of the Anthony Hillock. And then, of course, with the performance test on September 13th, 2024, that document standing alone also does not have the requirements for authentication with the date, place, and signature for admissibility.
All right, sir, I do see that. So based on that information, I will go ahead and suppress any information obtained by the speed measuring device. I am looking over the affidavit to see if there is any additional information from the trooper in regards to speed. So it says here that based upon my experience and training, I visually estimated the speed of the defendant's vehicle to be 80 miles per hour and a clearly posted 60-mile-per-hour zone. And then the speed measuring device displayed 76. That information has been suppressed on your 6.6 motion. Is there anything in regards to the visual estimation of the speed by the officer?
I was looking at the bottom for defendant's statement. Well, based on experience and training, he estimated. I don't. He doesn't give us any explanation as to the length of his experience or training, or how he arrives at a visual estimation of speed. I don't, whether he was using other vehicles in traffic as a guide or something else on the ground. He just doesn't tell us what he based his visual observation on, his actual observed indications, what he saw occurring.
Sir, it just says at the beginning, while at the academy, I was trained in the use of radar speed measuring devices and visual speed estimation. So it does state that he had training in regards to visual speed estimation.
But here we're actually cited for speed. He's citing for speed 16 over, but we're not. If he's using a visual estimation, it's difficult to understand why he's writing it for the radar. Here, we don't know what would be the speed that was committed. Is it just based on what he visually believes it might have been without the radar? We're not left with anything that would say definitively that it was 80 miles per hour based on a visual observation, based on training and experience. I just don't, I drive a lot. You and I can make, I suppose we could make guesses as to how fast another vehicle is going, but it's usually in relation to other traffic. We're getting passed by another vehicle. We know how fast we're going. But I would argue that there just aren't enough details where he's saying, this is my estimate. We're not giving what it is that he's relying on, again, for his estimate. The speed of other traffic, his speed, anything on the roadway that he was using as a guide. You can't really visually estimate unless you're telling us what you're using to base that estimate on, actual observations.
Okay. I will go ahead and grant your motion. I mean, I do think that he does have experience and training to be able to make visual estimates in regards to speed. However, I do think that that's a valid argument that there is no information in regards to what he is using relative to gauge the 80 miles per hour. He just says that there's a visual estimate of it, but not that he's looking at other vehicles or what he's using. So based on that information and your motion, I will go ahead and grant it. I will go ahead and dismiss this charge. Let me just go ahead and pull up this individual. So this is Grant. Why am I not seeing it? Right, so I will go ahead. Fill this out for you.
It is, John. It's the only matter I have this morning.
Okay, well, thank you, sir. I will go ahead and fill this out. I will dismiss the sole count. And this will be mailed to your office, sir.
Again, thank you for the court's time this morning, Erin.
All right, thank you, sir. All right, do you want to call in Motto really quickly? See if maybe he'll respond this time. Mr. Motto, if you could please unmute.
Good morning, Your Honor.
Good morning, sir. We're here in Bogdan Brovkin 5A022475. If you could please begin with preliminary motions.
Yeah, this is to be a defense motion to continue this morning. We'll make an oral waiver of 120 days to come down.
Well, there's a Tony Reiner, right? Attorney Joe Reimer. Yeah, sorry. No, it's fine. Mr. Reimer, if you could please unmute.
Good morning, Your Honor.
Good morning, sir.
Let me turn on the.
No worries. So you're here for Amanpreet Singh. That's 5A00052696. If you could please begin with any preliminary motions.
Yes, Your Honor. I do have a couple of preliminary motions. The first is that I have a copy of the officer's report. There's nothing on the report indicating that the officer used their user ID and password to authenticate their signature. So the language we normally see on almost all of these reports is, I sign this using my user ID and password. I use my user ID and password to authenticate it, something to that effect. And that's what allows them to electronically sign a document. So I'm moving to suppress the officer's narrative under RCW 5.50.010 subsection 3E. I have another argument, Your Honor. And that is in relation to the 6.6 certificate. I did take a look at the 6.6 certificate for device R2322. And although I see an indication that it passed performance tests on September 13th, I don't see any date at which that document was signed. So I don't know whether they signed it on the 13th of September. It doesn't appear to be signed at all. So we have two situations in which I'm arguing that it's improperly sworn to. And and no indication of the signature on the 6.6 document where the expert would be saying, I signed this I tested the device on September 13th. I signed this document on January 1st of 2025, for example.
Okay. In regards to your 6.6 motion, I will go ahead and suppress any information obtained by the SMD. The issue with that, though, is after further review of the radar affidavit from Trooper Hodel, it does say here that based upon my experience and training, I visually estimated the speed of the defendant's vehicle to be 70 miles per hour in a 60-mile-per-hour zone. So even if the speed from the SMD were to be suppressed, there is a visual estimate, of the speed that is from the officer's personal knowledge of viewing it. And then in regards to your I just am trying to look up another report because I don't know why I don't think I don't think I've seen that information that you stated where it says I have electronically affixed, because he's not stating, okay.
It's on most of the reports where they say, I swear under penalty of perjury in the laws of the state of Washington is true and correct, and I'm entering my authorized user ID and password to authenticate it.
I'm just looking at numerous reports and I don't see that on any of them, so I don't know if that's...
It's on this report on the separate document, and it's on the PC statement, the NOI.
The only issue with that is that we're looking at Sangam and Preet. The issue is that the affidavit, yes, I see what you are saying in regards to that he's saying under penalty of perjury that the foregoing is true and correct. But then if you look also at the violator copy, the NOI, it does say here that, I mean, it's only in the NOIs that I've ever seen it stating anything about needing the ID and the password to authenticate it. And he does have his stated law enforcement number specifically related to his badge. So then he does have technically a signature that is valid pursuant to 5.50. So
Your Honor, I mean, I do understand what you're saying is, okay, there's a visual estimate. He doesn't say I paced the vehicle for some period of time. I saw them from 50 miles, 50 feet away. And I mean, the state's burden is also to prove the offense. It's the state's burden to prove it with, by a preponderance of the evidence, but they have to lay a sufficient foundation for an appropriate reading. Seattle v. Peterson says that a speed measuring device can be relied upon where it's regularly tested. So there are situations where an officer can say, yes, I did, according to my training and my estimation, which is within about 5 miles an hour, I think he was going over the speed limit, and so I engaged my device. And that allows them to take a specific reading according to their training. So they're allowed to engage the device and take a reading. The courts agreed that they would suppress the speed measuring device, and here the state has the burden to prove a specific number of speeding 9 over the limit. The officer estimated 70. The device read 69. So actually their estimate was greater than the estimation. So they estimated 70. They were, they were close if we believe the reading. But what I'm saying is that, they could have chosen to charge him speeding 1 over. And then, much like charging a lesser offense instead of a greater offense, the state would have a burden to prove 1 mile an hour over. But here, the state chose to attempt to prove 9 over. And that is different. There's a different fine amount. There's different legal conclusions that need to be met, the state has the burden to say, yeah, by a preponderance of the evidence, they were going 9 over. And here, visual estimation of 70 just is insufficient in order to establish this foundation for proving 9 over the speed limit. Here we have a estimation. We don't know from the officer's testimony whether they estimate within 5 miles an hour, whether, they estimate it perfectly, whether an estimate of going over the speed limit is, sufficient to prove 9 over the speed limit. He says, I estimated a specific speed, which I appreciate. The officers are supposed to choose a specific speed to see whether it matches with their SMD. That's one of the checks that they do. So he actually did the training correctly in that he took a specific estimate, which many of the officers don't do. They just say, I think that was speeding. And they don't actually kind of write down, I think I was going 75, and then they check their device. So that's actually a check to make sure that the device is working properly. And, it's quote unquote matched. It was close enough to the visual estimate. It's one of the checks that they do to see that the SMD is working properly. But I don't think the visual estimate alone is sufficient in order to prove the specific burden of 9 over. Maybe it's enough to prove speeding 1 over the limit, right? But I don't think that that's sufficient to know that his estimate is definitely accurate to within 1 mile an hour in order to lay the appropriate foundation to say that this was done. And we don't know how long he saw the vehicle for.
Right. So I think that, sorry to interrupt. I think that your initial argument in regards to just how he obtained or paced that information, while it does state that experience and training is there, he doesn't state exactly how he did obtain the 70 and a 60. So based on that information, I will go ahead and dismiss. However, I do think that the argument of 69, which was obtained as opposed to his 70, which he visually estimated, only buffers the fact of how good his estimate was, the fact that it was only 1 mile per hour over. But since there is a burden to prove which one would have been the correct speed, I'll go ahead and give you the benefit of the doubt and dismiss.
Thank you, Your Honor. And I think that's everything I have in Your Honor's courtroom.
I think that's it today. Thank you.
All right. Have a nice day. Thank you.
You as well. Bye. Kwasniuk. Thank you. Right. So he looks like he's trying to unmute. Sir, if you could please unmute.
Good morning, Your Honor.
Good morning, sir. Or I'll go ahead and dismiss for lack of foundation. All right. The next one is Chidambaram Subaya 4A09203440.
Thank you, Your Honor. And first, I want to say congratulations on saying that name probably correctly.
I tried. I said it very slowly.
I was excited to see how you're going to do that.
Thank you.
That being said, we believe the 6.6 certification is invalid. It's signed in 2021 for the curricula vitae only, not signed for any testing portions, not signed whatsoever or dated for the testing portions, actually. For that reason, we ask to suppress and dismiss.
All right. So L1692. Do you see that? So I will go ahead and suppress any information obtained from the speed measuring device based on your 6.6 motion. I'm going to look through the report to see if there's any visual estimate, and there's not. It just says, I observed the defendant traveling at a visibly high rate of speed in excess of the posted speed limit. So as such, I'll go ahead and dismiss for lack of foundation.
Thank you, Your Honor.
And
Your Honor, I will say if it ever comes to the issue of a visual estimation, I have argument on that as well.
Can I hear it? I'd love to hear it.
Yeah, it's very
really
simple. In the state of Washington, there has to be an objective standard, not a subjective standard. Visual estimate is merely a subjective standard, not objective standard. Therefore, it is not reliable. And that's why
Okay.
we have experts and all that.
Subjective versus objective. Okay. And then what would make it objective if they're saying, you know, based on my training and experience, I visually estimated it to be, let's say, a 70 and a 60. Okay, that's subjective. But how would that ever become objective?
I would say, yeah, I mean, based on if it's based on their training and experience, it's still subjective. I can tell you that anybody who drives a vehicle knows how fast vehicles go by standing on the side of the road. It's still subjective. If the speed limit's 40, you can watch every car go by going 40. So everybody can make that argument. The state of Washington requires you to do more, and that requires, or the state to do more, and the state is required to have certifications and show that it's accurate and have some sort of testing device. That's why there, if you look at Spokane v. Knight, as far as like a pacing goes, you can't just do a visual estimation. You have to have certain criteria like a certified speedometer, equidistance, all of that.
Okay, and so is Spokane v. Knight the one that you're using for objective versus subjective, that argument?
I would probably invoke that one to show, at least draw a correlation between the two, because it stands to as a proposition that there has to be some objective standards that are subjective, because you have to have those different requirements in order to have. It's obviously it's an author's visual estimation at that point when you're pacing, but the pacing to specifically be a pace, there has to be specific requirements to qualify as a proper pace.
Okay, that's very well. So I've had that argument brought up a few times today, and man, none of them were as clear as what you just stated. I mean, they eventually got to a point which was valid, but it did not quite make sense. So that's a very good argument, the objective versus subjective. So very, very good job again.
Thank you.
Great job. That was wonderful. All right, Bodan Vasilievich. 4806. Go ahead, just begin. Just do what you do. Do what you do.
Thank you, Your Honor. I have two ways to come with get to the same result. I'll start with the easy one first, the invalid 6.6 certification. It's signed in 2021. I can give you the more full detailed one, if you wish.
In regards the argument.
Okay. Thank you for forwarding that. I have gone ahead and signed the final report.
Thank you.
Thank you. Number 8, 24-40047-308, In re Timothy Weaver.
Good afternoon, Your Honor. Josh Volvovic on behalf of the petitioner, Americana Health and Rehab Center.
Yeah. Let me just check in. I know you sent notice of the hearing to the proposed or the listed personal representative in the will if there was a probate occurring, and I don't see them on. Is anyone else here for the Timothy Weaver matter? Okay, have you received any response?
Your Honor, no, I haven't, although we haven't been able to file this yet with the court. We just were able to personally serve Sherry Weaver copies of this petition yesterday. Although we did mail all the documents on May 14th. I called this morning in preparation for the hearing. I called the phone number attached to the front page of the document Ms. Weaver filed with the court on December 27, 2024, that phone number, but I did not receive a call back. It went to voicemail, but I can represent for the court. She was personally served yesterday. So I was going to see, for the discretion of the court, I was hoping she would show up today, at least via Zoom, and I would continue the case, continue the matter for give her more time. But it's just a really unique matter, as she filed the will and she's not probating the estate and not reaching out to us, sent letters, certified mail, which the tracking number showed it was delivered. So we're a little bit at unsure what to do. That's why we've come to the court. So up to the court's discretion, I think perhaps I'd be willing to continue it, Your Honor, and make additional attempts to contact her, knowing that she's been served personally as of yesterday.
Yeah, that's fine. I do think we should set a new date. I do have concerns over whether we've acquired jurisdiction over her, whether we really have an action pending. There is no summons and complaint for any type of action. And like you said, this is a unique, very unique situation. I did a little bit of research into it. And if you're asking to move forward without a personal representative being appointed and probate, I guess I would want some additional briefing because I'm not sure sitting here today I can give you what you're requesting until we have a PR. And whether that's her or whether that's someone else that you ask for, but that's kind of my thought process right now.
Yes, Your Honor, I agree. We prefer it if the designated PR remains as the PR.
Okay.
And there is property, Your Honor, still in the name of Mr. Weaver. It's in Longview, Your Honor, and so
yeah,
it's just sitting there, Your Honor, and we're not sure.
I'm wondering about that too, because it looks like there is another individual's name on it. So it gives me a little more concern too. I don't know if this was a community asset. So again, I would have some hesitation giving relief anyway. So let's set this over. If you want to dig a little deeper, maybe provide me any authority for what you're requesting. I'll be happy to re-review it.
Will do, Your Honor. Thank you.
Do you want a specific date, or would you like to re-note on when it's ready?
I would prefer to just continue it, Your Honor, if that's possible. But up to the court's discretion. I understand too if
to continue to a date specific.
Yes, Your Honor.
Okay. What date would you like?
Would June 11th work for the court?
Yeah, I think I might suggest a little further out if she was just personally served yesterday and she's going to need to get notice of this new hearing and she's out of state. I would think a bit longer, but if you want to check in June 11th and see where we're at, I'm fine setting it. I just don't know that I could take action on that date.
Or July 9th, Your Honor, if that works.
Okay, let's do that. I think that's probably safer bet for everyone. Let's go to Wednesday, July 9th at 1 o'clock.
Thank you, Your Honor.
Okay, thank you. Okay, on the Robertson matter, are we expecting oral argument?
I believe so, Your Honor.
Okay, let me just, I have a couple other quicker matters. I'll circle back to this one in just a minute.
Thank you.
Shouldn't be too much longer. Okay. Number 11, 25-400-16508 in re estate of Carol Harrison. Mr. Frey, I just got oral argument.
I believe so, Your Honor.
Okay, let me just, I have a couple other quicker matters. I'll circle back to this one in just a minute.
Thank you.
Shouldn't be too much longer. Okay. Number 11, 25-400-16508 in re estate of Carol Harrison. Mr. Frey, I just got the proposed order in on the default that was granted last time. So I'm going to look through it as you speak to me. So go ahead.
Okay, Your Honor. Well, this follows the petition that we filed along with the summons, and we had service by the sheriff, and we also you should see a certificate of service by mail on this from last week of the actual default judgment we're proposing. The summon itself says the default judgment is in order here if the individual fails to answer the petition or object otherwise, and I believe that's the case. And so the you want me to keep talking, or are you ready to sign it?
You know what? Hold on one second. We might have the other individual here. So hold
Okay.
on. I'm just getting we might have them in the iPad booth. In iPad booth, I'm going to send you a request in iPad booth 1 to unmute. Can you tell the court your name? You have to click the unmute button, sir. We can't hear you.
This one?
Yes. What is your name, sir?
My name is Mario, and last name Mizgawa, Mizgawa.
Okay. So this is, you are the individual on the estate of Carol Harrison. Did you receive the proposed default judgment?
Yes, I have. That's been served from the sheriff.
Okay. Someone else is trying to speak. Are you trying to speak on this matter, ma'am? Okay, I'm going to mute folks who aren't currently in front of the court. We're getting some feedback. Okay. So you did receive it. What are you here to tell the court? I haven't received any filings from you.
Well, the court supposed to be my opinion because I don't know how to my fact explain it. That was very complicated. Is I got to receive the documents. The sheriff told me, Mario, you better read these things. I said, okay. I started reading. And then I went to my file, and in my file, a lot of documents been missing. Few, let's put this way. Then I went to Three River, attorneys, because I got an appointment on the 6th with them. And I said, well, a lot of documents been missing from, I can explain it how. But in the same time, the front desk told me, well, we're not taking your case, Mario. That's it. So in this point, they give me a referral to Mr. Anagnostu. And the other, I don't remember the other office. So anyway, I went to both offices, Mr. Anagnostu take the case. And I got an appointment with him on the 2nd. That's the appointment.
Next week?
Yes, so that's why I got an appointment with him.
Okay.
Now, he's on vacation. So I missed this one day because from some reason I'm really, really sorry, Judge. I don't know how, I can't explain it. I'm not going to make it up story. In my head was 26.
Mm-hmm.
So anyway, I asked the clerk because 21st I go to the courthouse, but I was a little bit late. So they don't give me any answer. So she said, the clerk said, you got to come over next day. So exactly next day I show up and they was looking at it. I'm telling them, I said, I got the, a court on the 26th, but I don't know what time is it. I would like to know the time. Well,
okay. So hold tight, Mr. Fry. I'm assuming this might be the first time that you've heard from this individual. So I'll go ahead with anything you're asking of the court today.
Thank you, Your Honor. Mr. Mizgawa, my name is Michael Fry, and I represent Ronald Harrison. And we sent you the summons, which explains what your obligations are under the law. And so the summons require you to answer in writing 5 days before the hearing, which was a week ago. So we expected your answer in writing by May 16th. And I think the court will want you to have a lawyer. I think it's best. I can't give you legal advice. Nobody else probably will either unless you hire them. So it would be best if you had a lawyer, but it's not required. And what's required is that we receive a written answer. And if the court's going to grant you any extra time, if that's what you're asking, I guess I would suggest we set over 1 week to check on the status.
Yeah.
But the petition that we filed is asking for injunctive relief, and we're looking for documents and information too. And my client has, and the whole family has a whole bunch of questions that they've asked me. And that's what the process is of this alternative dispute resolution of TEDRA that we have here. So I want to work with you, but through the proper channels, if that's okay with Your Honor. A set over for 1 week is what I'd propose for the petitioner.
Mr. Agnosto asked me about the, ask the judge on the 18th because he needs a little bit more time. So I appointment with him on the 2nd, but he would like to put on the docket on the 18th.
I'm opposed to setting over further than any more than 1 week after what we've heard.
Well, he's on vacation right now, so I can contact him.
Here's what I'm gonna do, because I did make an oral ruling for default, this was just a presentation docket technically, I'm gonna do a bench order that just pauses or stays a oral ruling. Again, folks, if you're not on docket right now, please stay muted. It'll stay my oral ruling until further review of this court. I think if the appointment with, you said the appointment with an attorney is on June 2nd.
Yes.
Could we set this to June 11th, kind of split the difference there? That gives 2 weeks.
Well,
Sorry, Your Honor, there is no splitting the difference. The family member died and this individual's, I mean, I've been mailing it.
Splitting, Mr. Fry, I'm talking
Filed
about
things with the court already. He filed a draft document with the court months ago, and we need answers as soon as possible.
Hold on,
The
Mr.
state is in
Fry.
jeopardy.
Mr. Fry, I'm talking about splitting the difference between the 1 week you're requesting and the 3 weeks he's requesting. So I'm suggesting we come back June 11th, which is 2 weeks.
Okay.
Are you available
available
June 11th?
Yes, Your Honor.
Sir, are you available June 11th?
Yes, Your Honor.
Okay. We'll come back on June 11th. Hopefully you have an attorney with you and we can work our way forward on this matter. Even if you don't have an attorney, you have to appear on June 11th and we're going to move forward, okay?
Thank you, Your Honor.
Okay, thank you. I'll go ahead and hold on to the original order.
What time again, Your Honor?
Yes, sir, go ahead.
On the 11th, what time exactly?
1 o'clock.
1 o'clock. Thank you, Your Honor.
Okay, and sir, if you're going to contact my office, or if you wanted to contact the family, only go through my office in writing, written word, either by email or dropping off a letter or whatever. That would be great. Thank you.
Your Honor,
Yes.
I have a problem with English. I can write only with attorney, so the attorney can write to you.
Yeah, go ahead and talk to your attorney on Monday when you said you have your appointment. They can reach out to Mr. Fry.
Okay, thank you.
Okay, thank you.
Thank you.
All right, number 12-25-400-19208, estate of Eric Height. Good afternoon, Mr. Claxton.
Good afternoon. I see Chris Height's here as well.
Okay.
And Kimberly Height.
Yeah. Oh, and Cody Height as well.
And
Yeah, I'm here.
okay. Go. Any questions for me?
No, I don't think so at this point.
Okay, well, thanks for your help in getting this done, and we'll see you back in 3 years.
Right.
Thank you.
Thank you, Your Honor.
Yeah, I know. All right. I do think that leaves us with the Robertson v. Robertson Danielson matter. Thanks everyone for your patience.
Good morning, Your Honor. Sinead Barngrover on behalf of the co-trustee Janice Robertson.
Okay.
Jacob Ron here for the petitioners.
And Mr. Ron, I'm having a little bit of difficulty hearing you. Let's try again.
How about now?
It's a little bit better. I'll just have you speak up just a little bit.
Oh, okay. Let's see how long.
Okay.
First off, thanks for calling me last. When I come off of lunch, I have the transition shades, and so I don't want you to think I'm rocking shades when I come in to see you. So I guess let me go with this, Your Honor. I could do really a long-winded opener, or I could kind of give you a cliff notes. Do you want me to go cliff notes for you, or?
Well, let's start with this. Let's start with, I have received and reviewed the parties' filings, so I really do appreciate that. Let's boil it down first to where we're disagreeing and what you're asking of the court to do today about those disagreements.
Okay, so I guess if our office would have got this file to begin with, it would have went something like this. We would have notified the beneficiaries if there was an existence of a trust.
Sorry, you kind of cut, it's when you put your head down, it's hard.
Oh, okay. Man, no notes today. Okay, so we would have notified beneficiaries of an existence of trust. We would have told our clients file the applicable tax returns. We would have had them pay the administration expenses, which would be standard trustee fees, recording costs to transfer a specific request such as a house, the accountant, and then most importantly, the attorney's fees get paid. And then once that's done, we tell the beneficiaries, this is the net distribution of the trust, and it would wrap up and close. Clearly, that was not done on this file. Basically, the accounting shows that the trustee took the assets, which was the net, and rather than conveying the house out as a specific bequest, she used those funds to maintain the property, and then she proceeded to then put her own money in to maintain the property, all with it operating under the trust. Specifically, we could break it down in the response, but what we're essentially asking for is that the trust is going to be reimbursed, that it's paid out of Janice's pocket personally, along with our attorney's fees. We're requesting that we get the supporting documents to the accounting because no financial statements were provided. I believe Edward Jones, there are a Chase checking account, which is the de facto trust account. That should be, as well as we would like to see all the receipts, and we would like to see the tax returns that were filed. And then I'm just going to go through and make sure I have the rest of the pieces. So I think we're looking at about $91,000. The initial report that the trustees have submitted should be denied. The co-trustees' power should be restricted at this point. I also would go a step further. This was kind of a blank line, but we believe that they should post a bond. And then we would also like for an accounting, because part of this issue that's going on is this isn't just from 2021. They've been acting as Bertram and Bear's agents all the way back since 2011. And so we would like to see an accounting done from the acts that Janice and Joan were taking as their agents, along with the actions that they took as trustee, because it all goes hand in hand. And so we would like to just see how far back this all goes.
Okay. Okay, I'm sure I'll hear from you more, but let me go to you, Ms. Barngrover.
Thank you. As we've fully admitted in our last hearing, this is messy. It's done by somebody who is unsophisticated, who didn't realize the duties here. Yeah, in a perfect world, that's how it would have gone, but that's not how it went. And here we are, and we're trying to make good for it. Mr. Ron, you received the Edward Jones statements via share file link. And I apologize, that's not my client's fault. That was a clerical oversight on behalf of my office, and I apologize profusely. As far as the Chase account, that's a commingled account. There's no right for the beneficiaries to have access to it or see the statements. If Your Honor would like an in-camera review, we're open to that. But as far as just giving out a commingled account, the statements to that, that's just not, they're not entitled to it under the trust provision. They're also not entitled to go back further than Vera's death. They're not entitled to an accounting before her death per the trust provisions. Most of what is in the response is direct contradiction of what is in the trust provisions. They're even going so far as to contest the payment of a caregiver in pursuit of the settler's wishes, which is abjectly contrary and a frankly strange position to take. They're also saying that that my client didn't have a right to use trust assets to clean up the tangible personal property that is a trust asset, regardless of who gets the specific bequest. Also, in their response, they state no authority for their positions and why that my client should be made to reimburse this. Then they want a reimbursement for the help that she received to do it. My client is a 60-some-year-old woman. She is not going to be able to move all those things by herself, and petitioners have never offered to help her. And so if she's working alone in here, she has authority to hire somebody and pay somebody from trust assets. They're also saying that she should be made to pay back basically everything except for the taxes, which were not fully paid from the CPA, My client engaged a CPA, the settler's longtime CPA in Longview, and those taxes were not paid until the beginning of 2023. To say that we could just distribute assets immediately is patently unreasonable. I will note that we agreed on the record to an accounting in pursuit of the statute when we were in court last time. And it was many, many back and forth conversations detailing, trying to get to the spirit of that agreement that was made on the record. So this unreasonableness is frankly burning down the trust. It is not in petitioner's best interest to continue down this road. And if Your Honor would like us to account for more, to give those itemized statements, we are happy to do so. But in the same vein, petitioners requested that this happen in 30 days. Going back that far, and my office trying to put together something and digging down all of these dead ends takes time. And so petitioner's own request to have it done in 30 days, and now they're saying that it's inadequate. We're happy to respond to more. But frankly, I've gotten no communication from petitioner's office. They refiled this response alleging claims that they didn't allege in the petition. Those items are not properly before the court. My understanding is that we are here on whether or not my client should be responsible for their attorney fees. And so to the extent Your Honor wishes to entertain some of those claims, I request a set over so that we can fully brief the matter as opposed to briefing it in 3 days.
Yeah, so let me ask this, what was originally on my docket was the attorney fee matter. I did receive and review the additional filings and replies since that time. So let me talk about that part first. So with regard to the issues of what claims might be had against Ms. Barngrover's client, if there's an offset, I saw in one of the briefs or replies that they're now requesting an offset for compensation for the work they've done. All of these issues, I guess my question is, and if not, I have a plan B, but are the parties open to mediation on these claims before the court making a decision?
Your Honor, we're open to mediation. I have doubts just because of the unreasonableness that's coming from the other side that we can come to a conclusion, but I think that a mediation would be appropriate here.
I'm not sensing necessarily, and I know it's difficult when you're working different sides of a case. I'm not seeing from either side that, people are taking positions that have merit on both sides, if I can get the words right. I think this really could benefit from a third party mediator, but and again, I'm still going to talk about attorney fees because I think that's what we're originally here for. But for these other issues, my options really are, because I don't think that it's ripe for a decision in a 20-minute hearing, would be either sending you to mediation or we set this for a trial in about 3 months.
Your Honor, I guess would be this, and I feel reasonable on this. I think obviously the accounting, and I'm just gonna say this as a sticking point, the accounting to us seems like it's inadequate. And so I think our attorney's fees are warranted to this point. I would argue that those should be approved because we had to bring this to even get what we've gotten so far. So I'll just say for the purpose of the hearing today, I think we should get our fees. Second, I would say that we are open to mediation, provided that the trustee's powers are limited and she needs to post a bond and we get an updated accounting. And we could, we'll wait a couple of months if that's what it takes before. I don't want to go to a mediation without getting this accounting of the financial statements. And I think the argument that the Chase checking account is we're not entitled to that. I mean, one of my favorite things I've always been told by senior counsel when I worked with them on files is, give them everything. We have nothing to hide. And so when we're hearing we're not entitled to this, we're not able to see that, it just creates more questions. And so, you know, they've in their pleadings admitted that this is the de facto checking account. We should be entitled to review that. The Jones account, we do have the statements, they weren't filed with the accounting. And then again, I'd like to see the tax returns, and I would like to see all the receipts for these services that were rendered. And I think that that would be very good. I'd be good with going to see Judge Warning as a mediator on this thing. And I think Judge Warning would appreciate to see those items too in the account.
Yeah, I mean, Ms. Barngrover, probably some amount of discovery needs to occur before this would go to trial or mediation, frankly. So let me put that on pause for a minute. I'll come back to the parties on mediation, which I would probably issue an order allowing some discovery to occur. And I agree. I think there's one aspect to this case of, hey, does the trust document allow for this type of review? That's one question. The other question is, under a TEDRA action, does it allow for review of that information? And that's really where we are. And so where there's been allegations of mismanagement, I think the court does have the power to require that those things be discovered. So that's a little bit different than maybe your client's position that, well, the trust document doesn't allow for it, so they don't get it. I think we're kind of a bit beyond that. So let's come back to discovery and mediation in a minute. Attorney fees, and I didn't see, and I'm triple checking my work here. I didn't see a specific order on the attorney fee issues. What do the parties want to tell me on that?
It's in the proposed, it's paragraph 9.
Oh, on the
Proposed order.
The 5, is it the 520?
Oh golly. I filed it on, 5/20/25.
Oh, there it is. I do see it. Okay, so this is the order disapproving intermediate report and granting other relief. What is Ms. Barngrover? I know there's a lot about probably the intermediate report issue, but as far as the attorney fees requested, what is your client's position?
Well, if your honor is inclined to grant the attorney fees, we'd request that a separate order be submitted that just speaks to the attorney fees.
Yeah, I think what I'm going to do, Mr. Ron, is have you I will approve the attorney fees as proposed. I mean, I understand there's a lot of issues here. I understand it took bringing this action to maybe even get to where we are now. I will approve the attorney fees in a separate standalone order because I'm going to reserve on the other issues pending the next step we take. So what I think the next step should be is a period of discovery and mediation. And if that does not resolve this, then the court can set this for trial.
And in my experience with mediation, your honor, we chose 3, they choose 3, and we pick one that's mutually agreed upon.
That is my practice. I will tell you just recently, I haven't had this happen, but for one time where the parties didn't agree to any. And so they came back and pitched me their proposals and I picked. I guess I'd send you to the drawing board to agree on one first. And if not agreeable, then please note it back on and I can pick.
And also in my experience, the fees are split 50-50, or is this a trust expense?
Mr. Ron, your position.
That should be a trust expense.
Sorry, I couldn't quite hear you.
Trust expense, your honor, sorry.
Okay, Ms. Barngrover, your position on trust expense.
We're fine with the trust expense. I mean, we're fine with the trust expense. It's just gonna lessen any amount due to the beneficiaries, which that's okay.
Well, I think either way, coming from beneficiaries and with the amount at issue that's potentially allegations are misappropriated, I think coming from the trust makes sense.
And as far as restricting my client hasn't hasn't tried to transfer this property. If your honor is inclined to restrict, there's no money to put up a bond for. So I'm not sure what we would bond.
So I think what I'm gonna do on that, when an order is presented to me, what I think I'll do is pending the outcome of mediation and further order of this court, we're just gonna stay any trust actions.
Okay.
Okay, so I think that kind of lessens, so we take away that bond issue. If there is some immediate emergent trust issue that needs to be dealt with, you can note it on with, shortened notice for a hearing, and I can decide. So court involvement, if there's something emergent that needs to happen to or about the trust. And then my thought is I would like to be specific about discovery. I think I try to in these situations, because we are starting with mediation and TEDR actions are supposed to be quick. I try to limit discovery to a number. For instance, I'll throw this out and I'm open to other ideas from the parties, but 10 interrogatories, 10 requests for production. Do parties think that would be sufficient to start with? And if you need more than that, you can come back to court and tell me why you need more.
I think 10's probably gonna be fine. Just trying to think through any of I think 10 should be good.
I also just want to note that my client has never been attorney in fact through a power of attorney at all. I think I said that in the last hearing, but it seems to be continuously brought up, so I wanted to make sure that was known.
Okay. Do you think that you're fine with 10 discovery requests, 10 interrogatories, 10 requests for production, leave of court for additional discovery? And my goal there is adhering to the legislative intent that TEDR actions are a little more swift than other types of cases.
Yes, that's fine, Your Honor.
Yeah.
So with regard to the attorney fee, so Mr. Ron, would you be willing to do a new attorney fee order, but one that also has the discovery language, sending this case to mediation and staying any trust activity until further order of the court?
Yes.
Okay. And if you both sign off on that, you can just submit it ex parte, so you don't have to spend any money coming back on docket.
Okay, thank you.
Okay, anything else we need to do today?
I don't think so, Your Honor.
All right, thank you all. I appreciate your time.
Thank you.
Thank you.
Every day in the USA, people find themselves in court.
$2,025. All under 93 days in jail. Credit 1, the balance is suspended. Thank you.
Thank you, Mr. Bowe. You're all set.
Court calls the case of the People versus Nicole Nelson. Both on.
Good afternoon, Assistant Public Defender Lauren Perry on behalf of Mr. Nelson. He's on Zoom. Mr. Nelson, please state your name for the record.
Nicole Nelson.
Today's meeting has President's Day. We did review the pre-sentence reports and don't have any material changes, additions, or deletions. I will say on behalf of Mr. Nelson, I've been working with him for quite some time. He has completely, I think, changed the majority of his habits since I started working with him. He has completed treatment and did transitional housing. As the court is aware and is reflected in the PSI, he has had some other issues up north. However, while speaking with him, he is dedicated to resolving those and getting everything back on track. He is living on his own now, and has acknowledged his struggles and wants to stay up there as he's leading a different life with different people. So I hope that the court adopts the recommendation, as Mr. Nelson starts this new chapter of his life.
All right. Mr. Nelson, anything you want to say before I go sentence?
Yeah, I just want to say I'm grateful that I was actually able, at that time, it wasn't the best experience, but now that I look back, I'm grateful that some things did happen in my past to get me to where I am now. And I'm just looking forward to growing and building my relationship with God and the community and being of service. So yeah, hopefully that this will keep me somewhat accountable.
And it's good to be alive, isn't it?
Amen. Yeah.
On the case ending in 1352, sentence of the court, 24 months probation term, $555 fines and court costs, $720 probation fees. How are you intending on getting that paid?
That might be a little difficult right now, but
are you working right now or no?
Yeah.
All right. Here's what I'm going to do. I'm going to have you talk to probation. I'll have you on a payment plan that's set up by probation. Okay.
All right. Sounds good.
There's to be no use of alcohol, recreational marijuana, or any illegal substance. You'll be subject to random testing as requested by probation. You're to provide proof of Bear River inpatient treatment program or program completion to probation. Continue and complete outpatient treatment through Bear River with status reports to probation. You're to attend one AANA meeting per week with monthly verification to probation. Maintain employment with proof to probation. Report to probation on June 3rd, 2025 at 2 p.m. That will be a Zoom appointment, and then you'll report as directed. I'll order 365 days of jail, credit 57, the balance is suspended on that case. On your other case, 24 months probation, $555 fines and costs, that will be payment set up by probation. I'll waive the probation oversight fees on that case. There's to be no use of alcohol, recreational marijuana, any illegal substance. You'll be subject to random testing as requested by probation. You are also on this case to provide proof of Bear River inpatient treatment program completion to probation. You're to continue and complete outpatient treatment through Bear River with status reports to probation. There's to be no assaulted, threatening, or intimidating behavior. No possession of any weapons, firearms, ammunition, or anything fashioned to be a weapon. You are to maintain employment with proof to probation. You're to report to probation on June 3rd, 2025 at 2 p.m. That's the Zoom appointment. And then you're to report as directed. I'll order 365 days in jail, credit 57, balance is suspended. Thank you, sir. Good luck to you, young man.
Thank you.
Court calls the case, People versus Cameron Reeves.
Assistant Public Defender Natalie Pate with and on behalf of Mr. Reeves, who should be present via Zoom. Sir, can you please unmute and state your name for the court?
Hello.
Hello, what's your name? 65 days in jail, credit 57, balance is suspended. Thank you, sir. Good luck to you, young man.
Thank you.
Court calls the case, People versus Cameron Reeves.
Assistant Public Defender Natalie Pate with and on behalf of Mr. Reeves, who should be present via Zoom. Sir, can you please unmute and state your name for the court?
Hello.
Hello, what's your name?
Mr. Reeves, can you state your name?
Yeah, can you hear me? I'm sorry.
I can hear you now.
Okay, my name is Cameron Reeves.
I need a camera.
Okay, hold on one second. Trying to get this shit up.
Mr. Reeves, you have to unmute and turn on your camera. Well, I don't know what he's doing now because he's staying muted. I'll pass the matter. Court calls case People versus Jacob Spellings.
Good morning, or good afternoon, Assistant Public Defender Lauren Perry on behalf of Mr. Spellings. Please state your name for the record.
Jacob Spellings.
Today is the date and time set for sentencing. We did.
Defendant having completed all of the terms, his case is dismissed pursuant to the prosecutor's deferred. And yes, and the defendant is discharged from probation with improvement. Thank you. Court recalls case of the People versus Cameron Reeves.
Assistant Public Defender Natalie Pate with and on behalf of Mr. Reeves. Mr. Reeves, can you please unmute and state your name for the court?
Cameron Reeves. Sorry, my camera, I turned it on and hung up. Apologies.
Okay, we've got you. All right.
Thank you, Your Honor. Today is a date and time set for sentencing. I have reviewed the recommendation, which is to re-refer Mr. Reeves for a PSI. He does state that he can make that in-person appointment next Tuesday at 1 p.m. and he does have the
Why didn't
address.
he get to his other one?
2 years ago, we do not recall, Your Honor. It was initially set in 2023. Since then, he has served some time in Wayne County. His recent failure to appear for sentencing last month was due to his incarceration there. Given that we are asking that the court adopt probation's recommendation so that he can make his appointment and will have his pre-sentence investigation completed so that he can come back for sentencing on June 11th.
Defendant is re-referred to probation for pre-sentence investigation and report. He's to pay a $75 referral fee. He's to pay that by this Friday, the 30th.
Okay.
So I'll set a new pre-sentence interview appointment for June 3rd, 2025 at 1 p.m. That is in person. I'll adjourn his sentencing to June 11th, 2025, 9 a.m.
Excuse me, Judge.
you.
Could I say something real quick, sir?
I wouldn't say anything about the case that we discussed, Mr. Reeves.
Oh yeah, it's just about the pre-sentence investigation. It's been it was rescheduled. This case is from some years ago, but it's been rescheduled 3 times since they rescheduled it for me since I was supposed to go. So I didn't actually miss it. They just kept rescheduling and pushing it back.
Well, you missed the one because you were in jail.
Yes, you are correct.
Yeah, that's a miss.
Okay. Yes, sir. All right.
All right. Thank you.
All right, no problem.
Thank you, Mr. Reeves. We'll be in touch.
Yes, ma'am.
I will talk to Mr. Goldstein and that's it for this block, right? And then I'll talk to counsel on Mr. Lee and then I'll come back. Try to fix it up. Court stands in recess. All rise. Yes, you should. Well, I don't know what he's doing now because he's staying muted. I'll pass the matter. Court calls case People versus Jacob Spellings.
Good morning, or good afternoon, Assistant Public Defender Lauren Perry on behalf of Mr. Spellings, please state your name for the record.
Jacob Spellings.
Today's the date and time set for sentencing. We did review the recommendation from probation. On behalf of Mr. Spellings, I also worked with Mr. Spellings for a couple of years now. He too has gotten sober. This is I believe the longest time that he has been sober. He did complete treatment. He hit a couple bumps in the road during his time on probation on his other case, but was always very honest with me, community corrections, and we were able to work through everything to lead him to where he is now. I think he caught both of the cases that he's currently on probation for. In this case happened in a close time period. And like I said, he's made those changes since then. He has been very, very attentive, very respectful. I've really enjoyed working with him. I think the recommendation is appropriate, and ask that you adopt it.
Sir, is there anything you want to say before I impose sentence?
Yeah, just that I think the courts, I'm in a lot better place now than I was, a year ago. And I really think that this time being sober is going to stick. I get my kids back every weekend now. I'm going to get them for weeks at a time in the summer coming up, and I'm just looking forward to how living a sober life is going to be.
The court will know that I'm imposing a fines and cost sentence because he is already on probation to me in another matter. So in this case, it'd be $855 fines and costs, $100 prosecution recovery costs, $100 police agency recovery costs. When do you think you can get that paid?
It can be paid either later today or tomorrow.
All right. Why don't we say pay it by this Friday then, the 30th? Okay.
Okay, sounds good.
Fantastic. Pay that by May 30th, 2025. You're to complete an IOP program, included all recommended aftercare that already has been completed. I will order 93 days in jail, credit for the 3 that you served. The balance is suspended. All right.
Thank you, sir.
Spellings, good luck to you.
Thank you.
All right, take care. Court calls the case of the People versus Jack Lyons.
Assistant Public Defender Natalie Pate for Mr. Lyons, who should be present via Zoom. I do believe he made his final payment, however.
And Teresa Claire on behalf of probation, Your Honor, Mr. Lyons did stop by.
Beginning in July. Okay. All right. Thank you.
Thank you, Your Honor.
Court calls the case People versus Samuel Hamilton.
Assistant Public Defender Lauren Perry on behalf of Mr. Hamilton. Oh, Mr. Hamilton is here. Awesome. Hamilton, please state your name for the record.
Samuel Hamilton.
Yes, we are
Still in the hospital.
a show cause. Yes, as the court may remember, Mr. Hamilton got into a bad car accident and was paralyzed from his neck down. I have been trying to get in touch with Mr. Hamilton about proof of that accident, but we've not been able to make contact. Not sure if I have the wrong number for you, or did you get my email?
Yes, I got your email.
Okay. So
I'm done.
Okay.
He's appeared before me every time in the same place, in the same hospital bed. I get it. I'm gonna waive all fines and costs except for statement. Mr. Hamilton, you take care of yourself.
Thank you. I really appreciate it.
All right. Court does call the case People versus Donald Holloway.
There is no counsel on this one, and I don't have it.
Yeah, my name is Mr. Holloway. Name, sir? Mr. Holloway. Your first name's Mr.?
Donald Holloway.
All right. sir.
How you
Sir, I
doing,
didn't know.
Mr. Simpson? Okay.
Your name it doesn't have counsel.
Simpson?
Good afternoon, sir. Can you state your name for the record, please?
My name is Robert Scott Lee.
Okay. You're here on a show cause. I have you owing $540.
Yes, sir. I won't even try to offer. Well, I just don't. I'm on a fixed income of $1,000 a month, and trying to pay $500 at one time is virtually impossible for me. So I was hoping that I could make some sort of arrangements, payment arrangements.
Okay, how much do you think you can pay each month?
Well, the gentleman that just left, he's paying $20 a month. If I could do that.
Hold up.
No, I'm
no, I'm gonna try to get the same payment plan. Why do you? No, you come.
Well, $20 a month is doable for
funny.
me.
Now, don't be looking behind you, because you know I'm talking about you. The moment you said that.
The moment I said.
The moment you said, well, I want the same payment plan as he had.
Oh,
they started laughing. Yes, you did. Don't shake your head. You know you did.
Okay, I'm sorry. I didn't mean to.
No, you're all right. You're okay.
But yeah, $20 a month would be awesome. That would ensure.
How much do you get each month?
Each month I get approximately $1,045.
Pay $25 a month.
Okay.
Would that work?
Yes, sir. I can live with that.
That's because that's what they said you should pay.
Okay, all
I
right.
would let you have the 20, but the one in the black, she said, give him more money. She was mouthing it up.
I'll deal with you later.
All right.
So 25.
No, the only reason he has 20 is that was set up with our collections department. I usually don't set anything that low, so but I'll give you $25.
Yes, sir. That I appreciate that. Thank you, sir.
Beginning in June. All right, sir.
Okay.
All right.
Thank you.
Take care of yourself.
Just one question. Can those payments be made online? Do you know?
They should be able to, correct?
Yes.
If there's not a warrant on it, you should be able to make it online.
Okay.
All right.
I can probably ask it when on my way out.
Yes.
Okay. Thank you, sir. I appreciate you.
You take care of yourself.
You do the same, sir. Thank you.
Court calls the case, People versus Keith Malone.
Good afternoon, this is the public defender Lauren hearing on behalf of Mr. Malone. Mr. Malone, please state the name for the record.
Keith Daryl Malone.
Thank you.
Warren, we are here for a show cause. I did speak with Mr. Malone regarding this file.
Okay.
All right.
I can probably ask it when on my way out.
Yes.
Okay. Thank you, sir. I appreciate you.
You take care of yourself.
You do the same, sir. Thank you.
Court calls the case, People versus Keith Malone.
Good afternoon, this is the public defender Lauren hearing on behalf of Mr. Malone. Mr. Malone, please state the name for the record.
Keith Daryl Malone.
Thank you.
Warren, we are here for a show cause. I did speak with Mr. Malone regarding this file. It is from living in a nursing home due to some medical issues that he has. Any income that he gets goes directly to the nursing home for his medical care. So he has no income at all. He did, he said that he filed an ability to pay for him with the help of his case managers.
He did.
I
see it.
So given all of that, I think at this point he's unable to pay anything. I'd ask the court to consider waiving everything.
I've already written what I'm gonna do. You wanna keep talking?
No,
Okay. Why are you laughing, Mr. Malone?
I just laughed at you because last night I did a whole probation for you, you know that, and I was just thinking go Tarpons had to say a Tarpon thing. I watch you every day. I happen to see my name come up. I'm watching one of your things, right? My son got the same name. I was like, wow. Then I called it was me. It happened in 2019. I'm like, wow, I ain't have no money left. Since I got another knee surgery coming up, I can walk. I'm still clean and sober. I'm motivated speaker now for drug and alcohol. So I'm doing that, but I don't get no income from that because I'm helping other people stay clean and sober. I think, man, Judge Simpson and Judge Barr had me going through these programs. Now I'm clean and sober 3 years now, due to the court and myself, but mostly myself and my help. And you were a good help to me too. You know, I know that very sure. You know, and
Thank you.
I would just laugh.
Thank you for saying that, sir.
Yeah, you are.
I do appreciate it.
Yeah.
I'm gonna waive all his fines and costs except the state minimums. You're all set, sir. All right. Good luck to you. Take care of
Yeah,
yourself.
thank you, Judge Simpson. Have a good day. Go Tarpons.
All right.
Yeah.
Court calls the case, People versus Lee Parker.
Assistant Public Defender Natalie Pate on behalf of Mr. Parker, who may be present via Zoom. Sir, if you're present, can you please unmute and state your name to the court? Your Honor, I do not have an explanation for Mr. Parker's failure to appear. I did leave a voicemail the number for him. I do understand he still has a balance of 569. For the record, I would respect.
All rise. Readers for the panel session. I will let the
All right, be seated. Derek Allen Makunovich.
Yes, sir.
File number 24T642916. I'm told a victim is coming here today. Is the victim here?
She's in the jury room. Let me get her.
Yes. Do you have a lawyer?
No, I haven't spoken to a lawyer yet. I have a family law lawyer.
Well, I sentenced you August 21 of 24. And then you were supposed to be arraigned another day, and I believe that was the day that you were perhaps had something to drink. I've got a charge here that alleges, and the charge here is disorderly person is what you pled to back in August, June actually. And then I sentenced you on the charge on August 1. Failure to clear all warrants, that you cleared all warrants when originally ordered to do so, but you since allowed a bench warrant to be issued on one case. That's count one. Count two is you failed to refrain from having contact, direct or indirect, with Danielle Lawler. She claims that you've been within 2 miles of her and her residence. Those are the charges. You have 7 violations. If you plead guilty, if you're found guilty, your probation could be revoked. You could be incarcerated for up to 90 days. Do you understand that?
Yes, yes, sir.
And did you sign an advice of rights and read and understand the rights today?
Yes, sir.
If you plead guilty, you'll be giving up all those rights and there will not be a hearing or a trial. Do you understand that?
Yes, sir.
All right, so you have the right to a lawyer. I'll be happy to give you one today at public expense. Would you like a lawyer?
Yes, sir.
Ma'am, your name?
Danielle Lawler.
Okay, so I understand you have somewhere to go, but I'm gonna give him a lawyer. So I will get to this case as soon as he's talked to the defense lawyer, okay? And then we'll get the probation officer in here and we'll go from there, all right? Okay, so sir, go out in the hall, we'll give you a lawyer, and then you're coming back in front of me. Any questions?
No, you're not.
So I am entering a not guilty plea just for the record, and I'll indicate you wanted a lawyer. Good luck. Thanks, Ms. Lawler. John. Turn that down for me. Turn the air down. I want to get it warm. All right. And then we'll set him up. People against nunnery. Crystal, give your name. Oh, they're having tech.
Judge, yeah, he messaged me. He's having difficulty.
Mr. Makunovich, who is your lawyer?
I can't remember his name.
Mr. Crawford, come on up here. Let's call in
Mr. Bailey, join the breakout room.
Jessica O'Donnell. Derek Allen Makunovich, file number 24T642916. Ma'am, Ms. Lawler, you can come up to that microphone. That is a microphone again. Sir, your name?
Derek Allen Makunovich.
Counsel?
Michael Crawford, representative.
We have two charges here. Failure to clear all warrants. They say he cleared, but then he got another charge that he didn't appear on, and he has a warrant outstanding. And two, failure to refrain from having contact with the victim. Ma'am, your name?
Danielle Lawler.
How is he going to proceed on these?
Your Honor, my client will plead guilty to both of the explanation.
Is that right, sir? Is that what you want to do?
Yes, Your Honor.
If you plead guilty here, I want you to understand you have 7 technical violations. Your probation could be revoked. You could be incarcerated on this. Do you understand that?
Yes, Your Honor.
Did you sign the advice of rights?
Yes, Your Honor.
And you could get the maximum. Do you understand that?
Yes, Your Honor.
Did you read and understand the rights?
Yes.
If you plead guilty, you'll be giving up all those rights, and there will not be a hearing or a trial. Do you understand that?
Yes, Your Honor.
Your name is O'Donnell?
On behalf of application.
You understand everything here?
Yes.
You understand if you plead guilty, you're waiving your right to a hearing?
Yes.
Is the count one that you failed to clear all warrants? Again, you did as you were supposed to, but then allowed another one to occur. How do you plead to that?
Guilty.
Did you fail to clear all of your warrants? Well, let me put it to you this way. Did you acquire a warrant after you cleared them and then not clear that one?
Yes, I didn't have the money fully paid. What is paid for? Sir. Yes.
Is the count two that you failed to refrain from having contact with Danielle Lawler, being within 2 miles of her and her residence? How do you plead?
Guilty.
Did you come within 2 miles of her residence?
Yes, Your Honor.
Did you call her?
No.
Did you talk to her?
No.
Did you appear at her doorstep?
No.
Anybody force you to plead guilty?
No.
All right, so I'm gonna accept your plea to count one, failure to clear all warrants, and 2, violation of the no contact, at least the order not to be within 2 miles of her. What happened? Can you tell me, Ms. Warren, or Ms. Lawler?
Yeah, so I was made aware that there would be a play date between my daughter and one of her school friends who lives 3 to 4 blocks away from my house. Play date has happened there before, however, it was not Derek who took her, it was Lori, which was fine.
Who's Lori?
His wife.
Okay.
And there was no incidents that day. The date went fine. He wasn't present. Ellie confirmed that he wasn't present. I found out a few days before this violation occurred that there would be another play date. I assumed it would go just the way it went before, where Lori would be the one taking her there and he would not be present. He did send me a message for that first play date, confirming that he knew he should not be there because of the no contact order. So for the second play date, I assumed it would be the same. However, when I went to pick up Ellie that night at 6 p.m., I did witness them sitting, so we drop off at the Trenton Police Department when she comes back to me. I pulled up to the police station approximately 10 minutes to 6, and they were sitting in the back of
Who's they?
Ellie, Derek, and Dory. In the back of the car with the hatch up, eating ice cream from Custard Corner. And that's something he said that he's been wanting to do, is get Custard Corner. When Ellie got in the car with me, she talked to me about the play date, and I did confirm that Derek was present the entire day at the friend's house. I verified where the friend's house was again with her, just to make sure there was no mistake. He was present for the play date and then stayed in the area to go to Custard Corner until drop off.
All right. So he didn't have any direct contact with you. He took his daughter to a location that's less than 2 miles away. You said did you say a few blocks, right?
Yes.
But he didn't call you, other than that first time, text you to say, hey, I'm going there on a play date, it's a violation of the court's order.
No, he stated that he would not be there because he knew he couldn't
Right.
be that close.
Why are you doing that if you know it's a violation of the court's order?
That was a different location, play date, that I knew. I wasn't aware until we got this play date, how close we are, and I should have left.
Your Honor, oh my, okay. Again, these are two different incidents.
I know.
The one that he said he thought would be a violation, he believed that proximity would have been a violation. The issue with this last one, he was taking his child to a birthday party, my understanding, his wife was driving, they didn't think he was within this area. So he thought it was okay for him to go, so he went, had a birthday party, he left. So again, he understands that technically, upon being aware of the proximity, it is a violation, he wants to take responsibility.
You know how to use Google Maps, right?
My wife, I should have, as soon as we got
So
there.
all you have to do is put in her address where she lives and put in the address where you're going and figure out how far it is.
That's what we did. Now we have a radius bubble, so I know exactly for sure.
And Your Honor, we would like to draw to the court's attention, again, hoping that my client isn't incarcerated, is gainfully employed. Your Honor, I want the court to reconsider how it fashions this particular order, because effectively he can't really parent his child. He can't take his child to school because of that proximity of 2 miles. He can't take her to dance class or any activities. He effectively will have no parenting time. And as you can see, based on both these violations, he's not actually trying to have contact with the victim or anything. He's trying to be a parent, a father to his child. So if there's a way we fashion this moving forward, the court could forgive him and understand his circumstance, it would help him out a lot. And the other violation, Your Honor,
something bothered me here when I sentenced him, I can tell you that. Go ahead, I'm sorry.
The other violation, Your Honor, my client cleared all the warrants as he was supposed to his last order by the court. This additional matter came up. My client submits, and I have personal understanding of this. He was led to believe that he had paid everything off on the ticket down to 36th District Court. Sometimes the court, because of its busyness and its huge administration, can get things a little confusing. There can be a miscommunication, even within his own ranks. He walked out and thought he had paid it, but then he came to be aware there was this small balance he still had to pay. So that popped up new to him after he thought he had cleared everything and was in compliance. As soon as he was aware that, okay, he owed another $100, he went down there and paid it, Your Honor.
Judge, if I could, on that warrant, that 36th District Court warrant, he did clear it on September 19th originally. He was then scheduled for a hearing as a pretrial hearing, like most cases would be. He didn't show for that hearing. That's why the warrant was then reissued. Also, he owes a balance of $290, so it wasn't a small balance that was owed on that. That has since been cleared at this point. He does owe a balance. They've given him till July to pay that balance as of today.
So it's been cleared, Your Honor.
How far do you live, Vic?
I live in Suffolk.
I'm just asking miles, what?
I think 10, 15 miles, I'm not sure exactly.
Who has custody primarily, you? So I want you to understand something. When I put these protections in place, I'm doing it for the benefit of the victim, okay? But the intent behind it is that he not be allowed to call you, text you, drive by your house, be some wise guy like that. It's not that he not be able to bring his daughter to a party that happens to be within 2 miles of your residence, or bring her other places. I want you to understand. And again, you've not been a model probationer. I don't know what's going on with you, Mr. Makunovich. You got 7 violations since August.
That started out very, very bad, but.
So.
We're not gonna get along good if you come back in front of me again. I'm promising you that.
Understood,
I hope you do.
yes.
So I'm just telling you, that's my intent. These are not the biggest violations I've ever seen. So I'm not gonna do it. I'm accepting his pleas. I'm gonna not require any additional costs, even though I could certainly justify that.
Judge, could I just make one comment though, just because when the victim Danielle issued the police report, she said that this incident would happen on April 23rd of 2025. The day after that, April 24th of 2025, Derek emailed me asking for the court's, Judge McNally's order, stated he needed them because he wanted to file a police report against Danielle, the victim on this case, because he believed that she drove past his house, and he believes that she broke that no contact order because he believes she drove past his house. I stated to him that the no contact order is not for him, is for him to not be near her, and again, could he necessarily prove that she drove past his house or not? So again, I do believe that Derek is very aware of the no contact, and he's very aware he's not supposed to be in 2 miles. I know it's difficult being that they share a child, but these are the consequences of Derek's actions.
You know, those are totally different circumstances.
Well,
She came by, she misunderstood what the protective order did, but what he was even alleging was that she came too close to him. What we're talking about is he was trying to parent his child. So
again, I think the timing of it though, the day after the incident happened, I think he was very much aware that he broke the no contact order on that
I
day.
don't think there's any question that based on what I've heard, that he knew he was violating the no contact provision. I mean, maybe not. I'm not gonna go into this. And when I say violated the no contact, he violated the zone within which he could drive. I'm not condoning his conduct. I'm not condoning your conduct at all. You don't get to violate judge's orders. That being said, the intent of the order was not so that you couldn't drive your child or be at your child's play date, so to speak, that's located within 2 miles of the victim's residence. That was never the intent. So I'm gonna go ahead, I'm not gonna impose costs, probation order modified. You're not to have direct or indirect contact with the victim. Requirement that he not be within 2 miles of the victim or residence or place of employment is deleted. Now, I want you to listen to me. Don't start puffing your chest over this one. I'm giving you a break.
Thank you.
I'm telling you, don't go near that lady. If I find out you're driving down the street, and by the way, when you start making comments about what the judge's order should be or not be, or is, I don't tell victims they can't have contact. If she called you on the phone, the fact that you could pick up the phone and talk to her, that's a violation by you, not her. Okay? Stay away from her. Except as I've got in this order. I wrote down here, no contact with Daniel Lauer except in conjunction with circuit court. Can't read my own writing here. I think I wrote circuit court procedure, I don't know. But the point is, you two, you, Mr. Vukunovich, something bothered me here. I mean, something bothered me. So I'm gonna let this go, but don't get to thinking that I'm gonna order her not to have contact with you, and don't get to thinking that don't read any more into this as it is. If there's a violation of no contact provision, you're going to jail. Okay?
Okay.
That's it. Have a nice day. Thank you very much. Good luck. Thank you, Ms. Lawler. I appreciate it. Michelle Rosalie Shock, 25T711721. Detective, your name?
Detective Corporal Sean Chapaniak, Trent Police Department.
Raise your right hand, solemnly swear or affirm under penalties of perjury that the testimony you will give in these proceedings will be the whole true self you got.
I do, Your Honor.
Go ahead.
On Friday, May 23rd, 2025, at approximately 22:25 hours, Corporal Blake Rusnick was monitoring traffic on Fort Street and Harrison Ave in the city of Trenton, County of Wayne, when he observed a gray Ford.
Turn the air down. I want to get it warm. All right. And then we'll set him up. People against nunnery. Crystal Nunnery, 25R706963. Your name, Lieutenant?
Detective Lieutenant Steve Murky, Rockwood Police.
Okay, good morning. I'm gonna need you to start your video. There you go. Raise your right hand. You're here for a citing on record. You solemnly swear affirm under penalties of perjury that the testimony you'll give in these proceedings will be the whole truth, so help you God.
I do, Your Honor.
Okay, go ahead.
Your Honor, on February 22nd of 2025 at approximately 10:41 p.m., Officer Freddie Harshbarger with the Rockwood Police Department, excuse me. Second, please. Sorry about that.
That's okay. I'm not making you nervous, am I?
No, I just swallowed the wrong way.
I'm just kidding. Go ahead.
On duty in fully marked patrol car 13-3. He was running stationary radar on Hero Drive near I-75 within the city of Rockwood when he observed a 2024 black Mercedes-Benz C-Class with Michigan plate of E. Edward H. Henry K. King 0719 going eastbound on Hero Drive that appeared to be going over the posted speed limit of 25 miles per hour. Officer Harshbarger activated his radar and obtained a reading of 45 miles per hour. Officer Harshbarger proceeded after the vehicle. When the vehicle got to the intersection of Hero Drive and 4th Street, the vehicle was in the left lane. The vehicle then made a right turn from the left lane onto southbound 4th Street. As traveling down southbound on 4th Street, the vehicle kept weaving outside of its lane of travel into the northbound lanes of 4th Street. Officer Harshbarger stopped the vehicle, and the driver identified herself with a Michigan driver's license as Crystal Nunnery. Officer Harshbarger was speaking with her, and whilst doing so, he could detect an odor of intoxicants coming from the vehicle. She had slurred speech, watery, bloodshot eyes. Officer Harshbarger asked where she was heading to, and she stated she was heading home. However, she was traveling south on 75 into Monroe County, going away from the city of Detroit where she lives. While Officer Harshbarger was speaking with her, she stated that she is a CPL holder. And Officer Harshbarger asked if she was carrying at that point, and she stated she was, and she had a gun, a Taurus, a G3 with serial number 1, K King A Adam 19259 handgun in her purse with a loaded 8-round 9mm magazine. Officer Harshbarger removed the gun from her purse and later secured it. Officer Harshbarger asked if she was consuming alcohol this evening. She stated she had consumed alcohol, and she also admitted that she's currently consuming alcohol while driving her vehicle. Officer Harshbarger observed a red Solo cup in the center cup holder of the vehicle. Ms. Nunnery stated that she was drinking Grey Goose. Officer Harshbarger asked her to step out of the vehicle to perform some field sobriety evaluations. While outside the vehicle, she was unsteady on her feet, and Officer Harshbarger could detect an odor of intoxicants about her breath and person. Officer Harshbarger had her perform the field sobriety evaluations, the horizontal gaze nystagmus, one-legged stand, walk and turn, and she failed all 3 of those tests. Officer Harshbarger advised Ms. Nunnery of her PBT rights, and she refused to take the test. Ms. Nunnery was taken into custody and transported to Gibraltar Police Department. While at the Gibraltar Police Department, Officer Harshbarger advised Ms. Nunnery of her chemical test rates verbatim from the DI 177. She stated she would take the test. The results of the first test of 0.232% BAC. After taking that test, Ms. Nunnery immediately ran into the jail cell and started drinking water. So at that point, Officer Harshbarger stopped the breathalyzer, filled out a affidavit for search warrant and a search warrant for Ms. Nunnery's blood. Officer Harshbarger contacted the Honorable Judge Jennifer Coleman Hessen with 33rd District Court. Judge Hessen authorized and signed the search warrant. Ms. Nunnery was transported to Corwell, Trenton, where Molly Johnson, RN, drew 2 vials of blood from Ms. Nunnery's left arm. The blood was sealed in the Michigan State Police specimen kit. On 2/24/25, I mailed the Michigan State Police specimen kit to the Michigan State Police Crime Lab in Lansing. On 3/10/25, I received a laboratory report from forensic scientist Rachel Perez stating the results of Crystal Nunnery's blood is 0.209 grams of alcohol per 100 milliliters of blood. During the investigation, Your Honor, Officer Harshbarger checked through lean with Miss Nunnery, did not have a CPL in it at the time. Her CPL expired on 11/8/22, and that the gun was checked through lean also, and there was no record of the gun unregistered in the state of Michigan. I submitted a warrant to Wayne County Prosecutor's Office. You have a charging document in front of you.
Based on your sworn testimony, I find the crimes of CCW, super drunk, and OWI were committed. There's probable cause to believe the crimes were committed by the defendant. I'm going to authorize the issuance of the complaint warrant. I'll note you sign the complaint. The court is signing and dating the complaint and the warrant for the arrest of the defendant. Have a great day. Thank you.
Appreciate it.
Jeffrey David Inch, 23R513309A.
Jeffrey Inch.
All right, so you're charged with failure to attend your biweekly substance abuse disorder group at the Guidance Center between May 4th and 10th. Count 2, failure to submit to twice weekly chemical testing on May 24th. You have 3 prior technical violations. That means your probation could be revoked and you could be incarcerated on this case for up to 93 days in jail. Do you understand that?
Yes.
And did you sign, read, and understand the advice of rights?
Yes.
If you plead guilty, you'll be giving up all those rights. And there complaint warrant, I'll note you sign the complaint. The court is signing and dating the complaint and the warrant for the arrest of the defendant. Have a great day. Thank you.
Appreciate it.
Jeffrey David Inch, 23R513309A.
Jeffrey Inch.
All right, so you're charged with failure to attend your biweekly substance abuse disorder group at the Guidance Center between May 4th and 10th. Count 2, failure to submit to twice weekly chemical testing on May 24th. You have 3 prior technical violations. That means your probation could be revoked and you could be incarcerated on this case for up to 93 days in jail. Do you understand that?
Yes.
And did you sign, read, and understand the advice of rights?
Yes.
If you plead guilty, you'll be giving up all those rights, and there will not be a hearing or a trial. Do you understand that? You have the right to a lawyer. I'll be happy to provide you with one at public expense. Would you like one?
Yes, sir.
I'm entering a not guilty plea. We're going to have a revocation hearing today. I'm going to give you a lawyer. I'm going to enter a not guilty plea, as I said. You'll go speak with the lawyer, and then you'll come back in here and speak with me. Do you have any questions for me? Okay, as soon as you speak with the lawyer, I'll get you out of here. Thank you. People against Sharp. Faraz Cartez Sharp, 24G700688. Jeez. Good morning, sir. Your name? Which one do you have?
Mr. Inch, Jeff.
Have a seat right there, if you would, ma'am, at the table. We have Jeffrey Inch down there. Jeffrey Inch. Jeffrey David Inch, 23R513309A.
Good morning, Judge. Nice to hear the term back.
Mr. Inch, your name?
Jeffrey Inch.
Call in, Beth. So what are we doing here? I arraigned him. I entered a not guilty plea. He has 2 counts. How's he going to proceed?
Judge, we'll plead guilty to count 2 and not guilty to count 1. I apologize. Guilty to count 1, not guilty to count 2.
All right. So if you plead the failure to attend your biweekly substance abuse disorder group during the week of May 4th through 10th, I'll just consider that one violation. Do you understand that?
Yes, sir.
Did you sign and read and understand the advice of rights?
Yes, sir.
If you plead guilty, you'll be giving up all those rights and there will be no hearing or trial. Do you understand that?
Yes, sir.
My information is that this would be a 4th technical violation. Your probation could be revoked. You could be incarcerated for up to 93 days. Do you understand that?
Yes, sir.
All right. You understand all your rights?
Yes, sir.
Do you have any questions on your rights?
No, sir.
to the charge you failed to attend your biweekly substance abuse disorder group at the Guidance Center on the week of May 4th through 10th. How do you plead?
Guilty.
Did you fail to attend your biweekly substance abuse disorder group between May the 4th and the 10th?
Yes, sir, yeah.
Anybody force you to plead guilty?
No.
I'm gonna accept that plea. Did somebody call Beth?
Beth is finishing up with the defendant at the window. She'll be ready.
Why don't you have a seat? I'm gonna have to take the other file first, okay?
Judge, I find Emerson, Miss Foley Carter and myself would like that sidebar with you.
Okay,
Yeah, on that.
I will do that momentarily, okay? Where is Mr. Crawford again? Good, thanks. Sarah Renee Diaz, 25W837-198. Your name, ma'am?
Sarah Renee Diaz.
We're gonna wait for your lawyer. Yeah, they'll give you a copy. Lisa, give counsel a copy on that, Lucky, the probation violation hearing. Thanks.
John's on his way back because you need to sign the commitment.
Okay. Good luck, ma'am. Wish you well. Thank you. Jeffrey David Inch, 23R513309A. All right, Mr. Gaith, your name?
Good morning, Judge Madison Gaith, up here on behalf of Mr. Inch.
Sir?
Jeffrey Inch.
So he was going to plead, or did he plead?
He pled to
Count one.
Count one, Judge.
So, but then I didn't want to accept the plea until I had you in here. Your name?
Elizabeth Weiss-Patient, Your Honor.
What's going on with count one, or count two rather, failure to submit to twice weekly chemical testing on May 24th? I'm asking you, Ms. Wilds, do you want to?
I apologize, Your Honor. Mr. Inch appeared for testing on the 24th. His first sample was dilute. His second sample was dilute. Because he arrived so close to when they close, he arrived at 9:20. Testing stops at 9:30. Within that span, they did allow him 2 attempts to provide a sample, so there was no time for a third sample. It was a weekend. There is no PM testing, but what all sobriety court defendants are aware of, and I instructed Mr. Inch on this prior, is that if you don't show for testing in the morning or provide a sample that is testable, what Mr. Inch didn't do is he didn't go to the alternative site that evening. On Sunday, he didn't go to the alternative site a morning or evening. He did not test on Monday. He did not test on Tuesday.
All right, so unless there's gonna be a plea here, I'm just gonna swear in and listen to her testimony and listen to whatever you have to say, Mr. Gay. And I'll make a ruling on count 2.
Yeah, I guess let's.
Raise your right hand. You solemnly swear affirm under penalties of perjury that the testimony you will give in these proceedings will be the whole true self you got.
I do, Your Honor.
Go ahead.
Would you like me to repeat, Your Honor?
Yes, please.
Yep. Mr. Inch did show for chemical testing May 24th. His first test and his second test were both dilute. Due to him arriving so close to their end time of 9:30, he arrived at 9:20 a.m. There wasn't time for Mr. Inch to stay for a third sample. It is the weekend. DNA does not offer evening hours, but as instructed in the sobriety court handbook, as well as additional paperwork that Mr. Inch has received, is that if you do not provide a good testable sample, you have to arrive to the alternative site. What Mr. Inch didn't do was follow through with those instructions as well. He did not show that evening, which was a Saturday, at our alternative site. He could have went on Sunday, the next day, again, did not go to the alternative site. He could have appeared back at DNA on Monday or Tuesday, although his color of yellow was not called, colors were called and they were open, and he did not go. His color was called today. It does not appear yet this morning, but again, he does have an opportunity to go this evening between 5 p.m. and 7 p.m. I did not receive any communication from Mr. Inch. I was out of the office last week. Monday was a holiday, but Mr. Inch did not reach out to the probation department in regards to this issue.
Any questions of her, Mr. Gaith?
No questions, Judge.
Does your client wish to testify or remain silent?
Judge, at this point, I'm gonna have him remain silent. I'd like to, with regard to what Ms. Wild said, Judge, my client, according to what he's told me this morning, did not even know that he had a violation until this morning with regard to that test. Now, he told me that he did go to the testing, and the only issue that came up was it came up dilute.
Well, dilute isn't good. They know they're not supposed to drink 14 gallons of water.
Understood, Judge. But in Mr. Inch's defense here, Mr. Inch, he's got other violations, and he's always been truthful with the court with regard to the other violations. Even when they showed up negative through the lab testing, he still admitted when he did something wrong. He admitted he took responsibility for it. Judge, at this point, I mean, I would believe that he's got no reason to deviate from what he's done.
What did I do when he admitted that he had it in the probation, the confirmation test came back negative? Do you remember? Did he tell you what I did?
Well, Judge, you found him, you gave him credit for being honest with the court.
And I dismissed the show cause, right?
Correct.
So even though he admitted something that I felt like clearly established his guilt, there's no question about it. But because he was honest and because we preach honesty in the program, I felt it was inappropriate to penalize somebody who we told you have to be honest to and was honest. And the confirmation test, as it turns out, came back negative. That's why I went ahead and dismissed it. But this one, this is kind of like, how do I say this? I don't want to get too melodramatic here, but what you've had here, it's all lines up. He didn't show up, essentially, because he diluted his test. That's what he'd done. He had 2 dilute tests. He could have gone to another site. He didn't do that, even though they're told to. He went to another, he could have gone to another site the next day. He didn't want to go because he diluted the sample for a reason. And then the following day, he still didn't go. And I've been watching Jeffrey here. I like the kid. I like him.
Judge, he's close to graduating. I mean,
I don't care. I don't care. I don't care. I'm finding you guilty as charged.
Oh, can I speak on this?
No, you can't speak unless you want to testify.
I want to speak on this.
Do you want to testify?
I would like to make clear that I was not fully aware that it was, I knew the first test was dilute. The second one, she said, okay, Mr. Inch, are good. I didn't know that meant it was still dilute. I did not know. I would have gone the second day. I've done that before, prior, a year ago when I diluted. I've been honest this whole time, like you just said.
I don't want to hear it.
I'm just telling you, if I made a mistake, I would tell you. I'm dumb. I had too much going on at home.
Why were you dilute? Let's talk about why you dilute.
I work a physically active job.
No. What do you tell those guys with regard to how much water they can consume?
No more than 12 ounces.
Now, it's not been 107 degrees with high humidity so far.
It's not, but I've been
So if we're going to have dilute samples every time it's 58 degrees out, and that's about what it was last week, or 60, we're going to have a big problem. You'll never have a valid test because they'll all be dilute because it's going to get hotter before it gets colder. Look, I warned you. I warned you with all of this. I warned you. You had to know you were on thin ice with me. You were doing so great, and now all of a sudden you're falling. Doesn't do any good to graduate if you're not going to keep up the program. And I mean, just stay sober. It doesn't do any good. I mean, this whole thing about completing programs, what does that have to do? It's like the guy who goes to Harvard, gets a degree, and ends up salting fries at the local fast food restaurant. I mean, it's the same concept. It does not do you any good to graduate from a sobriety court if you're still using. Now, you know what the rules are. You know what the rules are. I want you to get that lady on the phone, but I'm going to give you the benefit of the doubt in the sense that I'm getting that person on the phone on another court date here, Beth. Whoever was tending to Mr. Inch on that day, I want him on Zoom. And I'll tell you what, I'll give you the benefit of the doubt. I'll continue the hearing. But you're either going to testify or you're going to remain silent. You can't have the best of both worlds. You can't say, I'm going to remain silent and then say, wait a second, I want to talk. You want to talk? I'm going to swear you to an oath. Do you want me to swear you to an oath?
I guess I'll just remain silent, Your Honor. I would like to graduate this program.
Hang on.
No, Mr. Inch, just answer the judge's question. Either do you want to testify?
Not talking.
Well, you can't have the best of both worlds.
Judge, are you?
You don't, wait a minute. I want to make sure Mr. Inch understands this. You have the right to remain silent. There's nothing wrong with you remaining silent. But you can't remain silent and then start telling me your story and expect me to take it into consideration when you're not under oath.
Just don't know what to do. No, I want to complete this program.
I don't care.
I understand.
Jeff, I want you to listen to me. I'll give you more time to confer with your lawyer. We'll get the woman in here on Zoom. We'll continue the hearing date next week. I'll give you every opportunity to question her, have your lawyer question her as to whether or not she conveyed to you that the test was fine and you were free to go. We're gonna get her in here. When is a good day when Mr. Gates here, Lisa?
I have to check his schedule because you're off a few days next week.
It's funny because even before people violate, I kind of, and I don't mean this, I've just seen this with you, Jeff. The guy I was so proud of, and now you're just screwing around. You act like this is a option to violate probation when you feel like now. Listen.
Can we do June 9th in the afternoon? He's here at 1 p.m.
What day of the week is that?
It's a Monday.
Yeah. Is that good with you, Mr. Gaith? You're here?
Yeah, I'm here anyways, Judge.
June 9th at 1 p.m. So I want you to get them. We'll continue the hearing. Okay? That's it. We'll see you next week, Jeff. And I don't know what I'm going to do now, but I'm really disappointed in you if my mind doesn't change. Good luck. Stephen Charles Bailey, 25W838-436, A and B and C. Carmen, your name?
Good morning, Your Honor. Michael A. Carmen, P73824. On behalf of the defendant.
Mr. Bailey, your name?
Judge, he was on Zoom, but I do not see him.
I know. He's going to just have to come here in person or something. I don't know what to tell him. He's the one this happened with last week. We'll call him. I don't know whether I want to start off with Mr. Blisman or not. Thomas Robert Blisman, 25W706462 FD.
Good morning, Your Honor. Mr. Shank, can we get my client approaches?
So this is not going to be an easy one. Your name, sir?
Thomas Blisman.
All right, so he's done well on the bond phase. I took his plea to OWI 2 and to drive while suspend 1. And that was on April the 22nd. So I want to read the plea agreement into the record again, if I can, if you'll give me a minute. And everybody sign this, and here's what it says. Defendant will enter pleas to OWI 2nd and an added count of driving on a suspended. Sentence recommendation of 60 to 90 days jail is determined by the judge with work release if eligible and available. This jail condition may be waived at the discretion of the court if the defendant completes a specialty court program pursuant to statute. The OWI 3 charges will be dismissed at sentencing, provided the terms of the agreement are satisfied. A sentence of agreement of 2 years probation with sobriety, drug veterans, or mental health court that the defendant will need to find placement on or before sentencing. No early termination of the probation. Any SCAO approved sobriety or specialty court will be acceptable. The 33rd District Court has an acceptable program. That's nice of them to tell me that. In addition, all the terms set by the court, costs of prosecution of a minimum of $500 or more is determined in alcohol, drug screening, treatment, full restitution for any out-of-pocket costs for damages or harm incurred because of the offense on or before sentencing, if applicable. So I want to make sure, do we have the vehicle owner here that should have been notified? If you just give me 1 second here. We did send a letter to Gary Ennis Jr. on April the 22nd and also to Jason Glenn. This was a parked car, right? Is this not a parked car, or am I confusing this one? I'm just asking you. Can you tell me, Mr. Shemke?
Car was parked, I believe.
Yeah, I'm just curious as to why they notified 2 separate owners. Let me just double check something. Yeah, Unit 2, that's you. Was traveling northbound. I'm sorry, Unit 1 struck, that's you. Unit 3, which was parked on the street. I don't know why they, at any rate, I don't need to deal with that. I'm concerned. He's got 3 priors. Granted, none of them have happened in the last 24 years. I'll give him that, 25 years, but still it's a 4th offense. I'll listen to anything you have to say, and we'll go from there.
Yes, Your Honor, in the circumstance, I'd like to reflect that he has done extremely well on bond. He has a strong family support system. He has remained gainfully employed. Judge, he had used poor judgment. He was trying to assist a friend, and he found himself in this predicament. But I will say, as far as the client goes, any instructions that I give him, he's always been able to follow without any sort of issue. He's already been in treatment. Any sort of request or order that's been put in place by the court, my client has not hesitated to comply with 100% accuracy. It's because of that, Judge, and how well he's done on bond and the strides he's made and with his life in the past few years, besides having this notation, I'd ask for jail to be waived at this time, obviously to be considered if there were to be a violation, but he's very eager to demonstrate full compliance with the sobriety court. He appears timely, very respectful, and I think that he's going to demonstrate an outstanding effort in the program, Your Honor.
Anything you'd like to say?
Yes, I just, I know I made a bad mistake, bad judgment, but looking forward, I want to just, get this behind me, and I'll do whatever I have to do to make things right.
I don't know if I've ever had a 4th offender that I didn't send to jail, to be honest with you. I'm a drunk driver. I can't think of one. It's possible, but I don't know that I have. 2 years probation. You cannot leave the state without the consent of the court or violate any law or ordinance. If you change your address, place of employment, or home telephone number, you must notify probation. You have to report as directed. No alcohol, no illegal drugs, no marijuana. You're not to purchase, possess, or consume those. You're not to go to any place where alcohol is sold or dispensed. You're to submit to chemical testing, PBTs and ETGs when probation tells you to, when you know how often you have to test. You're to submit the PBTs, ETGs, and chemical testing on demand of probation. Like I said, you're to complete 60 days more on the SoberLink device from this date. But we will get that turned around. It'll be now covered by our grant. You're to attend 12-step meetings 3 times per week and provide written proof of attendance. You're to obtain an AANA 12-step sponsor. You're to attend all substance abuse treatment at an approved facility and provide written proof. You're to attend the Victims Impact Panel. You're to attend and complete the Armed Specialty Program. You're to report to sobriety court status review hearings with me every 2 weeks. You're to obtain and maintain employment and provide us with proof. Now, I'm going to talk about the fines. There was an agreement of $500, so I'm going to honor that. 200 fines, 500 costs, 75 victims' rights fee, $50 justice assessment, 8 1/4. Screening fee is 60 for 885. Probation fees are $480, bringing the total to $1365. Sobriety court probation fees, sobriety court fees are $360, bringing your total to $1,725. I'm coming back to that. You do have to pay, and I feel badly about this, but there's only so much I can do. Cost of recovery on this case is $150. So your total's $1,875. Now, I don't know what to do with you, Mr. Blisman. I don't usually come out here and say that. I don't. I mean, there's times I don't know exactly which direction I want to go, but just give me a minute, please. All right. I'm gonna do this one a little different. I'm gonna give you 200 fines, cost 500, that's per the agreement. $75 victims' rights fee, $50 justice assessment fee. $60 screening fee, $480 in probation fees, $360 in sobriety court fees. There's cost of recovery of $150. I'm gonna order that you serve 90 days jail, and that will be deferred. You're gonna serve I'm giving you credit for 1 day served. You're to serve 6 days on the court work program and pay $210 for that. That's your first 6 plus the 1 day credit. You're gonna complete 4 days of community service. I'm gonna give you all the way until September 1st to complete that. That's 32 hours. We're gonna have review hearing dates. And by the way, your total now fines and costs, including the court work program fees, you know, with the $500 minimum cost, I don't know why they're putting that in there, but I'm gonna honor it. It's $2,085, and I feel terrible about that, but I can't really do any better. I mean, these are all fees that are associated with the program. So it's 11 days jail now. Credit 1, serve 6 on the court work, 4 days community service. I'm giving you until September 1 to complete your community service. 79 days are deferred. You're to appear for a review hearing date. Lisa, I want you to give him a review hearing date every 4 months for me to determine if the defendant should have to serve the jail then. And here's the bottom line. You do everything, you cross all your T's, you dot all your I's. I'm not gonna end up sending you to jail on this, and that's significant. I know that the other ones are old, but you still have 4 of these. Now, the last one was 20 years ago or so, whatever I said, but I'm gonna do that. But I mean, I'm giving you credit. You're doing well so far. I'm glad to see that they're not hamstringing me on these probation sobriety court cases. They're, you know, some could criticize. That's okay. But if you violate 365, and I'm telling you, I will give you the 365 days if you don't make it through the program. But I hope your goal here is not to make it through the program, it's to gain lifelong sobriety. Restitution, if any, will be handled through civil litigation. None of the names I mentioned are here, correct, Lisa?
I have a Motorola that just popped in that I can't identify.
Well, let's bring them in and or her in, whoever it is, and I'll ask them. How's that? So I'm gonna do this for you, Mr. Plisman. Not that you don't deserve it, but it has been a long time, and we do make mistakes, and you've shown that you're, to me at least, that you're accepting responsibility, you're remorseful, you've done what we've asked you to do. So I'm gonna be more reasonable here. More reasonable to the extent I should be. Let's put it that way. Motorola, can you tell us your name, please? You have to show up with your name on there, please. What's your name? Motorola Moto G Power 55G 2023. What's your name? Start your video and tell me your name, please. Motorola G. If you better call, I don't know your name, sir, and you have to use, or ma'am, what's your name?
Judge, that's Stephen Bailey.
Okay, good.
Yeah, we're good.
So that's what we're doing. Can you pay all this today, or do you need time? How much do you have today? Okay.
Judge, I think there's a count 2 also.
Yeah, I know. I got to go on to that. You pay $1,000 on this. And then the balance, I'm just going to let you pay at the rate of $100 bi-weekly. Can you do that?
Yes, sure.
Pay that $100 bi-weekly. We'll start that. I'll give you some little bit of leeway time. 6/13/20. Is the 27th a Friday, right, Lisa? Of June?
Yes.
Okay, so that's what we'll do on that one. I don't really have a register. Give me the other file. I'm gonna go light on, or I just need another page of a register for count 2, like a first page. I'm just gonna fine you on that. I'll go light. 50 fines, 50 costs, 75 victim's rights fee, $50 justice assessment, 2 1/4. All right, so make sure you take care of whatever it is and they can offer whatever they want then and everybody will be happy, okay? Last adjournment. Good luck. Go down the hall, get your notice. Thank you. Lindsay. Lindsay Nicole Miller, 24FWA38652A, B, and C. Mr. Bulahanis, your name? Where is he? Do you know?
Judge, I don't know what happened. For some reason, he went to the breakout room. I'll try to move him.
Okay, I'm gonna go on to another one real.
Oh, there he is. There he is.
All right. Your appearance, Mr. Bulahanis, we lost you there. Your name?
Good morning, Your Honor. Greg Bulahanis, P36431, on behalf of Lindsay Miller.
Ms. Miller, your name, ma'am?
Lindsay Miller.
All right, so this says she's going to plead guilty, as I understand it, to operating while impaired. The super drunk will be dismissed. She's also going to plead responsible to no proof of insurance. And then they're going to go ahead and dismiss the open intox. Am I reading this right?
Yes, Your Honor.
And for purposes of arraignment, before we get to that, does she stand mute?
Yes, waive the reading, stand mute. We'd ask the court to enter a not guilty plea.
You understand everything your lawyers just said?
Yes, sir.
Okay, you seem very soft spoken. Can you get up closer to that somehow or turn that up, or she's got to yell or something? I don't know.
I got it. I just fixed it, Your Honor.
All right, ma'am, your name again?
Lindsay Miller.
So listen carefully. If you plead guilty to operating while impaired and you plead responsible to no proof of insurance, I'm going to go ahead and dismiss on motion of the prosecutor the operating while intoxicated and the open intox. And it says that you have insurance and it was verified by your lawyer. You understand that?
Yes, sir.
Wait a minute, I got to get you better than that. You got to talk a lot louder. This young lady in front of me is trying to take down everything we have, so yell at me, okay?
Yell at him.
Yes, sir.
All right. Did she have insurance in effect on the date of the offense, or did she just acquire it after?
She acquired it afterwards, but she did have insurance, but was storage insurance only. And what happened is there was some confusion in converting it to the full insurance. Here's a certificate of insurance, full insurance, May 5th, and it occurred on May 3rd. But they had insurance on the day too, but it wasn't.
Well, they had storage. I have storage. That doesn't do you any good. You can't drive.
I know. I explained everything to them, Your Honor.
Ma'am, if you plead guilty to operating while impaired, the possible penalties are up to 300 fines, 93 days jail, 360 hours community service. Court costs are all 4 points, license suspension or revocation in accordance with your record. And your vehicle could be or might have to be immobilized depending upon your record. You understand that?
Yes, sir.
You are presumed innocent. They have to prove you guilty beyond a reasonable doubt. You have the right to remain silent. You have the right to a trial by court or jury. You have the right to question their witnesses, to bring in your own, to use the subpoena powers of the court to bring in those witnesses. If you plead guilty, you're giving up all those rights, and we are not going to have a trial of any kind. Do you understand that?
Sir.
You got to go louder.
Yes, sir.
And you're waiving the presumption of innocence and waiving the requirement that they prove you guilty beyond a reasonable doubt. Do you understand that?
Yes, sir.
All right. To the charge operating while impaired, how do you plead?
Guilty.
To the charge, no proof of insurance, responsible or not responsible?
Responsible.
Were you operating a motor vehicle on May 3 of 25 at 12 o'clock in the morning on Ford Lane near West Road in the city of Woodhaven, County of Wayne?
Yes, sir.
Prior to that, did you drink alcohol? And if so, what did you drink and how much?
Yes, sir. I had about 6 or 7 mixed drinks.
What kind of mixed drinks?
It was vodka and lemonade, sir.
All right. Was your ability to operate the motor vehicle impaired due to the consumption of the alcohol? And if so, in what way?
Yes, sir. I was swerving and couldn't maintain my lane.
Do you think that you were swerving and couldn't maintain your lane, at least in part because of the alcohol consumption?
Yes, sir.
And you took a breathalyzer or a blood test?
Breathalyzer, Your Honor.
And were the results 0.223, and you so stipulate that was an accurate reading for purposes of the plea?
Yeah, 0.215 and 0.223, Your Honor.
Are you on probation or parole right now, ma'am?
No, sir.
Anybody force you to plead guilty?
No, sir.
I'm going to accept your plea to operating while impaired. I find it to be an accurate plea. I'm going to go ahead and dismiss the super drunk, and to the charge, no proof of insurance, responsible or not responsible.
Responsible.
All right, I'm going to accept that plea as well. So I'm accepting the plea to impaired, accepting the plea to no proof of insurance, dismissing the super drunk, dismissing file 52B, the open intox. I'm going to refer you for a screening and assessment. You're going to be screened today. You'll be sentenced at a later time. She has nothing on her record, right?
Right. Yes, Your Honor.
How old is she? She's 31?
32?
31.
31.
Give me a bond sheet, will you? All right, that's really high. That kind of concerns me here, okay? So here's what I'm going to do. I'll give you a personal bond of $1,000. You cannot leave the state without the consent of the court. You cannot violate any law or ordinance. You must appear in court as directed. No alcohol, no marijuana, no illegal drugs. And I want you to go into NA at least two. Yeah, I'll make it twice. I'll make it twice.
She has been attending AA, Your Honor, since the incident. She's been doing it virtually, but I indicated to her that you prefer in person, and she will do in person from here on out.
Good enough. So that'll be in person, no alcohol, no marijuana, no illegal drugs. You cannot leave the state without consent. You can't violate a law. You must appear in court as directed. $1,000 personal bond. I'm going to defer the sentencing on the no insurance. So I'll sentence her the same time on that one. We'll set a sentencing date on both of these at the same time. So Lisa, why don't you give me a date? And,
June 11th at 8:30.
Hold on one second. On June 11th?
So that June 11th, I'm here, right? All day? Yeah. I mean, that's a Wednesday.
Hold on one second. I have,
If you need another day, it's not a problem.
yeah, I'm just trying to, it's just my, for some reason, my, damn calendar isn't. Look, I can probably do it. Can we do it at a little bit later time? Your Honor?
You know what? I just want to start on these sentencings in the morning. How about the 18th, please? So we good that day, or is that, I'm not going to need, there was no,
Your Honor, the 18th is way worse for me. I can do the 11th.
Let's do a Monday. Let's do a Monday, Lisa. Do you got a Monday for me? He's retained.
Can we do a Tuesday? That's your probation day. So the 10th or the 24th?
Yeah, that's fine. We'll do the 10th. How's the 10th?
The 10th is, I can do it at, how about 9:30?
Are you gonna be here at 9:30?
I'm gonna probably be here at 9:15, Your Honor, but.
Good enough. June 10th, 9:30. No problem. And then I'll sentence her on both. So ma'am, you have to come up here today to get screened and assessed, okay? So you're gonna come up here today and fill out a questionnaire and be interviewed. And we'll see you back here for sentencing. Any questions at all? And you have an AA verification sheet to give her, right?
Yeah, I do have an AA verification sheet that I can give her for in-person attendance, Your Honor.
Good enough. Thank you very much. Good luck, man. We'll see you back here. Is he here on the Sunday?
Thank you, Your Honor.
Thank you very much. You have a good day.
You too.
Let me take a Shock. Michelle Rosalie Shock, 25T711721. Ms. Shock, or Detective Shapaniak, rather, your name, sir? Detective, your name? For her not to have contact with you, and don't get to thinking that don't read any more into this as it is. If there's a violation of no contact provision, you're going to jail. Okay?
Okay.
That's it. Have a nice day. Thank you very much. Good luck. Thank you, Ms. Lawler. I appreciate it. Michelle Rosalie Shock, 25T711721. Detective, your name?
Detective Corporal Sean Chapaniak, Trent Police Department.
Raise your right hand, solemnly swear or affirm under penalties of perjury that the testimony you will give in these proceedings will be the whole true self you got.
I do, Your Honor.
Go ahead.
On Friday, May 23rd, 2025, at approximately 22:25 hours, Corporal Blake Rusnick was monitoring traffic on Fort Street and Harrison Ave in the city of Trenton, County of Wayne, when he observed a gray Ford Escape bearing Michigan registration plates Edward William David 5467 in the right travel lane going approximately 35 miles an hour, failing to maintain their name. The vehicle proceeded west on Belmont Road, then north on Medford Road, when he observed the center brake late light to be inoperable. Corporal Rusnick made a traffic stop on Medford Road, just north of Belmont Road, where he made contact with the white female driver, identified by her Michigan identification card as Michelle Rosalie Shock, 76 of 94. Shock was advised for the reason of the stop and ran through lien/SOS and came back suspended with 3 prior convictions. Shock was removed from the vehicle and pursuant to department policy, an inventory search of the vehicle was conducted by Corporal Rusnick, where he located a teal hip-hop box in Shock's backpack. Corporal Rusnick inquired about the contents in the container, and Shock stated that inside was her methadone. There is a small slit in the top of the box, and Corporal Rusnick could observe chorboy and folded tinfoil believed to be narcotics. Shock advised there was heroin inside the teal box. Upon opening the teal box, Corporal Rusnick located a few folded up bundles of tinfoil believed to be narcotics, which were later confirmed to be fentanyl. Also located was a silver brass knuckle folding knife in the side pouch of Shock's backpack. Shock was advised she was under arrest and asked if she had any more contraband on her person. Shock voluntarily retrieved 2 used hypodermic needles, 1 crack pipe, and a large cellophane baggie, which contained several 1x1 bags of a white rock-like substance and several tinfoil bundles of a white powdery substance. The evidence was collected, and Shock was transported to the Trent Police Station by Patrolman Jonathan Lippa and Patrol Car 1109, where she was booked and housed. Corporal Rusnick field tested the white rock-like substance in the clear 1x1 baggies using the Dectachem mobile test kit and received a positive confirmation for crack cocaine. Corporal Rusnick also field tested the white powdery substance in the tinfoil bundles using the same mobile test tech. Positive confirmation for fentanyl. The total combined weight was approximately 14 grams. In total, 12 bags of crack cocaine and 24 bundles of fentanyl were collected.
Hang on a second. Lisa, where am I hearing that feedback from? Is there, do you know?
That's from Trenton, I believe.
All right, ask him to just, go ahead, Detective.
Hold on 1 second.
Go ahead, Your Honor.
What's that?
Go ahead, Your Honor.
So his thing is he doesn't.
Who's talking back there?
My partner's on the phone with another person. He's trying to get her off the line right now. We had a call come upstairs.
Was the defendant's license suspended or revoked?
Yes, Your Honor.
Did the defendant have a prior conviction building with intent January 4/19?
Yes, Your Honor.
I just want to make sure. So we got in the metallic knuckles, the defendant had possession, correct?
Correct, Your Honor.
Based on your sworn testimony, when authorized in all 4 counts, I find they've been made, I find that there's probable cause to believe those crimes were committed and defendant committed those crimes, and there's sufficient evidence on the record for the second offense notice. I'm going to authorize. You're all set. We'll put the warrant in the lien. Thank you very much. Have a good day. Thank you.
Thank you, Your Honor.
Sarah Renee Diaz, 25W837198. We'll take that one real quick. Where's Mr. Crawford at? Jeez. You got a corner here. Which one do you have?
I have Mr. H. Jones.
Have a seat right there, if you would, ma'am, at the table. We have Jeffrey Inch down there. Jeffrey Inch. Jeffrey David Inch, 23R513309A.
Good morning, Judge. Nice to hear the term,
Mr. Inch, your name?
Jeffrey Inch.
Call in, Beth. So what are we doing here? I arraigned him. I entered a not guilty plea. He has 2 counts. How's he going to proceed?
Judge will plead guilty to count 2 and not guilty to count, I apologize. Guilty to count 1, not guilty to count 2.
All right. So if you plead the failure to attend your biweekly substance abuse disorder group during the week of May 4th through 10th, I'll just consider that one violation. Do you understand that?
Yes, sir.
Did you sign and read and understand the advice of rights?
Yes, sir.
If you plead guilty, you'll be giving up all those rights and there will be no hearing or trial. Do you understand that?
Yes, sir.
My information is that this would be a 4th technical violation. Your probation could be revoked. You could be incarcerated for up to 93 days. Do you understand that?
Yes, sir.
All right. You understand all your rights?
Yes, sir.
Do you have any questions on your rights?
No, sir.
To the charge, you failed to attend your biweekly substance abuse disorder group at the Guidance Center on the week of May 4th through 10th. How do you plead?
Guilty.
Did you fail to attend your biweekly substance abuse disorder group between May the 4th and the 10th?
Yes, sir. Yeah.
Anybody force you to plead guilty?
No.
I'm gonna accept that plea. Did somebody call Beth?
Beth is finishing up with the defendant at the window. She'll be ready.
Why don't you have a seat? I'm gonna have to take the other file first, okay?
Judge,
Thank
I find Emerson, Miss Foley Carter and myself would like to sidebar with you.
Okay,
On that.
I will do that momentarily, okay? Where is Mr. Crawford again? Good, thanks. Sarah Renee Diaz, 25W837-198. Your name, ma'am?
Sarah Renee Diaz.
We're gonna wait for your lawyer. It's gonna be resolved that day, otherwise I have to set it for trial, okay?
Thank you.
Thank you. I'm gonna go in the back and talk to Ms. Foley Carter, right, on Emerson?
Yes, sir.
You and I and Ms. Foley Carter. All right, everybody stay safe. What are you here on?
I am on Alger Lucky. However, there's no one here that's handling that case, not the prosecutor, not.
Alger Lucky or Alger?
Lucky. So I'm trying to get information on the case, and there's nobody here to talk to.
Judge, she came into the Woodhaven conference room. It's not a Woodhaven case though, Your Honor. It appears to be a Brownstown case.
It's a probation violation.
Is your client? Okay, well, we're gonna take care of it. You got all these, it's probation violations.
Right, and
You entered in the.
I was trying to get cleared up, because some people said there was a show cause.
Well, listen, you can look at the file.
Okay,
I'll come out and take it, but he hasn't been here. Mr. Lucky has apparently not been lucky, and he hasn't been here in 3 years.
well, we hope to take care of that today, Your Honor.
So do I. Where's he been? We'll talk about it when I come back. I gotta talk to these lawyers in chambers. Where's Mr. Lucky?
He's here.
Where you been? What if I showed up 3 years from now and you were
He's been
supposed
in
to
Ohio, Your Honor.
be? I'll be right back. Everybody stay safe. Hi, guys. He wrote down here, okay? That's it. Good luck. Go down in front of Judge Hesson. I'm really worried about you. And the thing is, I can't say I haven't tried. Good luck. Let's do Alger Lucky. I know you guys are busy back there and I haven't been able to get you in here. Alger Lucky. Alger Ivory Pierre Lucky, 22B1397938.
Good morning, Your Honor. Kimberly Bell, P44711. I'm appearing on behalf of Mr. Lucky today.
Your name, sir? Are you here on this?
I am here on Inch, but I can go.
I need you to pull this file. All right, so defendant hasn't been here.
Yes, Your Honor.
We have multiple counts. He has 2 prior technical violations. He absconded. I have 6 counts. How's he going to proceed on these?
Your Honor, as I had indicated to you off the record, I was trying to get some more information as to the status of this file.
Well, the status is that he's blown us off for 3 years.
Right.
That's the status. I sentenced him May the 12th of 22. I don't know what else to tell you.
Well, let me
You can,
respond.
no.
Okay.
Hang on. You can look at the probation violations. He's got 6 of them. They think he didn't attend his probation visit on October 13, that he didn't attend the court work program on October 5 of 22, that he didn't provide proof of completing 4 hours community service by October 10 of 22. He didn't even provide verification of attending and completing outpatient treatment. That he failed to refrain from consuming alcohol and controlled substance, testing positive for marijuana and alcohol back at a chemical test back on September 13 of 22. I don't know what else to tell you. I mean, you can look at the file. He pled impaired.
Your Honor, may I address you now?
No, you look at the file. I can only do this in one way. I don't do Cobb's pleas.
Okay.
He's got a big problem with me.
All right.
He's blown off the court for 3 years, and I don't appreciate it. So I know, he was running the Pentagon. I don't know what to tell you, seriously. I don't want to hear these excuses. He knows that I know if I told him I'd give him $5,000, he'd have been here 3 years ago.
Give me a chance to.
Yeah, take your time, but I don't get it. I just don't get some of these guys. I really don't. They just, guys and gals, think they don't have to show up for 3 years and then come in and pretend like it didn't happen.
He's not a bad.
Oh, I'm sure he's not. None of them are. Anybody who ignores a court for 3 years is about as respectful as, that's the way I feel about it. You can come back and prove to me I've been thinking wrong for 60 years. William Michael James, 23B726981. I need Mr. Crawford. If we got to give other things to other lawyers, but I got him with Mr. Inch, right?
Mazin is with Mr. Inch.
These poor guys been waiting around and I can't get them in here.
Mr. Mazin said to me.
No, not Mr. Mazin. I'm talking about Mr. Crawford's got him. So you can leave.
Okay.
Come back with Mazin, Gaith, and Inch, and you can come back on the other one.
Mr. Gates said to me as he left that he was going to join for Mr. Inch on Zoom because something in custody, but I was.
Mr. Inch is right there.
No.
I have MDOC here that needs to be handled before we lose them.
Okay, go ahead.
Arraignment.
What you said.
All right, so William Michael James, 23B726981. Your name, sir?
William Michael James. Michael Crawford representing.
All right. Before we go on, I'll just indicate that the defendant has been on bond conditions. And we're going to accept them. So have you had a chance to review the report with him, and are there any material additions, corrections, or deletions?
I have had the opportunity to review the report with my client, and there are no material additions or deletions. We asked the court to adopt the recommendation as presented.
Anything that you would like to say on his behalf?
No, sir.
And you're done?
No, Your Honor.
Sir, I'm gonna be glad to take you, but you missed the test. We talked about status review this morning.
Yes, sir.
Can't miss you.
I
I'm gonna let it go. I'm not gonna let it go next time.
Okay, I'm sorry about that.
Well, why'd you miss?
I overslept my alarm, and I woke up at 9:50.
You have an alarm clock?
Yeah, I used my phone,
Well, then how did it not go off?
I swear, I was mad at myself for missing, because.
The phone was
I don't mind.
defective? Is the phone defective? Did you set your alarm?
I set like 10 alarms, I set.
10 alarms?
I said,
None of them went off?
I'm a heavy sleeper. So I accidentally
You
missed
should
them.
buy a lottery ticket.
Yeah.
I mean, if you turned 10 alarms on and none of them came on,
I think they came on, but I think I slept on my phone, so that probably had something to do with this, I didn't hear it.
all right, now wait a second, you're making this worse. You set 10
sorry.
alarms,
Yeah,
either none of them went off, or all of them went off, or any combination thereof went off, and you slept through it?
yes, sir.
Come on. Come on. What are you, Rip Van Winkle? I mean, come on. I mean, you gotta make sure this doesn't happen. Who do you live with again?
My parents,
Well, then you have them come wake you up.
my mom's awake.
I saw her, she raised her hand. Don't miss again.
I won't, I promise.
There is nothing I find amusing about this. 2 years probation, be glad to take you. But that worries me. You cannot leave the state without the consent of the court or violate any law. If you change your address, your place of employment, or home telephone number, you must notify probation. You have to report as directed. No alcohol, no illegal drugs, no marijuana either. You're not to purchase, possess, or consume any one of those. You're to submit to chemical testing on demand of probation. They're gonna tell you when you have to go. At least I'm gonna need his ownership record on this, please. No alcohol, no marijuana, no illegal drugs. Chemical testing on demand, submit to PBTs, ETGs, and chemical testing on demand of probation, complete 60 more days on the sober link, but we are going to switch that into our name, so we're paying the bill with our grant. Attend 12-step meetings 3 times a week and provide proof, obtain an AANA sponsor, attend all substance abuse treatment. Attend the Victims Impact Panel, attend and complete the Armed Specialty Program. Report to sobriety court status reviews with me every other week. Obtain and maintain employment with proof provided to the probation officer. Do you own that vehicle that was being operated on the date of that?
I do not, sir, was my father's.
What do you mean was your father's?
It is my father's, sorry.
Okay. Seven days jail, credit 1, serve 6. I'll let you serve those as follows. You're doing well on this otherwise. Serve 4 on the court work program, 2 days of community service. I'm gonna give you until August 1st to complete your 16 hours of community service. 4 days court work program, pay $105 for that. I'm sorry, $140 for that, $35 a day. Fines, fines $200, costs $300, 75 victims' rights fee, $50 justice assessment. So fines and costs are $6.25. Screening fees $60 for $685. You have probation fees of $360, bring your total to $1,045, $480 in probation fees. That brings it to $1,525 plus your court work program fees. Your total is $1,625. If you violate, your probation could be revoked. You could be incarcerated for 93 days with credit for 1 day served. You have 21 days to appeal, 14 days to apply for a court-appointed lawyer for purposes of appeal. Do you understand that?
Yes, sir.
Lisa, did you run that ownership?
Yep, give me 1 second. I have to grab it off the printer.
Take your time. So I would have to order your vehicle immobilized, but if you don't own it, I'm not ordering it. You didn't own it at the time of the accident. Or, I'm sorry, at the time of the incident. All right. Does he have all this to pay?
No, Your Honor.
How much does he have today?
400.
Okay. All right.
Judge, it's registered to a Brian and Brittany Janes.
That's my sister and my father.
Okay. You pay $400 now. You are making $750 a week, gross or net, before or after tax?
That's
Who's is Tricia James? Is this your mother? Is she gonna let you apply the bond or not? If you don't want to, you don't have to.
I'll apply the bond.
That's 5,000, 10%, I believe, Lisa. Or was it three? Let me see. I don't know if it's 5,000, 10% or 5,000 or 500 cash. But anyway, we're gonna say he pays 850 now. And then balance at the rate of, can you pay 50 a week? Balance at rate of 50 per week. I'll start that beginning on June the 21st, okay? If you need more time, no problem, call the clerk, we'll go on Zoom, I'll be glad to give you an extension, any questions?
So today I just pay
$850.
$850.
You're gonna pay, you're gonna sign over the bond, I don't have proof here right now as to whether or not it's 5,000, 10% or 500 cash.
It was a 10%, Judge.
So you have 450 plus your 450, I just made it 850, you wanna pay the other 50, you can. Okay? And then you'll meet with probation. I wish you well. I hope we help you. Good luck.
Thank you.
Don't miss again. Make sure he gets the testing. Darren Joseph Gazabon, 25B147802.
Good morning, I'm Michael Crawford, representing Mr. Gazabon.
Mr. Gazabon, your name?
Darren Joseph.
Boy, if anybody I've had today deserves to go to jail, I hate to give you the bad news. It's you. Have you had a chance to review the report with him?
I have, Your Honor. There are no material additions or deletions we've added on the clients. We need to comply and look forward to sobriety.
Mr. Casabon, what can you tell me?
Well, Your Honor, when this all started, about a month ago, I was having a problem with it. I had already do some self-checking and, this past month, honestly, I'm at 360. My life has changed and I'm looking forward to doing whatever I need to do and growing.
Mom, come on up here a second. I hate to do this. He's old enough. He's gonna be 40 years old pretty soon, right? I mean, you're 38, right?
Yes, sir. Mr. 38.
You're gonna die if you keep on this.
I'm experiencing health issues from using it in the past, they're kind of.
I don't want you to have to go into that. How you doing, ma'am?
Hello.
What's your name?
Deborah.
Deborah what? What can you tell me? You noticing a difference here?
Absolutely. I can tell you.
I scared her.
I'm sorry.
I think I scared her.
Well, I think it scares me in here. It's just uncomfortable, but it's right. And we were never against, the consequences of the bad decisions when he was younger. And just, watch the struggle. And it's been a struggle for all of us to watch, but I can tell you since he's been out, it's been a year and a half almost. It's been different, it's been totally different. Now, little blips, yes, a couple little blips. Friends are going away, and that's been a great thing. So getting rid of the old friends, the people that you think are okay. So now, since this, has it been 30 days?
The good news is this wasn't assaultive and it was not a drunk driving. It was loitering where drugs are present. I know he struggles with it. It's evident to me he's been struggling with it pretty much his whole life, going back to 05. I mean, it was just marijuana, then impaired 08, analogs 08. He's got larceny of buildings, retail frauds. He's got all these addictions. He's got all these ugly convictions on here. And I'm sorry. Cut you off.
Well, no, I wanna thank you.
You don't have to thank me. You would thank him because this makes parents get old. You're done with this. I'm telling you, I'll be your best friend if you stay clean. If you don't, I'm going to turn on you like you can't believe because honestly and truly, I will go home tonight and wonder why I did not send you to jail.
facility. I can do this.
2 years probation. You cannot leave the state without the consent of the court or violate any law or ordinance. If you change your address, your place of employment, or home telephone number, you have to notify probation. No alcohol, no marijuana, no illegal drugs, none of them. Not to purchase, possess, or consume any. Submit to chemical testing on demand of probation. Submit to PVTs, ETGs, and chemical testing. Even though you're not drinking, it doesn't sound like, you're still gonna go through 60 days on the sober link from today. You're to attend AA meetings at least 3 times per week. You're to obtain an AANA sponsor, attend all substance abuse treatment, attend the Victims Impact Panel, attend and complete the Armed Specialty Court Work Program, report to sobriety court status reviews with me every 2 weeks, obtain and maintain employment with proof provided. You don't have any health issues that prevent you from working on the work program, right?
No, sir. No.
100 fines, 100 costs. This is, again, I'm gonna keep in mind, this is not a drunk driving or an assaulted. 100 fines, 100 costs, 75 victim choice, $50 justice assessment, 3 1/4. Screening fees, 60 for 385. Probation fees are 480, so your total's 865 plus 1245, 316 sobriety court fees, you have 1245. And I gotta tell you, the court work program fees you're to clear all warrants within 30 days of sentencing. You're gonna do 10 days on the court work program, and you're gonna pay $35 for that, for a total of $350.
You have to pay that when I go there, or that's just all of it?
That's all included.
Okay.
So Lisa, what did I said before that? I forgot what number I had.
I'm at 1575 with the court work program.
100, 200, let me just double check that. Not that you wouldn't completely get it right. 385, 685, 745, 1145, 1225. Okay, I better do it again. I got 1575. Let me double check. 200.
That's what I said, 1575.
Oh, okay. Thank you. All right, so 1575, I hate to do that, but if you violate 90 days, you have 21 days to appeal, 14 days to apply for a court-appointed lawyer. Do you understand one another?
I do.
Stay with me.
I'm going to.
You seem like a nice kid, but you gotta stop the drugs. Okay? We're gonna help you.
I believe it.
Okay, ma'am, thanks for coming. You show up at sobriety court status reviews with him. That's fantastic.
I'm supportive of all this.
Of course. Well, he's gonna be a different person. If he just stays with us, he's gonna be a different person. Payment.
Your Honor, my client's only got $100 today. You can stop that.
He does have 100, or
He's got $100.
pay 100 now, and then how much can you afford to pay?
50 a week work.
I'll tell you what, you do it however you want. I'll make it 100 now, 100 bi-weekly, and I'll start that beginning June the 21st, okay? If you need more time, no problem, call the court, we'll go on Zoom, or you can come in here on or before the due date, 8:30, you'll meet with the probation. Sincerely wish you well. Good luck. Thank you. Thanks for coming, ma'am. Alger Ivory Pierre Lucky, 222-139-7938. I don't think I have any more of yours, do I, Mr. Crawford?
Yeah, you got one more. I've got 2 more.
Okay, go ahead. Go deal with them, and I'm gonna take this one and Mr. Inch.
Thank you, Your Honor.
All right, I need Beth Wiles.
For the record again, Kimberly Bell, P447111, I appear on behalf of Mr.
Good
Lucky.
morning again. Your name, sir?
Alger Lucky.
All right, so have you had a chance to review this file?
I did.
What is he going to do? Is he going to plead, or does he want a hearing on these 6 counts?
No, he will please.
So, sir, if you plead guilty here, I want you to understand your probation could be revoked and you could be incarcerated for 93 days. Do you understand that? And did he sign an advice of rights form today?
He did not, Your Honor.
You're presumed innocent. They have to prove you guilty by a preponderance of the evidence. You have the right to question their witnesses, to bring in your own, to use the subpoena powers of the court to bring in those witnesses, to testify or remain silent. If you remain silent, that silence would not be held against you. Do you understand that?
Yes.
If you plead guilty, you're waiving your right to a contested hearing. You're waiving your right to a hearing of any kind, and you could be incarcerated, as I said. And again, you have 2 priors, technical violations, it says. But given that you have absconded, you could get the maximum. Do you understand that?
Yes.
Any questions before we go on?
Your Honor, best with Judge Hudson.
Okay. Any questions before we go on?
He's got Mason. He's in custody.
No questions, Your
All right, as to count 1 that you failed to attend your scheduled visit on October 13 with probation of 22, how do you plead?
Yes.
You failed to attend your probation visit on that date.
Yes.
Count 2 that you failed to attend the court work program on October 5 of 22, how do you plead?
Yes.
You failed to attend on that day.
I showed up, but I had on shorts and I forgot that we could wear shorts and sent me on.
Count 3 that you failed to provide proof of completing 4 hours of community service by October 10 of 22, how do you plead?
Yes.
Did you fail to do that?
That's community service. That was my last day. I had community service, but I forgot I couldn't wear shorts.
You did 3 days.
Community service is different than court work. You would have set up your own community service.
I don't think, we were talking about this, Your Honor. I don't think he understands the court work program.
It's not considered community service. It is community service, but it's supervised court work.
All right.
So I ordered you to do 4 more hours of community service at some point, and I'm just asking you, did you complete the 4 hours of community service by the due date of October the 10th of 22?
He completed 3 days.
No, that's a court work program.
Oh, you're talking about the court.
I sanctioned him at one point in August 31 of 22 in order to complete 4 hours of community service by October 10. So the charge is that he failed to provide proof of completing that by October 10. So how do you plead to that?
Really?
Why are you confused?
Yeah, not guilty.
Did you fail to provide proof of completing community service hours that you were due to do?
I had 4 more left. I had 4 more hours left. The day sent me on. That was my last day of community service.
That's the court work program. I don't know how many times I gotta tell you that. When we're supervising, when you're showing up at this building, that's the court work program. That's where it's a little bit more stringent. I allowed you to do community service where you could go fold clothes somewhere, the Salvation Army, or do something else by October 10th.
I came here.
He did not, that's the court work program. Are you listening to me?
That's where they sent me home from.
But he said that they sent you home from the court work program.
That's not community service.
Oh, my bad.
You could have done community service at Salvation Army, St. Vincent de Paul, a church, Habitat for Humanity, an animal shelter. You could have done it wherever you wanted. You could have done it.
Oh, I had it confused. I'm sorry.
Oh, yeah, that's all right.
Yeah.
But so I'm gonna ask you again, did you fail to complete that by October 10 of 22? You didn't do it, right?
Right.
Count 5, that you failed to refrain from consuming alcohol, testing positive on September 13 of 22 for both alcohol, that's on count 5. How do you plead to that?
Guilty.
And count 6, marijuana, how do you plead to that?
Guilty.
Anybody, did you consume alcohol and drugs, marijuana within the 3 days before September 13?
Yeah.
Anybody force you to plead guilty?
No.
Pleas are accepted to those charges. You got 6 counts. I can't wait to hear what the explanation is. I have a feeling I'm not gonna like it because it's gonna be he didn't have a ride or he forgot or.
Your Honor, I would just very much appreciate it if you at least let me explain something.
Oh, no, you explain all of it. Take your time, have at it.
First of all, that was in 2022. This is 2025. Mr. Lucky's in a completely different position in terms of where he is with this case. He wants to take care of all of this and meet his responsibilities under this case. him not showing up, he moved to Ohio.
Did he get permission to leave the state?
I know where to live in Detroit.
I'm just asking you, did you get permission from anybody to leave the state?
Oh, you said I can go to work, because I work now. You said I can,
I didn't say you could live there though, did I?
No, I ain't had no choice.
I said you can leave state for employment, but go ahead. So he violated probation in that aspect too, but go ahead.
Okay, so, he was in Ohio, and because he had, this is based on the OWI charge, his license was revoked, so he didn't have transportation up here. Now he does.
How many drunk drivings does he have?
Just one.
They didn't revoke him there.
Oh, no.
They
Never had. No, I was trying to use my license when I ended up catching I was just paying my tickets off. When I ended up catching tickets last time.
Okay, go ahead, counsel.
Okay, so anyway, now he has access to transportation with his brother. Secondly, Your Honor, again, he moved to Ohio.
Whereabouts in Ohio?
Toledo.
This was a second drunk driving, right? Or at least he didn't appear to see. He had one in 15.
I thought this was the only one, Your Honor.
Well, maybe he still has that warrant out. Let me double check out of Dearborn.
I've had no warrants.
Go ahead, counsel. I'm listening to you.
Okay. So anyway, because he was in Ohio, that prevented him from coming. He didn't have to,
Where's he live in Ohio?
this is what I have to offer.
Where's he live in Ohio?
He's living in Toledo.
Come on.
So now through his brother, which he didn't have that transportation before, he has transportation now. He can get to his scheduled appointments. He can get to whatever programs and whatever he has to do. He's also able to pay all of his probation fees. And I would just ask Your Honor to consider all that. Like I said, he's not the same guy that he was in 2000.
Well, you're not giving me any reason to tell me he's changed, other than the fact that he moved to Ohio and couldn't get here from Toledo, which is
Well,
only
what
4.
has changed, I should say, not necessarily, I can't speak about him, but what has changed is that he has he has access to someone.
Where does he work?
He was working at the Chrysler plant and then got laid off.
When did he get, what Chrysler plant?
Toledo.
When did you get laid off?
January.
How long were you working there?
2017.
Did somebody call Beth on this?
I'm not sure if John did, Judge, well, I'll call her now.
Well, he did say she was in Judge Hesson's. I don't know if she still is. Can you tell by looking out there, Lisa, is she still in Judge Hesson's?
I can't see her courtroom, Judge.
Okay. All right, go ahead.
So anyway, for all of these reasons, I'm asking you to give my client another chance.
No, I just don't,
And
I'm telling you the way, to me, there's no stay of the probationary period. He's been gone for 3 years. I really, as far as I'm concerned, I lose jurisdiction after today. I mean, there's nothing I can do when they do this. That's why it's upsetting.
I understand.
He doesn't show up here. We know what happened. He tested positive. He got scared or unconcerned. He didn't do anything. 2 violations within the first 3 months.
But that's exactly what happened, Your Honor. He got scared. When he moved to Ohio and wasn't making his probation meetings, he felt that he was already in violation.
Well, yeah.
And I know the thing to do, or what the thing he should have done, was to call someone to tell them what his situation was. But we deal with real people. And,
Do you have kids? You married?
I got 3 kids, and that was a whole accident.
Where were your kids at?
At school, right now.
No. Where were they in 22, 23?
At 22, we was all together, we was all living together after the accident, one car.
Slow down.
Yeah.
How old are your kids?
I got a 19-year-old now, a 16-year-old, and a 12-year-old.
Did they all move to Toledo with you?
No.
They stayed in Detroit?
Yes. Me and my lady split up after the accident, the one car, it really took.
he had an accident, right?
The ticket, that's what I'm talking about. It really messed up my whole life. I had the phone, my old number with the all your contacts in it. She broke the phone, I couldn't get in the iCloud.
Just to put some context to this, on this OWI charge, it was a truck that hit him. And it kind of dominoed from there. And that's what he's trying to explain.
How old are you?
40.
You got laid off from Chrysler, Jeep plant in what month? January?
Yeah, yes.
Is that a permanent layoff or is that?
Yeah, because I didn't take the full time. I had turned it down, then I got pushed it back to the back. So now I'm on like what do they call it, TS or like a train, like a TPT. So I might, they might call me for the summer. I might.
Oh, you're a temporary employee?
Yeah.
Who do you live with now?
Homegirl.
Pardon?
One of my friends. She's my friend. I would say my girlfriend.
Well, that's all right. I don't need to get detailed. I just wondered where you're traveling about. You left your brothers then, right?
Do I leave my brothers?
Yeah.
No, I don't stay with my brother. He just.
I thought you said it did. Maybe I misunderstood you. Did you tell me or did you not tell me that you went to live with your brother in Ohio? Did I misunderstand?
I stayed in Ohio. I stayed with my uncle in Ohio. When I left my family in 2022, I went to Ohio and stayed out there in Ohio and was going to work
with who?
out there.
With who?
My homegirl.
Your girlfriend?
I said my girl.
Ms. Wild's your name?
Elizabeth Washbacher.
Can you give me any good news on this one?
I think the only bit of good news that I can give to you on Mr. Lucky is he did complete his victims impact panel. Other than that, unfortunately, it's kind of complete abscondment after he had missed his appointment October 13th. And even the 4 hours of community service was part of penalty from a prior violation. He didn't even complete those 4 hours of community service. I wish I had better things to say, but he just basically up and left and we didn't hear from him again.
And like I said, Your Honor, that's because of transportation issue. It's because he should have called, he should have let the probation officer know. However, he didn't do that, and he's in this situation now.
I mean, he just ignored us here. I'm looking at this. It's like, seriously?
But you know what people do, Your Honor? When they think they're facing penalties in jail, thinking that they're
I get it. I just still. Yeah, I get it.
I can appreciate transportation issues, but he was reporting by Zoom, Your Honor.
And not only that, he didn't live in Cleveland. He's living in Toledo. I mean, if I'm going to say somebody that I'm going to excuse somebody for not having transportation that lives in Toledo, I've got to pretty much excuse anybody who lives north of, I don't know, north of 12-mile road practice. And then I'm just not prepared to do. He could have gotten here. He knows he could have gotten here.
He didn't have anybody to help him at that time. He's got his brother to help him now. And that was the problem. It was a problem getting here. It was a problem with having someone bring him here. And who he had is his brother.
You know, you're on the same page. I mean, I remember a justice writing something about, well, people don't have to get rides. Let's do it on Zoom. All I know, I don't say this very often. All I know is that anybody that comes here in this courthouse, there's only one of three things. They either live here they drove here to commit the crime, right? Or they got a ride here. That's the only three things anybody could possibly come in front of me. They either here, they drove here, or they got a ride here. So I don't know what's so difficult about asking people that got a ride or drove here to get a ride here to pay the piper.
Right.
You know what I mean? So I'm trying to be understanding. I'm telling you, I'm not a fan of this. I never have been, and I never will be. I will do the best I can for him. How much do you have here, Lisa, in fees does he owe?
$884.
He will be able to pay that right away, Judge.
Does he have any credit coming other than the
The
one?
only credit I can say is we had scheduled for the work program. He was a no-show a few times. He wore shorts once, but he did complete at least one day of the work program, which was August 3rd. So I would say he's got a day of credit for that, Your Honor.
Doesn't look, it looks like he had a warrant out of someplace in 2015, out of the Dearborn District for OWI. I don't see any disposition on that, either on his traffic record or on the criminal history. I don't know what happened with that.
Your Honor, I can't say this for certain, but I don't believe he was charged. This is because it's my understanding, this is his only charge.
Well, they issued a warrant for him on an OWI at one point, failure to appear in court back in 15.
I do have the screening assessment obviously done at the time of his plea, Your Honor. 2012 out of 19th, he had failure to appear on drug and license suspended. 2015 out of Dearborn 19th for OWI and drug and license suspended. He also had 2019 out of 34th, but those were for civil infractions of speeding and no.
I'm not gonna take that into account. I was just mentioning that if there's no evidence of a conviction, there's no evidence of a conviction. Probation is revoked. You're to pay costs of $950 and serve 93 days jail, credit 2, for a total of 91. If you pay costs of $950, I will suspend 72 of the 91, requiring you to only serve 19. You have 21 days to appeal, 14 days to apply for a court-appointed lawyer for purposes of appeal. So you pay that money now, you'll be out in 19 days with credit for time served. No.
I got one last issue, Judge. You're gonna be sick of me. But there was a court date scheduled for May, and he didn't get a notice and I didn't get a notice. I spoke to the clerk, Lisa. I submitted an appearance by internet. She said, no, the court never got an appearance from me. And the notice was sent to Mr. Lucky's former address on Braille in Detroit and not to his current address.
Well, how are we supposed to know?
I don't know. I did my part.
Well,
At least I thought.
But we don't have an appearance in the file until the one you filed on May the 15th.
Exactly, that's what she told me. And I don't know how that happened.
So I don't know.
Because the appearance I sent in, I didn't send it in to Lisa. I didn't write down who or where
So what are you asking?
Sorry?
I don't know what you're asking me.
Oh, if you would reinstate the bond. And that was.
There was a third-party bond posted, Judge.
Yeah.
And that would help pay.
I'm not gonna, I'll tell you what, if you want to, if you want to address this when he's out of jail, I don't have a problem. I don't even have a problem with you addressing it by Zoom, but there's too much for me to digest here. When people don't show up. I'm not gonna apologize. I don't like it. And he played,
Can we get the bond? Can we at least apply?
I
the
heard
bond?
what you said. I
Oh,
understand,
okay.
but he hasn't shown up for 3 years. I mean, what is this?
Okay.
What bond are you talking about? The one that-
Judge, I can explain it. He posted a bond, so I set a court date. He did not appear because we had an old address. She states that she filed an appearance, but I never received it.
Is this a bond that he posted online on or about April 22nd?
Yes. Yes. So then when I heard from her questioning why she never got a date, she sent me a new appearance and I reset the court date.
I don't have a problem with reinstating the bond, but he's gonna have to pay whatever else he paid because that's in the name of the third-party poster. So the third-party poster can come in here. We'll refund the money to the third-party poster.
Okay.
Okay, I'll do that. I can
Thank
see
you.
that at least he did that.
Thank you.
But he's gonna have to pay his money today without the bond. And then he'll just have to serve those days that I gave him, which is after he pays the bond 19, or pays the fines and costs 19.
All right.
Stop doing this. Good luck, have a seat, thank you. People against.
Mr. Lucky.
Tangeray,
Thank you.
I want, thank you very much, nice to have you here. I want to do Inch as soon as I can get whoever his.
Yeah, Mr. Gates said he's going to do it on Zoom, Your Honor, because he's in, and he just unmuted and got himself on the screen.
Lisa, can you tell me whose lawyer Mr. Allen is?
It's
I'm
Mr.
her attorney,
Gates
Judge.
and Detective Cerna's here.
Good, let's do that right now. Tangeray, and we'll get, Mr. Gaith will do it, Maz and Gaith an Inch, and you can come back on the other one.
Mr. Gates said to me as he left, that he was gonna join for Mr. Inch on Zoom because something about something in custody, but I was,
Mr. Gaith, Mr. Inch is right there.
no,
I have MDOC here that needs to be handled before we lose them.
Okay, go ahead.
Arraignment.
What you said. Mr. Crawford's on one.
All right, so William Michael James, 23B 726-981. Your name, sir?
William Michael James. Michael Crawford, representing.
All right. Before we go on, I'll just indicate that defendant has been on bond conditions. And we're going to accept them. So have you had a chance to review the report with him, and are there any material additions, corrections, or deletions?
I have had the opportunity to review the report with my client, Your Honor, and there are no material additions or deletions. We ask the court without recommendation as presented.
Anything that you would like to say on his behalf?
No, sir.
And you're done?
No, Your Honor.
Sir, I'm gonna be glad to take you, but you missed the test. We talked about its status review this morning.
Yes, sir.
Can't miss you.
I know.
I'm gonna let it go. I'm not gonna let it go next time.
Okay. I'm sorry about that.
Well, why'd you miss?
I overslept my alarm. And I woke up at 9:50.
You have an alarm clock?
Yeah, I used my phone.
Well, then how did it not go off?
I swear, I was mad at myself for missing because.
The phone was
I don't mind.
defective? Is the phone defective? Did you set your alarm?
I set like 10 alarms. I set.
10 alarms?
I said,
None of them went off?
I'm a heavy sleeper. So I accidentally
You
missed
should
them.
go buy a lottery ticket.
Yeah.
I mean, if you turned 10 alarms on and none of them came on,
I think they came on, but I think I slept on my phone, so that probably had something to do with this. I didn't hear it.
all right, now wait a second, you're making this worse. You set 10
Sorry.
alarms,
Yeah.
either none of them went off, or all of them went off, or any combination thereof went off, and you slept through it?
Yes, sir.
Come on. Come on. What are you, Rip Van Winkle? I mean, come on. I mean, you gotta make sure this doesn't happen. Who do you live with again?
My parents.
Well, then you have them come wake you up.
My mom's awake.
I saw her, she raised her hand. Don't miss again.
I won't, I promise.
There is nothing I find amusing about this. 2 years probation, be glad to take you. But that worries me. You cannot leave the state without the consent of the court or violate any law. If you change your address, your place of employment, or home telephone number, you must notify probation. You have to report as directed. No alcohol, no illegal drugs, no marijuana either. You're not to purchase, possess, or consume any one of those. You're to submit to chemical testing On demanded probation, they're gonna tell you when you have to go. At least I'm gonna need his ownership record on this, please. No alcohol, no marijuana, no illegal drugs, chemical testing on demand, submit the PBTs, ETGs, and chemical testing on demanded probation, complete 60 more days on the sober link, but we are going to switch that into our name, so we're paying the bill with our grant. Attend 12-step meetings 3 times a week and provide proof, obtain an AANA sponsor, attend all substance abuse treatment, attend the Victims Impact Panel, attend and complete the Armed Specialty Program, report to sobriety court status reviews with me every other week, obtain and maintain employment with proof provided to the probation officer. Do you own that vehicle that was being operated on the date of that?
I do not, sir. Was my father's.
What do you mean was your father's?
It is my father's. Sorry.
Okay. Seven days jail, credit 1, serve 6. I'll let you serve those as follows. You're doing well on this otherwise. Serve 4 on the court work program, 2 days of community service. I'm gonna give you until August 1st to complete your 16 hours of community service. 4 days court work program, pay $105 for that. I'm sorry, $140 for that, $35 a day. Fines, fines $200, costs $300, 75 victims' rights fee, $50 justice assessment. So fines and costs are $6.25. Screening fees $60 for $685. You have probation fees of $360, bring your total to $1,045, $480 in probation fees. That brings it to $1,525 plus your court work program fees. Your total is $1,625. If you violate, your probation could be revoked. You could be incarcerated for 93 days with credit for 1 day served. You have 21 days to appeal, 14 days to apply for a court-appointed lawyer for purposes of appeal. Do you understand that?
Yes, sir.
Lisa, did you run that ownership?
Yep, give me 1 second. I have to grab it off the printer.
Take your time. So I would have to order your vehicle immobilized, but if you don't own it, I'm not ordering it. You didn't own it at the time of the accident? I'm sorry, at the time of the incident. All right. Does he have all this to pay?
No, Your Honor.
How much does he have today?
400.
Okay. All right.
Judge, it's registered to a Brian and Brittany Janes.
That's my sister and my father.
Okay. You pay $400 now. You are making $750 a week, gross or net, before or after tax?
That's after.
Who's is Tricia James? Is this your mother?
Yes,
is she gonna let you apply the bond or not? If you don't want to, you don't have to.
I'll apply the bond.
That's 5,000, 10%, I believe, Lisa. Or was it 3? Let me see. I don't know if it's 5,000, 10% or 5,000 or 500 cash. But anyway, we're gonna say he pays $850 now. And then balance at the rate of, can you pay 50 a week? Balance at rate of 50 per week. I'll start that beginning on June the 21st, okay? If you need more time, no problem, call the court, we'll go on Zoom. I'll be glad to give you an extension. Any questions?
So today I just pay
$850.
$850.
You're gonna pay, you're gonna sign over the bond. I don't have proof here right now as to whether or not it's a 5,000, 10% or 500 cash.
It was a 10%, Judge.
So you have $450 plus your $450. I just made it $850. You want to pay the other $50, you can. Okay? And then you'll meet with probation. I wish you well. I hope we help you. Good luck.
Thank you.
Don't miss again. Make sure he gets the testing. Darren Joseph Gazabon, 25B147802.
Good morning, Your Honor. Mike O'Connell, representing Mr. Gazabon.
Mr. Gazabon, your name?
Darren Joseph.
Well, if anybody I've had today deserves to go to jail, I hate to give you the bad news, it's you. Have you had a chance to review the report with him?
I have, Your Honor. There are no material additions or deletions we've added on the clients.
You have 450 plus your 450, I just made it 850. You want to pay the other 50, you can. Okay? And then you'll meet with probation. I wish you well. I hope we help you. Good luck.
Thank you.
Don't miss again. Make sure he gets the testing. Darren Joseph Gazabon, 25B147802.
Good morning, Your Honor. Mike O'Connell, representing Mr. Casabon.
Mr. Gazabon, your name?
Darren Joseph.
Boy, if anybody I've had today deserves to go to jail, I hate to give you the bad news, it's you. Have you had a chance to review the report with him?
I have, Your Honor. There are no material additions or deletions we've added on the clients. We need to comply and look forward to sobriety.
Mr. Casabon, what can you tell me?
Well, Your Honor, when this all started, about a month ago, I was having a problem with it. I had already do some self-checking and, this past month, honestly, I'm at 36. My life has changed and I'm looking forward to doing whatever I need to do and growing.
Mom, come on up here a second. I hate to do this. He's old enough. He's going to be 40 years old pretty soon, right? I mean, you're 38, right?
Yes, sir. Mr. 38.
You're going to die if you keep on this.
I'm experiencing health issues from using it in the past, they're kind of.
I don't want you to have to go into that. How you doing, ma'am?
Hello,
What's your name?
Deborah.
Deborah what? What can you tell me? You noticing a difference here?
Absolutely. I can tell you.
I scared her.
I'm sorry.
I think I scared her.
Well, I think it scares me in here. It's just uncomfortable, but it's right. And we were never against, the consequences of the bad decisions when he was younger. And just, watch the struggle. And it's been a struggle for all of us to watch, but I can tell you since he's been out, it's been a year and a half, almost. It's been different, it's been totally different. Now, little blips, yes, a couple little blips. Friends are going away, and that's been a great thing. So getting rid of the old friends, the people that you think are okay. So now, since this, has it been?
The good news is this wasn't assaultive and it was not a drunk driving. It was loitering where drugs are present. I know he struggles with it. It's evident to me he's been struggling with it pretty much his whole life, going back to 05. I mean, it was just marijuana, then impaired 08, analogs 08. He's got larceny of buildings, retail frauds. He's got all these addictions. He's got all these ugly convictions on here. And I'm sorry, I cut you off.
Well, no, I wanna thank you.
You don't have to thank me, you would thank him, because this makes parents get old. You're done with this. I'm telling you, I'll be your best friend if you stay clean. If you don't, I'm gonna turn on you like you can't believe, because honestly and truly, I will go home tonight and wonder why I did not send you to jail.
I can show you. I can do this.
2 years probation. You cannot leave the state without the consent of the court or violate any law or ordinance. If you change your address, your place of employment, or home telephone number, you have to notify probation. No alcohol, no marijuana, no illegal drugs, none of them. Not to purchase, possess, or consume any. Submit to chemical testing on demand of probation. Submit to PBTs, ETGs, and chemical testing. Even though you're not drinking, it doesn't sound like, you're just still gonna go through 60 days on the sober link from today. You're to attend AA meetings at least 3 times per week. You're to obtain an AANA sponsor, attend all substance abuse treatment, attend the Victims Impact Panel, attend and complete the Armed Specialty Court Work Program, report the sobriety court status with reviews with me every 2 weeks, obtain and maintain employment with proof provided. You don't have any health issues to prevent you from working on the work program, right?
No, sir.
100 fines, 100 costs. This is, again, I'm gonna keep in mind, this is not a drunk driving or an assaulted. 100 fines, 100 costs, 75 victim charge, $50 justice assessment, 3 1/4. Screening fees, 60 for 385. Probation fees are 480. So your total's 865 plus 1245.
We've already seen this. Jumping forward. No more of this craziness. This is stupid.
Every day in the USA, people find themselves in court.
There are several cases involving Mark Zachary. Is it Bender? Bender. 4 motions to revoke probation, correct?
Yes, sir.
Okay.
Yeah.
Let's take them in numerical sequence. 19-33421, 21-37960, 21-37961, and 22-40675 are all called. Each of these involve felonies, beginning with 19-33421. On each of these cases, does the defendant, who's here with Ms. Minaldi, his attorney, and the state's attorney, waive formal readings of the motions to revoke unadjudicated probation? Can we proceed in summary?
Yes, Judge.
In summary, 33421 states that, and by the way, raise your right hand, sir. Do you solemnly swear or affirm any statement you make during these hearings will be the truth, the whole truth, and nothing but the truth, so help you God?
Yes, sir.
Lower your hand. This motion, in this case, filed February 21st, 2025, states that on May 25th, 2023, in this court, you were placed on 10 years deferred or unadjudicated probation for the 3rd-degree felony of unlawfully carrying a prohibited weapon. Do you understand what this alleges, and is that true?
Yes, sir.
Maybe I want to go on.
Wait, I just did number 1 on the.
Well, number 1 on each of. Number 1 states you committed the offense of illegal possession of marijuana on or about October 8th, 2024 in Chambers County, Texas, in violation of your probation order, condition 1. Is that true or untrue?
True.
Are you pleading true to this voluntarily and because it is true?
Yes, sir.
You understand that a voluntary and knowingly made plea of truth for 1 or more violations of probation, that's enough to grant the motion to revoke probation? Your probation could be revoked and you could be sentenced to the full range of punishment, which is a 3rd-degree felony, no less than 2, no more than 10 years confinement in prison. Knowing that, do you insist on pleading true today?
Yes, sir.
I find you were pleading true voluntarily. You understand and appreciate the consequences of pleading true. And God bless this machine. All right. An agreement's been reached where your probation would be revoked. You would be found guilty, sentenced to 3 years in prison to run concurrently with other cases. Is that your understanding?
Yes, sir.
It looks like one case will be dismissed.
Misdemeanor.
24, okay.
Yes, sir.
Is that your understanding?
Yes.
If I. Okay, these other ones, what's gonna happen?
Same resolution for all.
Okay. This, and the sentences to run concurrently, right?
Yes, Judge.
Okay, this isn't here on this. Do you want to put that included on the, agreed recommendation?
Me too. I apologize, Judge.
Yeah, I'm gonna, put an X. And it's with these three, right?
Yes, Judge. So I have them if you want me to read them to you. F21-37960. F21-37961.
Okay.
And F22-40675.
And I got those. Okay, this is going to run concurrently with 3 other cases. If I follow this agreement, sir, you have no right of appeal in your cases. Do you understand?
Yes, sir.
I'm going to show you what's marked as States Exhibit 1. Did you sign that
Yes, sir.
agreement? Understand it, discuss it with your attorney? Are the contents of States Exhibit 1 true and correct?
Yes, sir.
States Exhibit 1 tendered into evidence without objection admitted. This essentially states you're admitting wrongdoing here and admitting to the motion to revoke unadjudicated probation as a violation of probation that can revoke you, and this will be the same for all cases. And you understand that you are giving up all rights of appeal if I follow this agreement, which I'm going to do in each case.
Yes, sir.
So the State's Exhibit 1 is made a part of the record for all purposes, pre-sentence reports waived and all of this. I'm going to find there is sufficient evidence supporting this motion to revoke probation to grant it by preponderance of the evidence or greater as allegation 1 is proven true, voluntarily and knowingly made by the defendant. Your probation is revoked. And in this case, your plea of guilty that placed you on deferred or unadjudicated probation in 2023 was made voluntarily, knowingly, intelligently. There was enough evidence supporting your guilty plea from State's Exhibit 1 admitted at the plea hearing to find you guilty beyond a reasonable doubt. I now find you guilty beyond a reasonable doubt. In this case, 33421, I'm following this agreement. You are hereby sentenced to confinement in the institutional division of the Texas Department of Criminal Justice to serve a term of 3 years. This will run concurrently with all the other cases. Do you understand what has happened?
Yes, sir.
Now, we're going to do it a little different on the others so you know where you are. We're going to do the same thing in each case, but I'm going to hold off the findings until the end and do them all together, okay? So 21-37960, 21-37961, and 22-40675. Those are all similar to the previous case.
Yes, there is an amendment we need to make on 40675 in the paragraph that starts with that Mark Binder, defendant in the above style cause. It says it's a possession of a controlled substance, a state jail felony. It should be possession of a controlled substance, a 3rd-degree felony on the first page. On the first page where it says state jail felony, should say a 3rd-degree felony. All of these are 3rd-degree felonies. And I missed that whenever I signed the motion to revoke.
You did.
I did. I missed it.
It's okay, Judge.
Yes. There's always a woman that catches my mistakes, Judge.
Okay, that has been corrected to a third degree felony on this date without objection. All right, in each of these three motions, 37960, 37961, and 40675, these are motions to revoke unadjudicated probation. Does the defendant waive formal readings of these motions? Can we proceed in summary?
Yes.
In summary, they similarly allege, and we'll, any objection to putting them together here, these, that on May 25th, 2023, in this court, you were placed on 10 years deferred or unadjudicated probation in each case for the third degree felonies of illegal possession of a controlled substance. Is all of that true and correct, sir?
Yes, sir.
Allegation number one in each case alleges similarly in the previous case that you've pleaded true to already and has been sentenced, that you committed the offense of illegal possession of marijuana on or about October 8th, 2024 in Chambers County, Texas, in violation of condition one of your probation orders in each of these cases. Is that true and correct in each case?
Yes, sir.
Are you pleading true and correct voluntarily, knowingly, intelligently, and because these allegations are true?
Yes, sir.
Do you understand that a voluntary and knowingly made plea of true to one or more violations of probation, that's enough to grant the motions to revoke probation by a preponderance of the evidence or greater? Your probations can now be revoked. You can be found guilty and sentenced up to the full range of punishment. These third-degree felonies carry with them a punishment range of no less than 2 nor more than 10 years confinement in prison and a fine up to $10,000. That's the punishment range in each case. Do you understand what you're exposed to?
Yes, sir.
By pleading true, and there are plea agreements in each of these cases that have been entered by the parties, agreed upon by the parties, where your probations would be revoked. You would be found guilty in each of these cases, sentenced to 3 years imprisonment on each case to run concurrently. Is that your understanding of the master plan?
Yes, sir.
In all these cases. If I follow these agreements, sir, you have no right of appeal of your cases. Do you understand?
Yes, sir.
Once again, on each of these cases, including the original one, are you pleading true to allegation one, committing the offense of illegal possession of marijuana in violation of condition one of your deferred order?
Yes, sir.
That's allegation one in each of these cases. These 4 cases, these 3 we're working on, and the 4th one that you originally pleaded true to a little while ago. Are you pleading true voluntarily, knowingly, intelligently, and because these allegations are indeed true and correct as they are alleged?
Yes, sir.
Stand by.
That thunder?
I think it is. This is all I've had. Was coffee all day, and my stomach is rebelling. Everybody.
I thought that was a comment on.
Everybody at home, take shelter. If I follow these agreements, sir, not to be lied about, you have no right of appeal, and I'm sorry about that. Well, on each of these cases, I'm going to show you what's marked as State's Exhibit 1. And I'm going to ask you if you signed each of these documents voluntarily, knowingly, intelligently, discuss them with your attorney, or the contents all true and correct.
Yes, sir.
State's Exhibit 1 is admitted on each of these cases, which states you are mentally competent to enter your pleas in these cases, which are freely and voluntarily made, and you are admitting guilt to these violations, and that you are have discussed all of this with your attorney, and you are satisfied with the representation of your attorney in each of these cases, and all of this is true, so help you God, as well as you are giving up all rights of appeal if I follow these agreements,
Yes.
which I'm going to do. All right. Anything else to add?
No.
If not, I'm going to find in each of these three cases, including the fourth one that has already been disposed of in the cases of Mark Zachary Binder. The defendant has pleaded true to allegation one in each of these motions to revoke probation voluntarily, knowingly, intelligently. That is enough to grant these motions to revoke probation by a preponderance of the evidence or greater. It is so ordered, and these motions are hereby granted. Your deferred or unadjudicated probations in each of these cases are hereby revoked. In each of these cases, you pleaded guilty voluntarily, knowingly, intelligently, when you made your pleas. In these cases, when you were placed on probation on or about May 25th of 2023 in this court, you were mentally competent to do so. You understood and appreciated the consequences of pleading guilty. There was sufficient evidence supporting your guilty pleas in each of those cases at that time to find you guilty beyond a reasonable doubt when we placed you on deferred or unadjudicated probation. Now that that is revoked, you are hereby found guilty beyond a reasonable doubt in each of these cases. I am following the agreements in each of these cases. You were hereby sentenced to confinement in the institutional division of the Texas Department of Criminal Justice to serve a term of 3 years. These sentences shall run concurrently. Do you understand what has happened today, sir?
Yes, sir.
Anything else to add by the parties?
No, Your Honor.
Then we are in recess on this case. Thank you.
Thank you.
Yay. Happy?
Well, honestly, it's gonna make for
Yeah, no, you will be seen. Why not? I'm going to share the cities.
Wow. That hurt my feelings. I hurt my feelings.
Gentlemen, Mr. Arvon.
No, yeah.
You know, he's. I'm glad those last three were the same. Maybe the lizards there.
Could I have Shannon Ordwan, please? And
He was filed. He writes us a lot, like his own motions, but before he got rid of the last attorney, Mr. Reynolds, he had filed, or was it Nathan Reynolds filed it? Motion for investigator.
Yeah, that's between him and y'all. I'm gonna step out, I guess, whenever he wants that, but I mean,
He wants
the order was granted when he had an attorney. And so I think, you know.
I understand.
Because he's pro se now. How do we?
It just carries with it with the case.
I don't think he knows how to get an investigator. Like he can't just pay a friend to do it. Like we need
Yeah,
actual.
He's gonna have to
I think it's in one of the other files. I put it up.
make arrangements somehow to get that.
Well, I think whether he wants it or not, I think I have to have a standby counsel to stand by.
Judge, that has been an issue in the
But
past.
in the middle of the trial, he could say, I've changed my mind, and then we have to start from square one. And they could sit just around and just say, he's right there. Whenever you need him, he's gonna be right over there. And if you don't need him.
He has specifically refused that. And I mean, that's been an issue in the past. I think that would probably not be advisable.
Well, the guy doesn't have to say anything to anybody. All they do is just sit, and they're in. So if he just says, I'm overwhelmed, I want a trial, I want a lawyer, then he'd have the right for us to have to stop and start again, and we'd have to go find a lawyer for him. And then the lawyer would say, I need some time to get prepared.
Well, if
if
that's something that you're contemplating, then he needs to have on the record an agreement to that, because otherwise I think we're walking dangerous territory.
I don't think he has to agree. Just that guy can sit there, and he doesn't have to look at him, and they don't have to talk. He's just ready to come in if the guy needs him. then I think we'd have to stop what we're doing and then find somebody.
From a practical standpoint, you're right. But I just think that this is something that we've seen before. Yeah, oh yeah, I know. But this is something we've seen before, and we've had issues in the past where.
Just bring them out, see what happens.
But either way, there's going to have to be some sort of practical way for him as a pro se defendant to obtain a licensed investigator. And I'm not quite sure. I'm not even supposed to be involved in that, so
Yeah.
But there's a few other things that I think we need to
It is
take up
already
too.
set for trial, July 28th.
Yeah, we need to take that up too. We're gonna have to take a couple things up before that, and then you can deal with that investigator.
Come on up. Okay, you are Shannon Ordwine.
Yes, sir.
And you got these cases. And let's make sure. All the. One, two, three. 4, 5, 6 cases, right?
Yes, sir.
Cause number is 22-40911. This is a first degree felony of murder, 23 CR 30. A first degree felony arson, 23 CR 1194. Third degree felony of assault on a public servant, 23 CR 1195. Assault public servant. 23 CR 2207, a state jail felony, burglary of a building. And finally, 23-413-64, third degree felony of assault, family violence by choking. Each of these indictments also similarly alleged 3 prior convictions of aggravated robbery in paragraph 2, assault on a public servant in 2012, and assault family violence also on September 24th, 2012. Let's make sure those are.
I don't think they are alleged in the burglary case, Judge. They might be, but they are. Okay.
And 6, they are similarly alleged in each of those cases, and as you probably intimately know, they in sequence allegations of the aggravated robbery in paragraph 2, and then 3 and 4, the assault on a public servant and assault family violence, or convictions on the same day of 2012, but they are in sequence so that these offenses alleged in paragraph 1 in each case will be enhanced to habitual felon purposes. So as so you're looking at minimum 25 years to life imprisonment if all of this is proven true beyond a reasonable doubt. And 40911, the murder case in 2330, the arson case, first degree felony. And 231194, the third degree felony of assault public servant. And 23 CR 1191, the third degree felony assault public servant. The 23 CR 2207, however, was a state jail felony. I'm gonna put that aside. 23 41364 is a third degree felony, family violence. And if found guilty, you're looking at the same 25 to life punishment range of the other four. So 5 of these 6 have that punishment range. 23 CR 2207 is different. It's a state jail felony and it's in sequence. So if you were found guilty of this state jail felony of burglary of a building, if it was proven paragraphs 2, 3, and 4 were proven beyond a reasonable doubt in punishment, then your punishment range would be a state jail felony conviction, punished though as though it were a second degree felony. So you're looking at no less than 2 nor more than 20 years confined in prison and a fine up to $10,000 in that case. So do you understand what you're facing in each of these cases? What is this? Something the defendant filed?
That's his original request for the investigator, Judge.
That's
or
that's request for state's intention to use evidence of.
I see, Judge, and we owe him that notice, and I'm working on it. I'm going to file it and serve him with it.
When will it be done?
I could have probably filed it today, but we ran late this morning, so I didn't have a chance.
There was
Okay.
a order attached. I know.
There's no order necessary. We've been served with notice. We have to give them experts in any extraneous.
Okay, what about this motion for appointment investigator? I granted that back in September of last year for Mr. Reynolds. What, did he do anything
No, sir.
to get it done?
He was replaced shortly thereafter.
Actually, before.
Okay. Do you want a private investigator to help you?
Yes, sir, I do.
All right. Well, we're gonna have to, anybody in particular?
I made some phone calls. I didn't know exactly what all I needed from the private investigator. Before I came here, I was hoping to find that out today.
I can't. I don't know. You got a copy of the motion for appointment. Yeah, let's see. It says in paragraph 3, necessary to ensure defendant receives effective assistance. That's just generalized. There's nothing specific it's asking for. It's just a general statement of, which is what defense attorneys generally file. They're not specific because they're just not that way. They like to be general.
Mm-hmm.
But I will appoint somebody.
Licensed is what the motion says.
Say that again?
Licensed is what the motion says and what the order says.
Say that again?
Licensed is what the order and motion says.
Okay.
It must be a licensed private investigator.
Yeah.
Not that, again, I'm not supposed to be.
Yeah. Well, that's the only ones I would choose.
I understand. I'm just saying that is the qualification.
Anyway, I'll get with them and get somebody we've got a list somewhere. And it'll be somebody here in Jefferson County to help you. And I'll call them and see what they're able to do in fulfilling the appointment and get them to talk to you so y'all can talk about what it is you wish on your behalf. You still want to represent yourself, correct?
Yes, sir.
All right. And what is going to be done is an attorney will also be appointed to help you if necessary. And you don't even have to sit in it. They don't have to sit with you. They'll sit there. And if at any time you change your mind during the trial, they'll be there. Okay. To advice, you can seek advice. What I want to do is get an attorney appointed as soon as possible, and then get them. I want a hearing in 2 weeks to make sure that they're going to meet with you and see what they're going to need to do to prepare for trial. And then we will set it for trial with more information about what they need. Which one do we try first?
Judge, it'll be the murder. Now, I've talked to Mr. Ardwan because he has been coming over to the court while the court was on break and reviewing his discovery. We will need a 2-week time to try this case. I've got over 30 witnesses. So I did kind of do a little bit of upfront work and talk with Ellie, and we think there might be a date in September where there's not a trial date the week after. There's not a trial the week after. That's my thinking is that,
When is that?
you would not, it's September 22nd.
Okay.
That way we could take up 2 weeks.
Right. I think historically your preference has been not to block, another jury if we can. So that's what I think we were looking at.
Okay.
And that way, if there is another attorney.
Okay. Then that's our plan.
Before then, we will also need a pretrial hearing where Mr. Ardwan can have any motions he wants considered submitted, and the court can rule on those beforehand.
May I ask how long the investigator will have to search for witnesses?
A reasonable amount of time. That's what the statutes and the law says, a reasonable amount. Everything is circumstance specific.
Right.
One case is different from another. And I'll let y'all talk and figure out.
And in the meantime, Judge, Mr. Ardwan still does have discovery and media that he's reviewing. He has not gone through everything yet. He's requested media that we're providing him,
Okay. Let me, what are you asking for in this handwritten motion?
Which one is that?
I don't know. I got this one.
I believe that's notice of extraneous.
Okay, what do y'all, intention to use evidence of extraneous offenses at trial?
Yes, sir.
Well, we know there are 5 other indictments. So what's the state planning?
I will give him a written notice, Judge, but I plan on using the other alleged offenses that occurred while he was had a warrant out for this murder, including the evading with a motor vehicle in Lufkin. But I will give him a written notice and we'll serve it to him in person. That way he, has a fair opportunity to look at everything. And
when are you going to do that?
I could have filed it today if we had finished up court a little earlier, but we ran late today, so I'll get it in the next few days. And I think Mr. Ardwan is going to probably be over here again sometime soon to continue reviewing his discovery. So we will give it to him then. Is that okay?
No, that's fine. Let me know how soon I'll be back.
I want to talk to him because I know there's no court on Friday. So maybe this week.
Thank you.
I could get that done.
I was going to see about tomorrow as well. I think court doesn't go in the afternoon, but we'll see.
Okay. Okay, we're gonna have a hearing in 2 weeks.
That'd be fine, Judge.
And see where this investigator is with you. And we'll try to get somebody in the next 24, 48 hours. Okay, anything else on this? No, sir. If not, we're in recess on this, these cases. What else do we have? Is that it? Tomorrow is great.
This is.
Because it doesn't do any good if it takes you 100 years. That doesn't help the victim. But paying the loss back fixes financially to a large degree that helps defendants too in resolving their cases less seriously than it would be otherwise. Isaiah Mochison, 25 CR 428. What are we doing on this? Why?
It's a case that I discussed with you.
And Your Honor, I advise Mr. Dusler, there were, the defendant's brother is also in jail for murder, and this tampering arises out of that murder. The defendant was on a jail call on April 17th while on bond, and he's on three-way call with his brother who's in jail, as well as his sister, Amaya Moore. And he's asking his sister for
who's he?
The defendant. He's asking his sister for some weed, money for some weed. We would just ask for a drug patch. We would ask for that he be tested today, as well as when he was in jail, he stated that
the defendant.
Yes, Your Honor. He stated that he would kill an individual by the name of Peanut if he doesn't bond him out. While he was on the phone with his sister and Maya Moore, he also stated that he would cut off his ankle monitor if you put him on home confinement. I don't believe he's on home confinement, but I would request that that he be on there, and I believe he does have a GPS monitor.
Do you? Yes, sir. Where is it on it? On your ankle?
I'm all right.
Well, what's he talking about? I mean, we're listening in to phone calls. It's what foolish person when you call, it states, I believe it warns you could be recorded. And we do. All of them. How foolish can you be by saying things like that are going to get you in trouble now, in worse trouble? You're looking at up to 10 years in prison for this. And all of that you're talking about, all of that can come in at the trial. That can be admitted. You think a jury's going to find that amusing? Yeah, they wouldn't take a minute to find you guilty. Well, that's what you backed yourself into by foolish behavior. You're not the only one, but that's what gets you into jail or prison, acting foolish. All right. What's his bond right now? You're not walking out of here from what I've just heard. Your bond's going to get raised. You're going to get tested. You're going to jail. Then y'all can celebrate together if that's what you're going to do with whoever it is. But that's what your choices have gotten you to.
$25,000.
Yeah, that's not enough for that kind of behavior. Have a seat. Deal with you later. All right, next is Brandon Foray. He just went to the restroom. You can sit down, thank you. Escar Herrera.
He is here, and so is Erica Bird.
Edgar Herrera.
What?
25 CR 122 is called Edgar Herrera. He doesn't speak English?
No, sir.
And please tell us your name for the record.
Erica Bird.
And Ms. Burge, I understand you're going to translate today. You are fluent in English and Spanish.
Right.
Have you been a translator before in court cases?
Yes, Judge.
Okay. And raise your right hand. Do you solemnly swear or affirm that you will truly and accurately translate from Spanish to English, English to Spanish during this hearing, which is Mr. Herrera's language? He speaks Spanish, and make sure that the translations are done correct so that we can have for the record the English translations and that it is clear and accurate. Will you do that? So help you God.
Yes, Judge.
Lower your hand. And you are charged with the third-degree felony of evading arrest or detention with a motor vehicle, which carries with it up to 10 years in prison. Serious. Do you understand? Ms. Minaldi is your attorney. Very good lawyer. Listen to her. She gives good advice. What are we going to do then?
Just, we were actually here for a designation today. Last time he expressed that he was going to hire an attorney. He has now expressed to me that he is unable to do so since he lost.
Are you able to hire a lawyer?
Not right now, I lost my mother this week, they called me, for a new job.
What were you doing?
Estaba haciendo un video. Work in the refinery.
How much were you making an hour?
Estaba payando a la hora. 22.
22. That's $40,000 plus. That's a lot of money. Are you a citizen of the United States? Are you a citizen of the United States?
Yes.
You don't speak English?
No habla inglés. No.
You have to be able to speak some English to be a citizen,
Ciudadano.
to pass the citizenship test.
Ciudadano.
How did you do that?
Mande. I was born here in Baytown.
Okay, but you were born here. You don't know English? Surely you have to be able to speak it. In the refinery, at the refinery, for safety reasons, you have to be able to speak English in an emergency. Correct?
Yes.
How long have you been living in the United States? You were born here.
So when I was small, they brought me back 2 nights ago.
Okay. Well, it comes in handy in America to speak English. Okay.
Yes.
Oh. What do you mean? Yeah, these things are always. There looks like an affidavit of indigence that was prepared somewhat. It's signed.
So, we did one last time, but we didn't have a translator available, so he wasn't able to fill it out. I have given him a new one today so that he can really fill it out. And Miss Burge has helped him with that.
All right. What do you want to do next?
I can have forward reset on him to make sure that he can review his discovery and we can.
Okay, what's the offer on this one? This one now.
Probation officer, judge.
That sounds promising. The bird.
Yes, sir.
Move on. Move on. Let's move forward. We're going to reset this for 4 weeks. Listen to your attorney. She's a very smart lady. Do you have that? Hold on, everybody. Settle down. Do you have the indigence affidavit done? Okay, make sure that's done. Thank you. Get a resetting. Ryan McGowan. Come on up. 25 CR 333.
Yeah, I think they're actually.
What is that? Indigent? Are you filling it out? Is it done?
Yes, sir.
Let me see it.
He has not been sworn to it. I want to see the.
There's no response, Your Honor.
There's no response to that name called in the courtroom. No response to the name called into the hall. Defendant has failed to appear. Warrant shall be issued for his arrest.
$15,000.
Bond is revoked. 15,000 is now $30,000 plus he must have a GPS device. Rodney Broussard. He's in
He's
custody.
in custody. Can we pass on that?
No. What are we gonna do?
Well, I need to go back there and talk to him. I hadn't had a chance to talk to him. Just to make sure we're on the same page. But that's a bond issue, so.
No, we got a motion to revoke probation announcement, right? I mean, we gotta dispose of cases.
This is the probation.
And the probation officer is here. The next,
I think the state's recommendation is after talking to the probation officer.
yeah,
What we'd like to do is he's been in jail for 80 days. He had been in a different parish when he wasn't reporting. He did, after he got out of jail, he still did not report. So what we would like to do is do a 60-day jail sanction. He's already served it and then have him do safe P as part of probation.
what's the other two cases all about? Oh, these are all NPRP?
TRPs, they're all together.
That's correct.
All right. Why don't y'all see if that's the
I'll
way
see
to do it? That helps him and we can move these three, get them
Sounds
moved.
good.
Okay.
So that.
DeMarcus Jones, while we're here.
Marcus Jones, the president, courtroom judge.
Mr. Jones, come on out.
Have not had an
Marcus
opportunity,
Jones, please.
not had an opportunity to review all of the discovery, so we're asking for another answer. It's a fairly good case.
Responsibly, and you let your passion get the best of you, which happens to all of us from time to time. So please see the probation officer and you will begin probation. Thank you. Anything else that is sound?
No, Judge, I do have Rodney Broussard.
Yeah.
And it's gonna be a probation amendment. So we don't have paperwork, we didn't turn anything in.
Okay.
But he agrees, and I don't know if you want to bring him out or I'm just wanting to meet with.
Who is it?
Rodney Broussard. He's gonna agree to safety and a 60-day jail sanction.
Okay, this is an MTRP. Yeah, bring him out, please. Rodney Broussard, thank you. Probation officers. That's it. All right, we call two matters, 23 CR 1813 and 23 CR 2223, the state of Texas versus Rodney Allen Broussard. That's you?
There should be a third, Your Honor.
A third one.
MTRP. It should be 2512 and 40.
24 CR 220. There are three first amended motions to revoke unadjudicated probation. The defendant is on probation for evading arrest or detention with a motor vehicle in each of these cases, right? Third-degree fire. The first, well, these are failures to report. But look on. There was a motion to revoke probation filed on February 20th, which alleged those first three grounds of failing to report August, September, and October 2024, failing to provide verification of community service hours, failing to pay court assessed fees. And then later on, the first amended gets filed on March 27th of 25. Like 5 weeks later, and it alleges failing to report to the probation office. All right. In August, which is already in the first one, December of 2024, which is a new month, January and February. So we have allegations that he failed August, September, October. Nothing in November.
He was in jail.
He was in jail. Then was he released from jail? And then December, January, February. Half a year. How much time does he have credit on all this? Please.
He doesn't.
Care about that, I'm gonna wait. I'm sure.
Okay, while we're looking that up. What's the deal?
The agreement is for him to go to sick pay. And
What's the deal? Why is he not reporting? Because the one thing you have to do is report. I don't care. I mean, I do care. You can fail to do everything else with good reasons, but if you fail to report unless you're physically unable, then you're not on supervision. And I open the door for one, I open the door for everybody. If there aren't consequences that are severe, you got to report, you got to show up. If you don't show up, you're marked absent and you're gone. And probation is a waste of everybody's time if you're not going to appear. We can't be searching for them. How many, 5,000 people? Roughly 5,000 people. Whatever's good for you, if they can go. I want the Rodney Broussard rule. I'm going to not report for a while, and then when y'all catch me, then I'll be able to get out of jail free. You don't have 166 days. 5 months. All right. So what was the deal? I mean, he had the first one, then he's in custody, then he gets out and he just doesn't do it again?
Exactly.
Well, how many chances do you get?
Well, the first one, we have been August, I actually got picked up that day that I was going to my probation.
Yeah.
Warrant in.
Whatever.
No, really.
Everybody says that. The point is you weren't there.
Yes, no.
but he had a warrant out in Louisiana and he was arrested. He was in jail.
Yeah, it was literally unfortunate circumstances. And when I got out. Sorry.
Okay. Well, if you're in custody, you can't report. I mean, it would be a defense. But when were you not in custody? When were you free and didn't report? That's what I
I got
want.
out very end of December. Like.
So
2 days
August,
before Christmas.
September, and October of 24, you're in custody?
Yes, sir.
Is that right? Well, why would we file that if he's in custody? He can't report if he's in custody.
I believe he was in custody August and September.
No, I wasn't, man. Got picked up August 14th.
Which she'll know.
If he was in custody somewhere else, Judge, I'm not gonna have that information.
Where were you in custody in August?
Louisiana. He had a Louisiana warrant.
He was in custody here.
No, they picked me up here August 14th, for the Louisiana warrant.
And then you went to Louisiana in December, was there for a couple of days, they let you out.
I was there for about a week and a half. Then I got out right a few days before Christmas. And then the holidays and then January. So pretty much I looked like January from everywhere else. And then I missed
January and February. And then they immediately picked me up on warrant for that. Let's see, everything whenever I got out, they have a place to stay, everything, you know, it's not the right thing, everything. I had to do means of transportation due to situations I put myself in. Because of the unfortunate thing that none of it's, you know, really don't have a place to stay or really count on. I took myself in to report, go to make those calls or to make sure that I was able to go to push it. It was failures on my end, but also through some very stagnant circumstances. That's where it fixed it. That's a good environment. That's really.
It was in September when I talked to your brother. He was bringing you up in the program. No, it's September 13th. So you weren't in custody.
Could be off by 1 month.
Yeah.
Okay, what's the answer? What months did he fail to report?
January and February 2025. For certain.
And he got out in July. He got put on probation in July 24.
Yes, ma'am.
And he did not report in August and September.
I know, but if they're in custody,
Yeah,
they
but
can't do that. And that's the question is, it seems, I know what he's saying, what we're saying, but it's not
August
matching. I want to know what the truth is. And that's why I want to know what is accurate.
It's possible he was in custody in August. It's possible he didn't report in August. We don't have that exact date, but he was released in December. The amended.
How often was he supposed to report?
And well, he went to his initial intake in Beaumont, then he never reported to me. So I've never actually seen him in the office, but he should be reporting at least every month or 2 months. When he
But
got
they're
out.
ordered to like once a week, once a month.
Mhm. But I never saw him to get an assessment to see where he was gonna.
Oh, he absconded from.
Before he ever saw me in office.
Explain that.
Well, like I said a minute ago, he was picked up.
No, he hadn't been picked up for half a year. He's been available to report.
Since
How many times since you were released in July, how many times have you been to our probation office?
One time.
One time?
Yes.
One time?
For initial intake.
Yeah.
One time
End of July.
in July.
End of July, enrolled into the probation program.
Okay. It's May.
But then in August, I was picked up and I'd gone to jail.
So you've been on probation for 9 months and you only reported at the beginning?
The very first report after he got put on probation.
9 months you've been in custody?
The judge.
No, I want to know that. You lie to me and you're gone.
No. Your Honor.
Go ahead. Try to trick me. You're gone. I got 3 cases here. And you're looking at what, 10 years on each one? Go ahead. Try to fool me. You tell me in 9 months that you hadn't been able to find your way to the probation office?
He was in custody for 5.
I want to know if he was in custody for 9 months. If he was, if that's fine. But if he wasn't, shame on him, because that's what I'm being led to.
That's the dates that he was in Jefferson County.
In Jefferson County, it was September 18th to 12/24. So that's a little less than 3 months. Then he's in Jefferson County, 3/25 to 5/25, May.
That's to
Today. So then we've got from 12/12, well, he was released in August, you said? Or July?
He was put on probation at the end of July.
Okay, so we have something in August we don't know about. He never reported in August at all. Then he gets put in our jail on September 18th. He's released on 12/12.
To go to Louisiana, but he was only stayed about a week and a half in Louisiana.
Okay.
So he failed to report January, February.
All right,
And August.
April.
August, January, February. Okay, 3 months. Is that fair? It's fair. But you can't do anything else, you gotta report, or you're AWOL. You ever been to the military? When you go AWOL, they arrest you and you're in the brig. They don't put you on the front lines, you're in the brig. But you got 3 cases here. And what was going on in Louisiana?
It's the same case.
It's not the same case. It had to be a different case, sir. What happened in Jefferson County, Louisiana doesn't have any responsibility over, we do. What happened?
What he's saying, Judge, is that he evaded police in
The
Texas.
same thing?
Into Louisiana and evaded those police in Louisiana. Same day.
Do we have a problem learning a lesson?
Yes.
Okay, so it says. What's the status of the case in Louisiana? Mr. Galmore, what's the status of
I
Louisiana?
don't have a judgment or anything from Louisiana. What was the outcome?
Yeah, I went there and took it part and put me on probation. I'm on probation. It started in January.
Okay, I think I know. So what are we doing then? Now, what do we want to do? I'm not talking about you, I'm talking about this, the state and the defense.
I want to let him go to safety and see if he can be better this time. He was only on probation really for a couple of months. He got out of jail. He didn't report. He should have definitely reported. But I'm hoping that if we send him to safety, he can continue all 3 of these probations and his Louisiana probation. And if he doesn't, we'll revoke him and we'll sentence him to prison.
That's pretty.
Okay. All right. What we're about to do is what's going to be called the Rodney Broussard rule from now on. You get to do this and you get a chance to go to safety. Is that what we want to open the door? What's good for him is good for everybody. Is that the message we want to send? You can scamper out for a few months and we're here to help you. Okay. Do it. No, we've got to force you to do the right thing. I'm reluctant to open that door for everybody because that's what I'm going to do. But I'll do it. Everybody gets this then. All right, on these first amended motions, the state, you failed to report in allegation 4 in each of these cases. Is that true or untrue? Are you pleading true to that voluntarily and because it is true? You understand that plea of true?
Yes.
And knowing plea of true is enough to grant a motion to revoke probation. The probation can be revoked. You can then be found guilty and sentenced up to the full range of punishment. Knowing that, do you insist on pleading true today in each of these allegations?
Yeah.
Right. In each case, 1813, 2223, and 2222. Okay. Even though there's enough evidence to revoke, I'm going to continue you on probation. And there will be terms and conditions of probation, which will include an additional term of entering and successfully completing the substance abuse felony punishment facility. Cases. Sign those. Those are all the three cases. You will be continued on probation and we'll see where that goes.
Thank you, Judge.
Here. On Anthony Owens, so that you come on up, sir. On Mr. Owens, we're going to convicted though. If you're convicted at trial, that's a forever conviction. It's not like deferred where you're clear.
Yeah.
You just need to know there's a big difference between a jury cannot give a deferred probation, only I can. And that's no longer available for you. Keeler Maldonado. What are you going to do on Mr. Maldonado? Here. Come on up. You're, what are we going to do on this one, David?
On Mr. Maldonado requests this case be set for trial.
Well, what was the offer on this one too? Was this a deferred?
No, sir, I don't believe that was not. This was a PDC time, but it's just say to find the file.
I need I think I got it. Hold on. No, I don't.
Here, I got it.
No, he's getting more and more.
What's-
fun, making all his fun.
Are you working somewhere?
I'm working with my cousin right now, landscaping. I'll be going with him 2 to 3.
Well, how much do you make?
100 per yard. Whenever I go, I got his car.
What's his bond on this case?
$30,000.
Who posted your bond? You did? Well, yeah, somebody posted a $30,000 bond to get you out of jail. Who did that?
Sure.
You don't even know? It wasn't you though, right? Why not? You're not an adult taking care of your problems? Somebody else is? You're in a mess. You're looking at life imprisonment. Do you know that? Do you understand and appreciate that? Do you? You're looking at life imprisonment. You can't get deferred or unadjudicated probation in front of a jury. In fact, whatever sentence you get for an aggravated robbery, it has to, 50% of it has to be served in prison. So if you get 50 years, you got to serve 25 years at least before you're paroled. You understand how serious this is? Do you? But you don't even know who bailed you out of jail?
Oh, who bailed me out? Cousin.
Your cousin. Who was your cousin?
Anthony. I think that's his name. They call him. I think it was Anthony.
Okay, what's his last name?
Second drill, what this guy's getting.
You don't even know the name of the person who is a relative of yours who bailed you out? What kind of family is this? Y'all don't even know each other's name?
Sure, I just don't know his last name.
Probably was real.
Have a seat over there. Okay. We'll get back to him in a little bit. Okay, David, on Venetia Mims.
That'll be a plea, Judge. I don't ever signed up yet.
Okay. Miss Mims, he's got to do some paperwork. If you can get that done as soon as possible. Thank you. Anthony Owens. Just stand by. She's going to do some paperwork and work with you here. Thank you, ma'am. Anthony Owens, what are we going to do on Anthony Owens?
Anthony Owens wants this case.
Okay, David, on Venetia Mims.
That'll be a plea, Judge. I don't ever signed up yet.
Okay. Miss Mims, he's got to do some paperwork. If you can get that done as soon as possible. Thank you. Anthony Owens. Just stand by. She's going to do some paperwork and work with you here. Thank you, ma'am. Anthony Owens, what are we going to do on Anthony Owens?
Anthony Owens wants this case set aside.
Where's Anthony Owens? That's you? All right, you have a seat over there too. Right over there. Jacali Palmer.
Judge, if I could speak to the prosecutor, District Court, about that. He's like to withhold that for a little while.
And Dalen Parkerson.
Dalen Parkerson, Judge, I'd like to have a reset on that. There's some additional investigation.
How much time do you need? 4 weeks?
4 weeks.
That's all? Okay. That's reset. Darius Smith. Darius, get him a sentence. Darius Smith.
Darius Smith would also like his case set for trial, I believe.
Who goes to trial for unlawful possession of a firearm by a fellow?
I'm not trying to put it, sir. I just know Mr. Rose is a busy man, and I was just trying to get the case resolved.
Oh, you were.
Well,
He says he.
I'm not offering information.
okay. Schools and all parts.
I've got Ty Cooley. That's John West. Where else? Anthony Owens.
Judge, please wait to talk to Ms. Road.
What are you gonna do on Anthony Owens?
Let me make sure, Judge.
They have Kenesha Mims, Anthony Owens.
Kenesha Mims is plea, and I just signed her up, and I'm trying to get out of that. Let me just make sure that I'm not confusing him. Mr. Owens, I think would like to have it reset for a couple of weeks. I have him down as a trial.
Where's Mr. Owens?
He's outside.
He needs to get out. Come
Yes,
in
sir.
here. Mr. Solano? Is that you?
No.
Yes.
Can I go talk to my cousin?
No, no, David's gonna, is David your lawyer?
Yes, sir.
Yeah.
He's gonna be a plea. Yes, sir.
Okay. You need,
I need to sign him up, Judge.
I understand. What are you sitting in the box for? Did I put you in the box?
No, I asked him to go there and sit down.
Okay. What do you want him now? Where do you want him to go when you talk to him and?
She cleared it. You got to leave all of it. Okay, just relock it. Judge, if I could take him out front, that'd probably be the best place.
Okay.
All right.
Well, okay, I've got Mr. Solomon. And I've got Mr. Solano. What do we do?
Mr. Solano will be a plea.
Struggle here. Then I have Kenesha Mims.
That's gonna be a plea.
That's
It's
a-
Solomon, we need an update on.
Right, see the probation officer, thank
He
you.
learned his lesson.
Okay, then I have, let's see. Here we go. Anthony Owens.
Yes, sir.
What are we doing with Mr. Owens?
That's a plea.
Okay. We don't have anything in a queue.
Oh, I'm sorry, Your Honor. it is not a plea. I think it's just the court wants them to reset the case and discuss it with me.
Is that right, sir?
Yes, sir.
Well, what's the offer? Do you know?
4 years to.
It's 4 years TDC, Your Honor, and he has no prior conviction.
Is that,
Yeah,
is,
still
who's on that?
He has a prior, he does have priors.
What do you have on it?
He has, it's in possession of a firearm by a felon, so obviously he has a prior.
He has an assault on a security officer for which he did 2 years. That he was originally given deferred adjudication for, and he also is currently on federal supervision.
No.
For what?
Well, you were on federal supervision.
You say correct. But
For what?
A weapons charge.
What is the weapons from?
I don't remember exactly. I was on Pacer.
What court? What district? Eastern District of Texas? Out of Baltimore?
To be unlawful transport of firearms.
What was the sentence on that?
36 months. With 18 months supervised release.
Yeah. He went to federal prison and then there was supervised release afterwards.
Yes,
Yes.
That's
Total of
like
5 years.
parole.
So what's the offer on this one?
4 years TDC.
When was that federal crime committee? When was he sentenced for that?
2020.
Okay, that's a prior conviction. That isn't alleged though,
No, it is not. One of the-
Sure.
but it could be. If they want, if they allege it, then it moves it up to a second degree felony, if they could add that, yeah. What do y'all? Is that what you want? Looking at up to 20 years? I don't think so. So what's the offer on this?
The offer was 4 years TDC, I believe.
Yes.
All right. And in front of a jury, you're not eligible for probation, so you can't get probation in front of a jury. What are we gonna do on this?
Can I go to trial? Can I take it to trial?
Yeah, I'm gonna give them time to re-indict it and add that prior conviction. And yeah, you can go to trial. You're not eligible for trial, but you're looking at 20 years, up to 20 years. That's your business. We'll do it. That's what we'll do. That's what we'll do. And
I believe, Judge, that's what he wanted to do.
all right, then let's set the trial.
Originally,
But it's gonna they're gonna have a chance to re-indict it and add the prior felony.
So the prior
Federal.
felony, the federal, it counts to.
Yes, all felonies, federal or state count, yeah. It doesn't matter. It says a prior conviction, which means in any state or the United States District Courts. Then I was in the United States Attorney's office for 20 years, and I know how that works. It's never forgotten. It's not in the past. It's always hovering. And I'll give the state a chance to re-indict, but we'll set it for trial, and that's what we'll do. And we'll let a jury decide, I guess, if that's what y'all want, okay? And there's no deals. When it comes back, we're gonna move it fast. We're gonna set it for trial quickly so we can figure out where his life is gonna go. And that's it on that. Orlena Solomon?
Oh, yes.
Orlena Solomon?
Judge, Orlena Solomon is here. I believe that Mr. Owens wanted to talk to the court about another attorney.
You don't have a right to pick an attorney. David Grove is
Dalen Parker's son, Judge, I'd like to have a reset on that. There's some additional investigation.
How much time do you need? 4 weeks?
4 weeks.
That's all, okay. That's reset. Darius Smith. Darius, get a reset. Darius Smith.
Darius Smith would also like his case set for trial, I believe.
Who goes to trial for unlawful possession of a firearm by a
Oh,
felon?
I'm not trying to put a trial, sir. I just know Mr. Rose is a busy man and I was just trying to get the case resolved.
Oh, you were,
Well, then you can- well,
he says he,
because-
I'm not offering information.
School to all parts.
what's he offer on? What's he offer on?
The offer on it is, 4 years, 4 years TDC.
Hold on, but I'm sorry, y'all are going a little fast. So is Mr. Palmer going over there?
Yeah.
Okay. And then Mr. Parkinson's being reset.
Right.
Okay, thank you, sorry.
Yes, I just.
It's not highlighted, that's fine.
Zane, you're still testing positive. You're not getting out until that changes. So you're taking it into custody.
Say is he lying with the fucking get back.
Again, Darius Smith. Have this conviction on June 7th out of Ellis County. So every time, so you commit a third-degree felony each time you're unlawfully possessing a firearm.
That probably, hold on, let me share the logs.
Yes, please.
Yeah.
What other
and-
convictions do you have?
I keep felony marijuana.
The one in 17 from Ellis County, right?
Yes, sir.
What else? That's it.
Mr. Newman, please raise your right hand to swear to affirm and the truth and the truth and the truth self you got. Need you to each of your right and right. Okay, please sit down.
There's a firearm underneath your seat, the driver's seat.
Yes, sir.
And what's your defense on this?
I had forgot it was there that morning.
That ain't, that's so what?
I understand, but I had took it for like.
It's an extended mag style where it's got 30 rounds, Judge.
See, you're not eligible for probation. You're not eligible even in front of a jury for a conviction. Prior felony conviction. I don't know if you understand that or not, so.
2.5 right now in school. I was just.
So what?
in school.
Yeah, you got,
Take care of
like, just like me.
Yeah.
What would I lose
Yeah.
if I commit a crime? A lot more than you. That's why
Yes, sir.
I don't commit crimes, but,
I understand.
um,
So I had got there from my home.
it doesn't matter.
I know.
It's illegal possession. I mean, it's,
They was trying to keep.
the lowest is 2. They can do 2. Yes. How much time does he have credit?
Judge, he thinks he has only a week. Probably not much.
2 days.
Hmm?
2 days.
Yeah.
Yeah. 24 CR 1771 is called the State of Texas versus Terrence Newman. That is you, sir?
Yes, sir, Your Honor.
With your attorney and the state's attorney. Does, Mr. Gamma, does the defendant waive a formal reading of the indictment and arraignment? Can we proceed in summary?
Yes, Judge.
In summary, sir, this indictment alleges that on or about August 4th, 2020, I'm sorry. Yeah, August 4th, 2024 in Jefferson County, Texas, you committed the third-degree felony of assault family.
Yeah, of course.
And thank you. Ms. Shannon. Darius Smith, please. 24 CR 1703 is called. You are Darius Smith, present with Mr. Grove, your attorney, and the state's attorney. Does the defendant waive a formal reading of the indictment and the arraignment here? Can we proceed in summary?
Yes, sir.
In summary, this indictment alleges that on or about May 18th, 2024 in Jefferson County, Texas, you committed the third-degree felony of unlawful possession of a firearm by a previous convicted felon. Do you understand what you were charged with?
Sir.
If convicted, you face a term of not more than 10 years or less than 2 years in prison. In addition, a fine may be assessed not to exceed $10,000. Do you understand?
Yes, sir.
An agreement's been reached in your case where you will be pleading guilty. Whatever sentence shall not exceed a cap of 4 years in prison. We'll order a pre-sentence report and come back after that is done, and then everybody gets to sound in, and then the court makes its decision.
Yes, sir.
If I follow this agreement, you have no right of appeal of your case. Do you understand?
Yes, sir.
I think you're looking at no less than 2, no more than 4 years confinement. You're looking at deferred or unadjudicated probation, and also regular probation can be assessed. So those are 3 options. I'm going to show you what's marked as State's Exhibit 1. Did you sign that document voluntarily? Understand it, discuss it with your attorney, or the contents true and correct?
Yes.
State's Exhibit 1 tendered into evidence.
No objection.
Without objection admitted. Among other things, this states you are mentally competent to enter your guilty plea. It's freely and voluntarily made. You know what you've been charged with. The indictment's been read to you. You've read it. You were guilty of the crime charged and any lesser included offenses. You were giving up your rights to a jury trial and the rights to the appearance, confrontation, cross-examination of witnesses. You were totally satisfied with the representation provided by your lawyer. All of this the state so help you God. Is that a true and correct?
Yes, sir.
The State's Exhibit 1 is made a part of the record for all purposes. And the court makes findings in support of State's Exhibit 1. And those findings are in accordance with the recitations in State's Exhibit 1 made a part of the record for all purposes. Pre-sentence report will be ordered. We'll be returning back and you'll get a resetting. Everybody will come back and sound in, and then the court will make its decision then. And please get a resetting from this lady. What is it, about 4 weeks?
I did June 20th. I'm sure Justin will have it ready by then.
Okay, I have some cases here. Ernesto Solano. Come on up. I don't have any
I'm gonna
papers.
send it right to you right now.
Okay. 24 CR 2406 is called. You're Ernesto Jesus Solano. Present, you have to speak out. So
I'm sure Justin will have it ready by then.
okay, I have some cases here. Ernesto Solano. Come on up. I don't have any
I'm gonna
papers.
send it right to you right now.
Okay. 24 CR 2406 is called. You're Ernesto Jesus Solano. Present, you have to speak out so this lady can. Yes. Okay. You are here with David Grove, your attorney, and the state's attorney. Does the defendant waive a formal reading of this indictment and arraignment? Can we proceed in summary?
Yes, sir.
In summary, this indictment alleges that, just go around here and I'm gonna talk to you while you're doing this thing, fingerprint. No.
No, sir.
Probably 2 hours later.
No, sir.
In summary, this indictment alleges that on or about June 30th, 2024, in Jefferson County, Texas, you committed a state jail felony of operating a motor vehicle while you were intoxicated with a child passenger. Do you understand what you're charged with?
Yes.
It's a state jail felony, which means if you face confinement in a state jail for any term of not less than 180 days or more than 2 years. Additionally, a fine may be assessed not to exceed $10,000. Do you understand?
Yes.
An agreement's been reached in your case where you would be pleading guilty, sentenced to 2 years in the state jail. That would be suspended. You would be placed on regular probation for up to 5 years. And fined $500. There would be terms and conditions of probation, which are normal and customary for this type of offense. Is that your understanding of the plan?
Yes.
If I follow this agreement, you have no right of appeal of your case. Do you understand?
Yes.
How do you plead to this, guilty or not guilty?
Guilty.
Are you pleading guilty voluntarily and because you are guilty?
Yes.
I'm going to show you what's marked as State's Exhibit 1. Did you sign this document voluntarily? Did you understand it, discuss it with your attorney? Or are the contents all true and correct?
Yes.
Yes, you have to speak out.
Yes, sir.
State's Exhibit 1 is tendered into evidence without objection.
No objection.
Admitted. I will find that here you are mentally competent to enter your guilty plea, which is freely and voluntarily made. You know what you've been charged with. The indictment's been read to you. You've read it. You were guilty of the crime charged and any lesser included offenses. You were giving up your rights to a jury trial and the rights to the appearance, confrontation, cross-examination of witnesses. You were totally satisfied with the representation provided by your lawyer. All of this is true. It states, so help you God. Correct?
Correct.
State's Exhibit 1 is made a part of the record for all purposes. Pre-sentence report is now waived.
Yes, sir.
I'm going to follow this agreement based upon the findings, and I find that the evidence supports from State's Exhibit 1 the indictment, and I hereby find you guilty beyond a reasonable doubt of this state jail felony of operating a motor vehicle while intoxicated with a child passenger. I'm following this agreement. You are hereby sentenced to confinement in the state jail for 2 years. That is suspended. You were placed on regular probation for 5 years. You must pay a fine of $500. You shall complete a DWI course as directed. There will be other terms and conditions of probation, which are normal and customary for this type of offense.
One more signature. I think I saw it.
Confinement on a DWI misdemeanor, you get what you're ordered, 10 days?
3 days.
Third, DWI with a child passenger, there's not any upfront time that they have to do.
There's no upfront on misdemeanor?
Well, under that particular statute, there's not.
Right.
For DWI?
For DWI.
What, on this case, what are we doing? What do we want? Anything recommended by the state?
Not for any upfront time, Your Honor.
Okay, then make sure you do better. All right, see the probation officer. Thank
He
you.
learned his lesson.
Okay, then I have, let's see. Here we go. Anthony Owens.
Yes, sir.
What are we doing with Mr. Owens?
Every day in the USA, people find themselves in court.
Kansas versus Destiny Rose Bookout. It's case number 2024 CR 517. James Watts again appears by Zoom, as does Brett Sweeney from the Butler County Attorney's Office. Destiny Bookout now apparently has been taken into custody and he appears from a judicial center, a Zoom location. This matter comes before the court at this time for sentencing. Ms. Bookout, this was scheduled for 10 o'clock this morning, but you were not here. We even waited for you to give you an opportunity to get here late and you didn't show up. Is there an explanation for this?
Your Honor, I was on my way here. I got stuck on the highway because there was a traffic jam. I got here about like 15 minutes after 10.
Well, that's 15 minutes too late as far as the court's concerned. We waited. You didn't show up until after the court proceeding was over, and the court had already ordered bond forfeiture, bench warrant, and a no bond hold. So I trust you've been held at the judicial centers in detention waiting for this hearing, correct?
Yes, Your Honor.
You're darn lucky, Ms. Bookout, that the court worked you in at this point. We're going to proceed further with your sentencing proceeding at this time. Again, noting for the record that the defendant had been convicted back on February the 18th of possession of methamphetamine, a level 5 drug felony. A pre-sentence report has been received. Is there any objection to the criminal history as stated in this report, Mr. Sweeney?
No, Your Honor.
By the defense, Mr. Watts?
Excuse me, Your Honor, I have reviewed the scoring with my client. We believe it is correct. We have no objection.
Court will adopt the criminal history stated in the report and finds that the criminal history score applicable to today's sentencing is criminal history score G, and the court will proceed further accordingly. Mr. Watts, do you know of any legal reason why sentence should not be pronounced in the Bookout case at this time?
No, sir.
Mr. Sweeney, are you aware of any such legal reason?
No, Your Honor.
Ms. Bookout, are you aware of a legal reason or any other good reason why the court shouldn't proceed further with your sentencing at this time?
No, Your Honor.
Court will proceed further then. Counsel, I'm not aware that there's been a motion for a departure sentence or any other type of sentencing related motion to take up. Does the state have any such motions to pursue?
No, Your Honor.
Does the defense, Mr. Watts?
No, sir.
Are there any victims or members of a victim's family present who desires to address the court in relation to the Bookout sentencing? Court finds no such persons present. So at this time, the court will ask for recommendations from counsel regarding an appropriate sentence for Ms. Bookout, starting with Brett Sweeney on behalf of the state of Kansas.
Thank you, Your Honor. Your Honor, the state is recommending 15 months in the Department of Corrections. Ms. Bookout is eligible for the 20% maximum good time percentage. As well, she would have a 12-month post-release supervision duration. She does have 44 days of jail time credit. She's currently on community corrections in Sedgwick County 22 CR 1496. There's a special rule that's listed on the face sheet of the PSI, and the state would ask the court to run this case consecutive to that 22 CR Sedgwick County case. She is a mandatory Senate bill in this case, at least. Even though I don't think that she finished all the Senate Bill 123 pre-sentencing evaluations, I think it's she does qualify. I think it's appropriate to go ahead and sentence her, obviously. The state would ask that the up to 18 months of community corrections probation be adopted. All of the standard conditions that include compliance with the Senate Bill 123 treatment. It sounds like she is doing some of that in Sedgwick County. Although in speaking with Miss Ashenfelter, it sounds like she's flunked out of inpatient treatment, which is where she was. And I mean, this is the information that I've been given. And that maybe that's resulted in a warrant as it relates to the Sedgwick County case. So it's kind of in an interesting position that Ms. Bookout finds herself in, where she's mandatory Senate bill, but she's already kind of on a similar path in another case, but not doing so well. I'll just leave that at that. As far as costs and fees associated with the case go, Your Honor, the state's not requesting a fine. We are requesting the court costs in the matter. There was a KBI lab report, so the state is seeking $400 in restitution. We're seeking $300 payable towards the Senate Bill 123 treatment, correction and supervision fees, and of course, attorneys and bids fees if the court finds those appropriate.
Thank you, Mr. Sweeney. Mr. Watts, your recommendations regarding an appropriate sentence?
Your Honor, this is a Senate Bill 123 case. The recommendations of the state are normal and expected for a Senate bill case. The one thing I will note is, as Mr. Sweeney put it, if she is struggling with her Senate Bill 123 issues over in Sedgwick County, she'll have an opportunity to get those issues straight in this case. But I guess I would put on the record, and for Ms. Bookout's benefit more than anyone else's, this is now a second drug felony. A third drug felony would result in a presumptive prison category. That's something Ms. Bookout ought to be well aware of as she goes forward. Judge, as far as the sentencing recommendations, I think mine are in line with the state's recommendations. Thank you.
All right. At this time, the court will address the defendant, Destiny Rose Bookout, personally and ask her if she has any statements that she wishes to make in mitigation of punishment or anything further that she would like to present to the court.
In regards to Mr. Sweeney saying that I flunked out of treatment, I was actually medically discharged, and I have a bed date for another inpatient treatment facility scheduled for tomorrow.
Oh, what facility is that?
Cherry Creek.
Okay. All right. Anything else? Ms. Bookout?
No, Your Honor.
The court will pronounce sentence in this case at this time. Court hereby establishes count 1 as the base sentence in the case for the offense of possession of methamphetamine, a severity level 5 drug, non-person felony, in which the defendant has a criminal history score of G, thus placing her in grid box 5, drug G. Court hereby sentences the defendant to a term of 15 months in the custody of the Secretary of Corrections of the state of Kansas. On this sentence, the defendant may earn up to 20% of good time credit and would be subject to 12 months of post-release supervision. No fine is imposed. Court does note that this would generally be a presumptive probation case. However, I do note the application of a special rule here. This crime was committed while she was on community corrections for another offense. The court will run this case consecutively to Sedgwick County case 2022 CR 1496. And even if the law didn't require it, this court would do it as a matter of discretion in this case. So court will run the case consecutively to the Sedgwick County matter. Court does note that in this case, the defendant had a high risk score on the WRNA, and that her SASE indicated that there's a high probability of a substance abuse disorder. This makes this a mandatory case for Senate Bill 123. Court does order the defendant to complete a drug treatment program and aftercare requirements for a period of up to 18 months. That will be the length of her community corrections probation granted by this court up to 18 months. Conditions being that she report to an ISO as directed, observe all laws, obtain an approved substance abuse evaluation from her community corrections officer, and abide by the recommendations of that evaluation. Ms. Bookout, I understand your plans to enter into a new program, but community corrections has to approve your entry into any new program. So before you enter,
Okay.
you need to make sure you get specific permission and consent from your community corrections officer. You shall not possess or consume alcohol or illegal drugs. At your ISO's request and at your own expense, you shall submit to random breath, blood, and urinalysis testing, perform any community service work pursuant to program requirements, gain and maintain employment suitably throughout your probationary term, notify your supervising officer of any changes in employment, residence, telephone number, or email address within 24 hours of any such change taking place, have no contact with any co-defendant, abide by any curfew or travel restrictions associated with community corrections programming, and to be assessed and considered for Senate Bill 123 by community corrections and follow the recommendations of the new substance abuse evaluation or the approved substance abuse evaluation. The court will also authorize community corrections to require the defendant to reside in a long-term sober living environment. Court will be assessing a felony docket fee, felony probation fee, community corrections fee, $300 reimbursement to Senate Bill 123 programming, and a $400 restitution amount to the KBI laboratory. Given this defendant's treatment needs, the court will be waiving any bids assessments in this case. Ms. Bookout, this court is empowered to sentence you to up to 60 days in the county jail as a condition of probation in this case. This court wonders if Senate Bill 123 is going to work for you. I wonder if you're really highly motivated to successfully complete a community-based treatment alternative, or if maybe you shouldn't just do your prison time to separate you from illegal street drugs, especially dangerous ones like methamphetamine. Perhaps an additional period of jail time would be necessary to reinforce for you that this is a serious matter and that you need to comply with rules. Is that going to be necessary here, Ms. Bookout?
No, Your Honor.
Court does note that this defendant has served 44 days previous jail time in this case. I hope that's had some impact, Ms. Bookout, as well as the 2.5 hours additional detention that you've received waiting on this hearing. Court will grant the defendant relief from any holds in this case, effective at the end of this court proceeding. However, I'm going to direct law enforcement here at the Judicial Center to check for any warrant holds that this defendant may have from other jurisdictions. Certainly not releasing her from other holds other than this case. As stated earlier, the court does award the defendant 44 days and 2.5 hours of jail time credit. At some point in the future, Ms. Bookout, you may have the right to seek expungement of this offense. Certain statutory limitations do apply. If you have any questions about your right to someday seek expungement, you can address those questions to a lawyer and I'm sure get your questions answered. Under certain limited circumstances, a criminal defendant may have the right to appeal their conviction to an appellate court having jurisdiction. If they are unable to pay the cost of an appeal, a defendant may request the court to appoint a lawyer to represent them on appeal and to direct that they be supplied with a transcript of trial court proceedings. Pursuant to KSA 22-3608C, Ms. Bookout, you, the defendant, have 14 days after this judgment in court to file any notice of appeal with the clerk of the district court of Butler County, Kansas. You do have the right to appeal this sentence if the court has ruled adversely to you at this hearing. I will remind you that there's prohibitions against a convicted felon possessing a firearm and if there are losses of certain civil rights, such as the right to vote, until your sentence is fully discharged. Ms. Bookout, if you've previously been married to methamphetamine, you need to get a divorce right away, because if you don't, if you continue to deal with dangerous drugs, you will end up in prison. If you'd rather be in the community working on any addiction issues, then you need to choose to do so and not relapse. Very, very important. All right, I do have Christy Ashenfelter from Community Corrections on this meeting at this time. Ms. Ashenfelter, what direction do you give?
Your Honor, if I could please get a breakout room with the defendant after the hearing.
It will necessarily need to be very brief and concise, but I think we can accommodate it. Ms. Ashenfelter. All right, and Ms. Bookout, you need to stay on this Zoom meeting after everybody else gets off and meet with the community corrections officer by Zoom and follow that officer's direction about what you need to do next to be successful on your community corrections probation, okay?
Okay, Your Honor.
All right, Mr. Watts, anything further at this time?
Only one thing, Judge, and I may have missed it. I thought I heard Your Honor announce 15% good time earlier rather than 20. I may have missed.
I think the legal amount would be 20% of good time credit.
I think so as well, Your Honor. I may have misheard it.
If necessary, the record is corrected. It's 20% good time credit.
1996.
Mr. Sweeney, anything further at this time?
No, Your Honor.
All right, Ms. Bookout, you have any questions about what we've done here?
No, Your Honor.
Okay, stay on the meeting and discuss matters further with the community corrections officer. I don't see her on screen anymore.
She's already in the breakout room.
Okay, join the breakout room.
Go ahead and bring it up.
Ms. Bookout. If there's nothing further, the Bookout matter will be in recess at this time. And we'll recess proceedings and stop the record at this point.
We are on the record in 13th Judicial District, the District Court of Butler County, Kansas. This matter does come on for our weekly traffic docket this May 28th, 2025. First on the docket, do we have Burke Bodie? On the record in 2025, TR 292, State of Kansas versus Burke Bodie. Jared Regier for the state. Is the defendant Burke Bodie here?
I got him here, Judge. Yes, Your Honor.
Thank you, Mr. Bodie. You are charged with speeding 105 miles per hour in a 55 mile per hour zone in a 55 mile per hour zone in Butler County, Kansas on December 18th of 2024. Looks like you were allegedly in the 300 block of Southwest Ohio Street, which I can take judicial notice is a 2-lane road, county road in Butler County, Kansas, where the posted and maximum speed is 55. You were allegedly going 105 miles per hour in a 2018 Jaguar. Mr. Bodie, I presume you're wanting a trial on this since you appeared today, is that correct?
Yes, Your Honor.
And your first name is Burke and your last name is Bodie. Do we have that in the right order?
Yes, ma'am.
Burke Bodie, all right. Now, Mr. Bodie, the scheduled fine on that is $503. And the court costs on that, strike that. The scheduled fine goes up to $503 for 100 miles in a 55-mile-per-hour zone. And then for each mile over 100, it is $15 per each mile over. Mr. Regier, I know there is a statute that addresses a limit of $500, but as I look at those statutes today, they seem to be inconsistent in that we have a statute that says infractions are limited at 500, and yet we have a schedule that has it at 503 plus 15 over. In the past, I have generally limited them to 500, but between now and the trial, we may want to determine if there's any rule as to which of those actually apply, since it clearly does say 503 at 100 over, and then the 15. But at least, Mr. Bodie, you're fine if convicted, either by plea or by trial, would be $500 at least. Now, again, it may be more than that, and the court costs on top of that would be 108. But that only is what the minimum I think you could have on that is. It may be the maximum too. I'll do a little bit of checking to see which of those statutes will apply, since they seem to be, in your particular case, contradictory. Let's see, which clerk am I with today? Am I with Jen?
It's Destiny, Your Honor.
Destiny, oh yes, it's Wednesday, Destiny. So could you tell me when we have available a trial date for this gentleman?
July 16th at 1:30, Your Honor.
July 16th at 1:30. Can you be back here for trial at that time, Mr. Bodie?
Is there any way to try to resolve this today? Because I showed up on the original court date that was on my ticket. The clerk's office, no one had my ticket, so they made a copy of my ticket and then scheduled me out. I'm trying in the process to get a service dog, and since this is an open court case right now, regardless of what it's for, it's holding the proceedings on me getting my service dog. So I would like to try to resolve this today if possible.
Well, like I said, if you want a trial, we have to schedule that for trial. Are you saying you don't want a trial?
I would like to either be, I guess, give you my side of it and have you decide today if possible.
Okay. Well, that is not possible for you to give me your side and for me to decide today. Mr. Regier would have to bring in his witnesses, and so he could present his side of it, being a representative of the state. So I'm going to set this for July 16th at 1:30 for trial. You must be here by Zoom. Make sure that you have any witnesses or evidence you wish to present at that time.
Yes, are minors considered witnesses?
They can be, if they are able to know the difference between right and wrong and understand the duties of taking an oath, etc.
Okay.
All right. So anything further, Mr. Regier?
Your Honor, I'm not sure if the court wants to address the issue of at least a possible defense attorney in this case. Beyond that, I have nothing further.
All right, and I just noticed, Mr. Regier, the fine is $495. I was including the court costs when I said 503, but it still says 15 for each over. Mr. Brody, we'll talk about sentencing possibilities further if we need to. I don't know how the outcome of your trial will be. I'm not going to be able to appoint him an attorney because it is still an infraction, even though the speed is alleged to be 105 in a 55. But Mr. Bodie, as I looked at that statute again, I was looking at the column. The 503 was the column of fines plus docket fees. The fine does say $495. It does have the language of the 15 for each mile over, but I no longer think that that's inconsistent necessarily with the statute. So I think your maximum is $500 possible fines and 108 court costs. But that's only,
One last question, Your Honor. Is there any way between now and then that I could possibly meet with the district attorney and try to resolve this before the trial?
that would be up to you and the prosecutor. You just have to call them and see what they have to say about that.
Okay.
Or you could
All right.
go.
Thank
to
you.
their office.
Thank you, Your Honor.
You're welcome. Or you could go to their office, but I have the traffic attorney tied up for the rest of the morning on this docket.
Okay. Thank you, Your
sir.
Honor.
You're welcome. You are excused and may go.
Thank you, Your Honor.
You're welcome. Deputy, who else do you have there?
Well, I have several people, but I have an attorney
Okay.
for Caden Campbell. He's
That's-
sitting in the hall. I think he's going to ask for a continuance.
All right,
I can bring
Who is
him
the
in real quick.
bring him in, and who's your attorney that you have?
Okay. I'll let him pronounce his name.
Good morning, Your Honor. Frank Ojal on behalf of Caden
Oh,
Campbell.
sure. Hello,
How are
Mr.
you?
Ojai. I'm good.
But I have an attorney
Okay.
for Caden Campbell. He's
That's-
sitting in the hall. I think he's going to ask for a continuance.
All right,
I can bring
Who is
him
the
in real quick.
bring him in, and who's your attorney that you have?
Okay. I'll let him pronounce his name.
Good morning, Your Honor. Frank Ojal on behalf of Caden
Oh,
Campbell.
sure. Hello,
How are
Mr.
you?
Ojai. I'm good.
Good.
Let's see. Let me find Mr. Campbell on my docket here. Shouldn't be too hard. We are on the record in 2024 TR 2786, State of Kansas versus Caden Allen Campbell. Please announce appearances.
Jared Regier on behalf of the state.
Frank Ojal on behalf of Caden Campbell.
And Mr. Campbell is charged with a registration or tag violation. How does he wish to plead to that, Mr. Ojai?
Not guilty. I believe he's already got that taken care of, Your Honor. He's stranded in Boise, Idaho right now. I got a call from his dad late last night saying, help. So here I am.
Okay, he did fail to appear at first appearance January 22nd of 25. A bench warrant of $500 cash or surety was ordered. You think he's gotten that and that taken care of?
I believe so, Your Honor. Like I said, I just found out about all this last night at 9:30.
It
So if
looks
we
like
could
he
get,
did. I'm sorry.
so if we can get this passed a little bit, then I can speak with the county attorney and see what we can do about getting this matter resolved.
Okay, it looked like he did post a $500 cash bond January 30th, 2025. So he has taken care of any warrants and made bond apparently. So we will set this, you want it set for trial then on a Wednesday afternoon?
That would be fine, Your Honor.
Destiny, do we have time for that July 16th docket at 1:30?
We do, Your Honor. It's our last one on that day.
All right, Mr. O'Giles, does July 16th at 1:30 work?
Actually, Your Honor, I've got a pretrial that afternoon in Sedgwick County.
All right, we'll go with a different date.
The next one we have available is July 23rd.
How about that one at 1:30?
July 23rd works, Your Honor.
All right, that will be the trial, July 23rd at 1:30. Of course, if you and counsel come to some conclusion between now and then, you can always remove that from the docket. Mr. Regier, do you want to be heard on this matter?
Very briefly, Your Honor, the state has no objection to setting this to trial on the July 23rd date. I have no personal knowledge as to any of the allegations presented by counsel for the defense on the record here today. I'm not, based off my notes, although counsel for the defense does appear on behalf of the defendants apparently today, my notes indicate that this is a case where the defendant has yet to actually appear before Your Honor in this matter, so I'm not sure if the court is departing from its usual custom about requiring defendants to actually appear, especially on misdemeanor charges.
Since he has retained Mr. O'Giles and Mr. O'Giles has appeared for him, and it is the unclassified misdemeanor in this instance, I will, as you say, depart from normal custom and let him off the hook today, but I will want him here for any trial or pleas. Mr. Ojai, he can always appear by Zoom, and you certainly can in future hearings as well.
Okay,
Thank you for coming over, but we can handle this by Zoom, I do believe. If there's nothing further, we'll be in recess at this time. Mr. Ojai, you are excused.
Your Honor, is the
Thank-
court also continuing the bond in this case?
Bond will be continued, yes, with the condition that he reappear in person for plea or sentence, or
Thank
plea
you.
or here trial.
Thank you, Your Honor.
Thank you, Your Honor.
You're welcome. You're excused at this time. You have any other attorneys or defendants down there, Deputy? You said quite a few.
I have 10 people here, 9
All
or
right,
10
then-
people.
Then let me look at the case that Attorney Mike Kinder is here on. Mr. Kinder, who are you here for? Well, you. I'm not seeing an entry of appearance, Mr. Kinder. Which case are you here? How to do that?
Okay, thank
Okay.
you.
All right, thank you. And you are entitled to hire an attorney to represent you. But I
Thank
can't
you, Your
appoint one on an infraction. Thank you. You may go.
Okay, next one I have coming up is Richard Longobardi.
Okay. We are on the record in 2025 TR 329, State of Kansas versus Richard Joseph Longobardi. Jared Regier for the state, Mr. Longobardi in person, and am I saying it right? Is it Longobardi?
Longobardi.
Longobardi, okay.
Yes, ma'am.
Oh, let's look at your charges, Mr. Longobardi. Sir, you're charged in count 1 with operating a motor vehicle without valid registration or an expired tag. This is an unclassified misdemeanor. Penalties could be, there's a maximum fine up to $2,500. There is a possible sentence of 30 days to 6 months. Those are extremes. They're usually much less results than that, but you're also looking at a Class B misdemeanor operating without proof of liability insurance. And that has a minimum fine that must be ordered if you're convicted. That would be $300, but it could be up to $1,000. You also could get up to 6 months sentence, but that's usually a probation unless you've got some terrible record of traffic violations. Because it is a B misdemeanor, you have the right to plead not guilty and set this for trial. Or you can plead not guilty, or I'm sorry, you can plead guilty and proceed today. You can plead no contest. That means you don't want to admit it, but you don't want to deny it. You'd still be found guilty, and we could proceed to sentencing. Before you decide how you want to plead, I will advise you that you do have the right to an attorney. You can hire any attorney of your choice, and if you cannot afford to hire an attorney, you can apply and see if you qualify for a court-appointed attorney. You also have the right to waive an attorney and represent yourself in these matters. There is that program I've been talking about, if you've heard me this morning about diversion, but I see you do have a traffic record fairly extensively dating back to at least 2004. So my, not only in Butler, but other counties as well. So my experience tells me you probably wouldn't qualify, but that's not my decision to make. But I just don't see you qualifying. How do you want to proceed at this time? Do you want an attorney?
No, ma'am, I don't need an attorney.
All right. Do you understand that you can hire one and that I can appoint one if you qualify for court appointed?
I do understand.
And knowing that, you wish to waive your right to an attorney and represent yourself?
Yes, ma'am.
Very well. Deputy, do you have a waiver of counsel for him?
That's
And Your Honor,
Yes, Mr. Regier?
Forgive my interjection, but the state's information appears to suggest there is another case involving this same defendant. Butler County 25 TR 0366. The state's understanding is that case is currently set for hearing exactly 1 week from today, June 6, 2025. I am not showing a first appearance has been conducted in that matter. I'm not sure if the court wishes to take up both matters at this time in the interest of judicial economy.
Well, let's take a look at that, Mr. Longobardi, while you're here. Did you
I
know
was
you
gonna
had-
bring that up myself.
Okay. Let me take a look at next week's docket as well.
I appreciate that. Thank you so much.
You're welcome. We will also take up case number 2025 TR 366, State of Kansas versus Richard Joseph Longobardi. Mr. Longobardi, you are in this case charged with count 1, operating a motor vehicle without registration or expired tag. And you're charged again with operating a motor vehicle without proof of liability insurance. These allegedly occurred February 7, 2025. At this time, the penalties are as they were in the first case that I told you. But if you get a conviction for no liability insurance a second time, the fine goes up to a minimum of $800 up to $2,500. It becomes an A misdemeanor. And the maximum sentence possible goes from 6 months to a year, although again, probation usually applies. So, and again, you have the right to hire an attorney or apply for court appointed. Knowing that, are you still wishing to waive your right in both cases and
Yes,
represent
ma'am.
yourself?
Yes, ma'am.
All right, then you would need to fill out a waiver in both cases if you're confident that's what you want to do. And I will tell you, this is kind of an aside. It's outside of my obligations and authorities, but if you have 3 serious violations, you can get your driver's license revoked by the state of Kansas Department of Revenue, and they would take your license for 3 years. So if you already have something serious on your record, and I see you do have some things that are significant.
May I ask what they are? Because I don't know of anything other than not having a seatbelt on.
All right, that's your Wilson County. BU 25366 we're dealing with today. The 329 we're taking care of today. All right. The other ones go back. You have a number of things on there, but they're like a 2019 improper turn approach. They failure to yield the stop sign, that goes back to 2018, speeding 2004. So you may not have that third on there, but it would sure mean you couldn't get another. But I'm not gonna give you any legal advice to hold on to.
I understand. Yeah, no, I appreciate it. I just wanted to know.
Okay.
Because I didn't know of anything else. That's all I was asking, because it's been years since I've really had a ticket in my estimation.
Okay, well, and sure understand.
Which, that's good. Thank you so much, ma'am.
What I'm giving you is not your official record. I'm just telling you what I see when I call up cases you've had filed in Kansas.
Gotcha. I understand. Thank you very much.
Official record would have to be obtained through the Department of Revenue, and they may have different things than I do.
I understand. Thank you so much.
You're welcome. So how do you want to proceed? You still want to waive your attorney, or do you want to maybe take?
Yeah, really, honestly, to me, I have no choice. I mean, I'm ready to proceed. I mean, I understand what happened and everything. There are extenuating circumstances. I don't know if anybody's going to listen to it or hear it, but I'm ready to go forward.
They might. That's why you sometimes want an attorney, because the attorneys have lots of experience knowing what's considerable and what isn't. And so
I
I'd be
understand.
happy to give you time if you wanted to talk to an attorney.
I'm fine. I have the
Alright.
biggest attorney in the world, so I'm good with it.
Okay. All right. I just want to make sure that you're well informed of your rights. So,
Yes, thank you so much, ma'am.
all right, you would need to, deputy, he'll need to sign one in each case if he hasn't. Do you have those case numbers?
He has.
All right. Now, let's look at 366, since I have that one pulled up on the screen. Okay. Now, sometimes attorneys, well, almost always, if you hire an attorney, they talk to the county attorney about negotiations and seeing if they can trade cases. And if you waive your right, I always give you, or try to always give you, the opportunity to discuss negotiations with the prosecutor, and it's up to the prosecutor if he wants to do that or not.
I would appreciate doing something like that because I really did come here to talk to the prosecutor once in the past. And the lady that was in his office that spoke with me said that because the guy that I was borrowing the vehicle from did not register the vehicle, even up to this date, because he had the vehicle repossessed from him, that she couldn't do anything with the ticket. I had to come to court no matter what. And that's why I'm here today.
Well, it sure sounds to me like you might want to consider talking to an attorney, but if you're bound and determined not to talk to an attorney, I'll see if Mr. Regier wants to talk to you. We have a full docket though, so I can't give you much time.
I understand. I'd just rather talk to the DA or whatever. I'm fine with that. I get it, but the attorney situation, I'm all right with all of it. Whatever happens is in God's hands. I'm good with that.
All right. Well, Mr. Regier, we have a full docket, but I would give the two of you a few moments to talk about these two cases. I don't know if a few moments is enough to talk about what he's looking at.
Your Honor, if I may,
Go ahead, please.
as a preliminary matter, is the court find that the defendant has successfully waived his right to counsel in both cases?
Yes.
Your Honor, for purposes of expediency, as the court has already indicated, we do have a full docket today. The state is prepared to dismiss 25 TR 366 in exchange for a plea to all counts in the 25 TR 329 case, as well as recommend probation.
There you go. That's his offer.
I'm willing to accept that.
All right. So let's focus then on
Thank you so much, sir. I appreciate your offer.
Let's focus then on
I've just had a bad run for the last year. It's the craziest life I'm living, but hey, God's taking care of me. That's all I can say.
Yeah, we do seem to go through things from time to time. Okay, so let's focus then on the one that we're actually originally scheduled for today. And that is 25 TR 329.
Yeah, he said no matter what, I had to get processed. So I'm good with that.
Yes, you do need to get your picture and prints taken on both cases.
I understand.
Okay.
I'm good with all that.
All right. N25 TR 329, how do you plead in count one to operating a motor vehicle on a highway or roadway open to the public in Butler County, Kansas on February 3rd, 2025 without a valid registration or with an expired tag?
Did the deal we just made, you said I had to plead guilty, correct?
I think that's what he implied if he didn't say it. Guilty
That's
or
what
no
I plead.
contest.
I will plead guilty.
All right.
I mean, I was operating a vehicle. I cannot deny that. And the vehicle I operated, I found out that day the tags were expired. And the vehicle I operated that day, I found out did not have insurance on it. Which is the craziest thing because I thought it was the law that everyone that owns a vehicle has to have insurance. But my friend loaned me a vehicle so I could get to work. And this is the payment that I have to pay because of his stupidity.
Yes,
And he was
the
an
law-
insurance agent.
Oh, my.
And he did all of it. He was my insurance agent and he did all of that because my car was stolen.
Wow. All right. Well, you're right. The law does require if you're going to be out there driving a vehicle, it has to have insurance and a tag
I
on
get
it.
it. Now I have insurance no matter what vehicle I drive. So I'm covered from now on.
Still have the same agent, just out of
I
curiosity.
do not have the same agent and
Okay,
we're
you
not
don't.
friends. I gave him back his vehicle. That's why it got repoed.
All right. And did this happen on the Kansas Turnpike,
Yes, ma'am.
I-35 mile marker 59 inside of Butler County?
That sounds approximately correct. Yes. I was on my way back to Wichita from working in El Dorado for the company I work for.
And you've told me you were guilty in so many words. Are you pleading guilty to count 2, the insurance, as well as count 1, the registration?
Yes, ma'am. There was no insurance on the vehicle.
All right. I will find that you're knowingly and voluntarily entering this plea to both counts, and I will find you guilty of each count. I will dismiss 2025 TR 366 on motion of the state per plea agreement and proceed to sentencing. Mr. Regier, recommendations?
One moment, Your Honor.
Please be merciful. Yes, it's the craziest story. I can't get over it with my insurance agent.
All right. Well, let's let Mr. Regier have his moment here.
For sure. Do you guys ever hear something like that?
We hear all kinds of things, but I've never heard that one, that the insurance
Oh,
agent.
my goodness.
Okay.
Your Honor, at this time, pursuant to plea negotiations, the state is prepared to recommend a non-reporting probationary period for a period of 1 year. The state is further recommending that the court impose court costs as well as fines of $100 for count 1 and the minimum fine required by law of $300 for count 2. The state is recommending a 6-month underlying sentence in both cases. The maximum underlying sentence for a class B misdemeanor for count 2 and the maximum allowed under KSA 8149 with respect to count 1. The state is recommending that those run consecutive. Notwithstanding the plea agreement in this matter, this is a case where the alleged occurrence dates in both those cases appear to be in very close proximity to each other. Nevertheless, the state is prepared to proceed with non-reporting probation pursuant to plea negotiations.
Okay,
Thank
now,
you, sir.
Mr. Longobardi, your story with the insurance agent works for me on one case, but how about the other one? Was it the same vehicle?
It was the exact same vehicle, ma'am.
But you didn't learn from the first time that it didn't have insurance?
Well, when I called him that night, or actually I texted him and I said, hey, I just got pulled over. Can you send me the proof of your insurance? And he said, because he was going through a divorce at the time, he said, I didn't have the money and I wasn't able to pay it, but I will take care of it. And I said, okay.
All right.
And so I just assumed he would take care of it. 3 days later, I think it was maybe 4 days. It was within the same week. I just thinking, I want to get to work. I've got children that I need to feed and stuff. I didn't think nothing of it, honestly. I thought it is what it is. All I got to do is get to work. But no, it didn't work out the way I would have thought. And I was a little naive and no, he didn't. The second time I got pulled over, I said, okay, I got pulled over again. Can you send me your proof of insurance? And he said, I didn't get it. And I said, you know what? I'm bringing you back your vehicle and we don't have to have any communication from now on.
All right, well, that is an explanation that at this
It's sad to
time,
say, I should have been smarter.
okay, well, let's proceed. Let's live and learn and proceed to your sentence. At this
Thank you.
time, sir, I will follow the recommendations. I think that Mr. Regier has been pretty accommodating to you and reasonable to offer the sentence he has in light of the circumstances. At this time, on count one, driving without registration or expired tag, your fine is $100 and your sentence is 6 months. On count two, driving without insurance, your fine is $300 and your sentence is 6 months. I am running these consecutive, which means if you get your probation revoked, you'll serve 6 months for count one, and then you'll serve another 6 months for the second count for a total of a year. I'm doing this since the first count or the first case was dismissed, and that seems appropriate in light of everything you've shared with me today. You will be assessed court costs of $108. Your total due will be $508. Do you need some time to pay that?
Yes, please.
How much time will you need?
How much time can you give me?
Well, how about 120 days? That's a little more than sometimes I go, but
For sure. Yes. Thank you so much.
now,
Now, how do I pay this?
you stop by the clerk's office on your way out today. They're right across from the security as you come in, and they'll tell you the different ways you can pay it.
Oh,
I would
thank you,
urge
ma'am.
you to pay anything you can today, if at all, and make payments as soon as you can in increments so that you don't wait 120 days and come up short.
Yes. Thank you so much. I appreciate that.
You're welcome.
It
You
will get
are-
paid off fast as I can. It's not going to take no 120 days, but I
Okay.
appreciate that. Thank you.
All
Thank
right,
you,
now
Jesus. Boy.
you are on probation for 1 year. That means that if you don't do what I tell you to, you can end up getting that revoked and serve a year in the county jail. To not serve a year in the county jail, you're not going to have a probation officer to see and remind you to do this. But the conditions are very simple. 1, pay that within 120 days. 2, violate no laws. So next time you get in a vehicle, regardless of who owns it, make sure it's legally tagged, insured, that its lights work, and that you have a valid driver's license. And so don't violate any laws, pay within 120 days, and you should successfully complete your 1 year non-reporting probation, and the case
Okay.
will close.
How long
Okay.
is the probation period? 12
1
months?
year from today,
Okay.
12 months,
Okay, thank
1
you.
year from
No
today.
speeding tickets, no kind of tickets whatsoever, you're saying?
I'm saying don't jaywalk and get a ticket for it.
Okay, well, I'm trying to be an honest citizen. Honestly, I do, but good gosh.
Okay. All right. Is there anything further, Mr. Aguirre, on this matter?
Your Honor, the state's understanding that the court had previously ordered booking and processing in both cases. What I would tell the court is that in the 366 case, notwithstanding the dismissal pursuant to plea negotiations, on March 17, 2025, my office did file an amended information dismissing count 2 while retaining count 1, an unclassified misdemeanor. If it is the court's order that the defendant continue to be booked in both cases, I would request leave of the court to journalize that in the journal entry in both cases from today's hearing, if that is the court's determination.
I am giving you a third condition of probation. Mr. Longobardi, I'm giving you a third condition of probation to get your picture and prints taken. Make sure they're in both of these cases, even the one that was dismissed. Deputy, would you please make sure that's accomplished?
So this is what they gave me. So tomorrow I'm supposed to go there. So tell them tomorrow, this is really for 2 cases, or they'll know. Okay, I will take care of that. Thank you so much, ma'am.
Yes. All right.
I will be
Thank
there tomorrow.
All right, thank you. If there's nothing further, we're in recess, but stop by the clerk's office and they'll tell you the different ways you can pay.
Because I'm going to pay some today. I can pay
Very
some now.
good. Very
Thank you
good.
so much. At least half.
Okay, next one I have up is.
Thank you, sir.
You bet. Christopher
Thank you.
Monroe.
We are on the record in case number 2023 TR 2208, State of Kansas versus Chris We are on the record in the 13th Judicial District, the District Court of Greenwood County, or Butler County, Kansas. I wanted to take up the Virgil Fry cases first, but is he or Mr. Patterson here?
Virgil Fry's here, but I don't see Mr. Patterson on yet.
Jenna, if you have a chance to text him and email him and remind him we have this case.
Just entering the waiting room.
Oh, yes, very good. All right.
Mr. Fry.
All right, as I was just starting to say, I'd like to take up the Virgil Fry matters. There is a motion on file. We'll take up case number 2023 CR 149, 2023 TR 939, and 2023 CR 161, each captioned State of Kansas versus Virgil Melvin Fry. Jared Regier for the County Attorney's Office, Darren Patterson for the defendant, and Mr. Tony Bauer, are you here as the probation officer?
Yes, Your Honor, I'm on this case.
Very well. Now, Mr. Patterson, you filed a motion. Would you like to be heard on that motion?
Judge, I would tell the court that I did file that motion. We had previously had it set some time ago at the last hearing. I think it was set over to today for the state to respond. And I wasn't certain at this point what that response was. I had not heard from Mr. Regier. So I stand on my motion. I just wanted to find out if there's a defense by the state.
All right, well, that was my recollection as well. I did not see a written response. Mr. Regier, have you an oral response to the motion to dismiss warrant to show cause and set aside the warrant for the reasons stated in the motion?
Yes, Your Honor, as the state is prepared to call two witnesses to the stand in response to the defendant's motion to dismiss. However, in the interest of fairness, I would tell the court that the state does intend to produce 3 exhibits. I understand those 3 exhibits were provided accounts for the defense earlier in the day. I do not know if he's had the opportunity to do the same at this time.
All right, well, this is basically an argument pursuant to State v. Haynes. Mr. Patterson, anything further before we begin the evidence?
Yeah, I'd like to know what the evidence is, Judge. So maybe Mr. Regier and I could have a breakout room and discuss what their position is.
That'd be fine. Missy, if you could put them in a breakout room. Do you want Mr. Bauer in that breakout room or not, Mr. Patterson, Mr. Regier? At this time, you just want the attorneys?
That's fine, Judge. If Mr. Bauer goes in there.
All right. In case he has any input or needed information. That leaves me with several other cases. Unfortunately, with the prosecutor gone, we are kind of at a standstill. I show 2021 TR 779, State versus Aubrey Patrick Owens. Is the defendant here?
Sorry, kid. Bye-bye.
Aubrey Patrick Owens, is he here? Do you have him at court security?
No, Your Honor.
Okay, he's Mr. Gearing's client, so we'll wait until we get the prosecutor back to see if he's heard anything.
What? Oh, what's red? You got a mosquito in the back room.
Right, are we ready to proceed? Do we have everyone back from the breakout room?
All right, I think we're ready to go on the record. Yes.
All right, thank you. We are on the record again in 23 CR 161, 23 TR 939, 23 CR 149. Each captain state of Kansas versus Virgil Melvin Fry Jr. All parties as before, that is Jared Regier for the state, Virgil Fry in person and with counsel Darren Patterson, and CSO Tony Bauer. Any announcements at this time, gentlemen?
Judge, I would tell the court that I have discussed with Mr. Regier who the witnesses might be. I've discussed with him what documents he might have. I've received one of the 3 documents. I don't have the other 2 yet. I haven't had a chance to look at those. He's provided me a case site that he would be arguing. I have not looked that up yet to prepare it. Just as the state had requested additional time, I am requesting additional time to prepare for the motion in response to the state's evidence. Again, I was not aware that there was any response until just minutes ago. So I'm asking the court to set this over to a new date so that I can look at what the state is presenting.
As I looked at the docket this afternoon, I didn't, as I said, see a state's response, and I thought that's why we set this over, is for the state to provide one if they wanted. Seeing none, I thought perhaps the state was acquiescing to the motion, but now, Mr. Regier, as I understand, you do object to the motion. You have a couple of witnesses, several pieces of physical evidence. Is that correct, to object?
It is, Your Honor, and insofar as the other documents that counsel had indicated not received yet, I have just concluded communicating with my staff, so I would anticipate that being provided to counsel for the defense in short order. If under these particular circumstances, the state is not opposed to setting this matter over in the interest of fairness, if that is the order of the court, and if the state's witnesses can confirm their availability for a follow-up date.
Who are your witnesses? I understand one is Lori Mann of the sheriff's office. Is that right?
Yes, Your Honor.
And the other?
The state would further be calling the testimony of Court Services Officer Bauer at the appropriate time, Your Honor.
And you intend for them to be witnesses in your motion as well as the show cause? I'm sorry, you intend for them to be witnesses in Mr. Patterson's motion as well as the show cause?
The state would be calling these 2 witnesses in opposition to the defendant's motion, Your Honor.
All right. Well, these are 2023 cases, as we all know, getting no not Missy. Jenna, when can you set this over on the 1:30 docket?
Your Honor, I can do July 30th.
All right. Council, July 30th at 1:30. And we might want to limit the number of cases we put on that docket again, although if we keep limiting and not using, then I'm going to get myself in a bind on the other cases that need set.
Your Honor, that docket actually already has 3 other cases on it, but it's the same person. So we're seeing 3 cases of the same person on that docket as well, plus this one.
Who has 3 cases. So we're looking at 6 cases, 2 defendants.
Correct.
What's the next one after that?
August 13th.
Well, let's leave it on that July 30th and see what happens. In the meantime, Mr. Bauer, do you have anything worked out with Mr. Fry for reporting?
Your Honor, he was ordered to report to me until this hearing date today. He came and seen me the day of our last hearing and has failed to report since then.
Mr. Patterson, he raised his hand. I don't know if you want him to say anything.
I was going to ask that he immediately come to my office so that I can discuss things with him and kind of go over these documents I've received.
All right, Mr. Bauer, any instructions you'd like to give the defendant?
If he could call me when he's done with Mr. Patterson, if he would give me a call, we can meet and I will get him scheduled with another appointment.
Okay. Well, this matter is in recess until the date given. Thank you to the witnesses who are here, and hopefully if you have any problems with that date, you can tell me now. You may not know your schedule, so.
I have nothing scheduled at this time, Your Honor.
Yes, ma'am.
I can be available.
All right, thank you very much. Then we're in recess and the witnesses, defendant are excused at this time. Mr. Patterson is excused as this seems to be his only case today as well.
And Judge, if the court had just a brief moment, I was going to see on a whole different matter, see if I could have Mr. Regier and yourself in a brief breakout room.
Yes, Jenna, are you Missy, would you put us in a breakout room, please? That leaves me with several other cases. Unfortunately, with the prosecutor gone, we are kind of at a standstill. I show 2021 TR 779 State versus Aubrey Patrick Owens. Is the defendant here?
Sorry, kid. Bye-bye.
Aubrey Patrick Owens, is he here? Do you have him at court security? He
No,
is.
Your Honor.
Okay, he's Mr. Gearing's client, so we'll wait until we get the prosecutor back to see if he's heard anything. And Dravid and Patel, are you here?
I've got him here at court security, Your Honor.
Tommy Joe Robertson, are you here?
Yes, Your Honor.
All right, Missy, could you please put Tommy Joe Robertson's name on his screen there at Summit 5G? Now, I see some other individuals. One says Iman or Eman. What is your full name in relationship to one of these cases, please? And Miss McManus, you are here on which case?
Your Honor, I am here on Aubrey Owens.
Thank you. Who's here on Tommy Robertson besides Tommy Robertson? I can figure that out. Well, it's long enough. I don't think they're going to. We are on the record in case number 2021 TR 779, State of Kansas versus Aubrey Patrick Owens. Present for the state is Attorney Jared Regier. Intensive Supervision Officer, Community Corrections is Lori Mann. Oh, you have him with you, court security?
He just showed up, I guess. He's checking in now.
He's checking in now. Did he bring is it the defendant or his attorney or both?
Just the defendant's all I've heard. He hasn't came in the room yet, but
All right. Well, let's see. We'll recess that again till I get situated. We will try case. All right, Gina Panatex, you were here for which case again? The
Patel. Patel.
Okay. We are on the record in, do you have a Patel in the court security?
yes, I do.
Okay, then we'll take up the one you have up here first then. And this is Mr. Owens, correct? Where did he go?
So you want to take up Mr. Owens?
I'll just take up whoever you have handy, sir.
Oh, they're both
Whoever-
here. So
Whoever you put in the chair, I will call. So this is which one?
this is Mr. Owens.
Mr. Owens. We are on the record in case number 2021 TR 779, State of Kansas versus Aubrey Patrick Owens, Jared Regier appearing for the state, Mr. Owens appearing in person, and at least at this point, pro se. Mr. Owens, I do show Christopher Ryan Gehring as your counsel of record. Have you talked to him about this hearing?
Yes, ma'am. I just left his office actually. That's why I was running a little behind. I forgot that you requested I come in person.
All right. Well, do you know where he is?
Yeah, he wasn't able to make it in person.
Is he going to make
today.
it by Zoom?
I'm sorry.
Is he going to make it by Zoom? The Zoom transmission?
He didn't say that, no.
So you don't know if he's 30 minutes late, but so you think he's going to come or not?
No. Because I had went to his office, and then he reminded me that it showed that I needed to show up in person.
All right.
But he's willing to represent and everything. It's just I forgot about that part.
Who just needs a different court date?
Yeah, if possible at all. That would be awesome.
April 16th to 25, he was unable to appear. Asked for a continuance.
Yeah, I had not been able to hire him yet at that point.
Looks like, have you hired him by this point, May 28th?
Yes, I was at his office this morning.
February 26th, you told me you were hiring him. Well, Mr. Regier, we are here on a motion to revoke probation that's been pending for some time now. What is the state's position on this?
Your Honor, at this time, the state would defer to the court as to how it wishes to proceed. However, if the court does continue this matter again for a third time, the state does have some very significant concerns. It would appear that, based off my notes, the request for revocation, or rather a first appearance for the same, was conducted over 3 months ago on February 26th. It would appear that, based off my notes, that at the time of that hearing, the defendant announced an intent on the record to hire attorney Gehring. The state is not aware of any recent entries of appearance in this case, although the state does acknowledge that at least at the time of sentencing in March of 2023, it would appear that attorney Matthew Levitt did appear, although at an earlier hearing, it looks like attorney Gehring was present. At the April 16th hearing before Judge Hutchinson, the defendant apparently raised a similar allegation about speaking to Attorney Guerin within the last 24 hours, and the court did specifically order, besides that the defendant appear in person, that the continuance to today's date and time would be the last time for continuance based off my notes. So it does appear this has been pending for quite some time, and the state is eager to reach a resolution in this matter. Again, it looks like the first appearance on the request for revocation was conducted over 3 months ago, almost to the day. So if the court is going to continue this matter again, the state would have its objections to the same noted on the record, while at the same time acknowledging the defendant's constitutional rights. But again, the state does have its own concerns about judicial expediency, economy, and the burden on the Butler County taxpayers to be setting this matter over for yet another setting.
In addition to what you've just stated, counsel, filed in Butler County District Court January 16th of 24 was a waiver of right to probation violation hearing. And at that time, the defendant, acknowledging his sentence for driving under the influence of alcohol, stated he understood that he was accused of failing to refrain from possession or consumption of other illegal drugs as ordered by the court, and that he had failed to obey the laws of the United States, the state of Kansas, and any other jurisdiction. And having waived his right, it looks like he did a jail sanction of 2 days. And again, that was in January of 2024. And then there came a request for revocation of probation again, November 15th of 2024. And I believe that's the one we're still trying to get him to hearing on. Is it not, Miss McManus? So it's actually longer than you stated, counselor. It goes clear back to November that the state's been trying to have its hearing on this motion to revoke probation. And so Mr. Owens, you are entitled to an attorney, but you're not entitled to manipulate the court system indefinitely on the theory that you're going to get an attorney.
I understand.
Where do you work?
I'm sorry.
Where do you work?
I work for a contractor, Mitchell Flores.
And what do you do for Mitchell Flores? What work?
I operate heavier machinery, help him, move stuff around when he needs it.
Well, at this time, I'm going to appoint Attorney Darren Patterson to represent you in this show cause matter. And I am going to set this the next available possible date. What does Monday morning, well, he probably can't get to it that fast. What does next Wednesday is 1:30 look like? Is that our language interpreter docket?
Your Honor, yeah, that's our interpreter.
And is it like beyond packed?
I have 5 of 5.
5 of 5. Let's put Mr. Owens on that docket and try to get the appointment to Mr. Patterson as soon as possible. Now, Mr. Owens, if you can get your retained attorney here at that date and time, great. But I'm not going to keep putting this off.
Yes, ma'am.
You've bought yourself a lot of potential freedom here. If you were in violation and the court would have revoked you back there in November, you've bought yourself a lot of time by saying you're going to get an attorney, and not.
I understand.
So go over there to Mr. Patterson's office right now and tell him what the court has done. Mr. Regier, please get him any discovery that he might need as soon as possible, because I just I just don't want any more delays. Ms. McManus, I should have asked, can you be here next week?
I have a 3 o'clock appointment, but I should be available from 1:30 to 3.
All right, well, I certainly hope to get you out of here by then. You might remind me to go, that we need to go first if I don't remember that. Okay, thank you.
And
All
Your Honor,
right. And you'll need to be here at the courthouse, sir. Yes, Mr. McGill.
Your Honor, as previously on the record, if the state is objecting to this continuance, and the state would have its objections noted on the record.
Well, I'm objecting to it too, but I'm overruling us both. We're gonna do it.
Very good, Your Honor.
All right, thank you. Be back here at the courthouse, sir.
Yes, ma'am.
That was a poor attempt at humor. Let's see. All right, so anyone on that case alone is excused.
Yeah.
Court security might want to mute unless you're gonna tell me who you have there next. Do you have
Mr. Patel.
Aubrey Patrick Owens? Is he here? Do you have him at court security? He
No,
is.
Your Honor.
Okay, he's Mr. Gearing's client, so we'll wait until we get the prosecutor back to see if he's heard anything. And Dravid and Patel, are you here?
I've got him here at court security, Your Honor.
Tommy Joe Robertson, are you here?
Yes, Your Honor.
All right, Missy, could you please put Tommy Joe Robertson's name on his screen there at Summit 5G? Now, I see some other individuals. One says Iman or Eman. What is your full name in relationship to one of these cases, please?
Laurie Mann, and I'm with the Fry case.
All right, you're the supervising officer. Missy, can you put her name on the screen? And then Gina Panatex. Thank you. And you are with?
State of Kansas versus Patel. And I'm with State Farm Insurance.
Okay. And that's the one that Mr. Gearing and his client are missing. Is that correct? I called that Patrick. Is that what you, is that the same case, 21 TR 779? Is that the case you're here for?
I'm not sure of the number, Judge.
And then is the name Aubrey Patrick Owens?
It is for Patel.
Oh, Patel.
Yeah, State of Kansas versus, yes.
Okay. Got it. Cooper Herbert, you're here for which case?
I'm here for Patel, Your Honor.
Okay, thank you. And Ms. McManus, you are here on which case?
Your Honor, I am here on Aubrey Owens.
Thank you. Let's see.
Right
All right,
across the street.
so
Or
anyone
got
on
a
that
yellow
case
sign on the
is
window.
excused.
Yeah.
Court
That's
security
Patterson.
might want to mute unless you're going to tell me who you have there next. Do you have,
Mr. Patel.
let's bring in Mr. Patel. We have witnesses waiting on that. We are on the record in 2024 TR 2964, State of Kansas versus Andravadon Patel. Jared Regier for the state. The defendant appears in person and pro se. We are set for bench trial. The state has charged that the defendant was driving without insurance or proof of insurance on November 9th of 2024 in Butler County. The defendant denies that allegation and then apparently says he did have insurance at that date and time. So are we still ready to proceed, Mr. Regier?
There are one or two other housekeeping matters, Your Honor, but beyond that, the state is prepared to proceed.
Mr. Patel, are you ready to proceed with your trial?
Yes, ma'am.
And you still maintain that you did have liability insurance, correct?
I did.
All right. Now, what are these housekeeping matters, Counselor?
Your Honor, previously, before the last hearing, the state did file an amended motion for a post-arraignment endorsement. Based off of my notes from the April 16th hearing presided over by Judge Hutchinson, that amended motion for endorsement was granted. The notice of hearing attached to the same does set that motion for hearing on April 16th, 2025. Shortly thereafter, on April 7th of 2025, a motion for continuance was filed with the court, setting the matter over from April 16th, 2025 to May 28th, 2025. It would appear that the paragraph 1 of the motion for continuance does address both the bench trial and the motion for endorsement. So I'm not sure if the court feels it necessary to re-grant the amended motion for endorsement, but that is the state's request at this time, for purposes of the record, if for no other reason.
The endorsement is maintained. He's been endorsed. He or she has been endorsed and will continue to be approved as a witness in this case. So please proceed.
Thank you, Your Honor. The state is prepared to proceed to trial, Your Honor, and would waive opening statements at this time.
All right. Please call your first witness.
Thank you, Your Honor. The state calls Trooper Buck Herbert to the stand.
Please raise your right hand, sir. Do you solemnly swear the testimony you're about to give shall be the truth, the whole truth, and nothing but the truth? So help you God.
Yes, Your Honor.
Thank you. Please proceed.
Would you please state your name for the record?
Trooper Buck Herbert
Where are you employed?
with the Kansas Highway Patrol.
And what is your professional title with the Kansas Highway Patrol?
I am a state trooper.
Approximately how long have you worked in law enforcement?
Approximately 7 years.
Okay. And approximately how much of those 7 years was spent with the Kansas Highway Patrol?
Since 2020.
Okay. So approximately 5 years with Kansas Highway Patrol specifically?
Correct.
Okay. Were you on active duty in your professional capacity on November 9th, 2024 at approximately 9:13 p.m.?
Yes.
At that time, where were you at?
I was traveling eastbound on K-254 highway,
Okay. Do you recall what mile marker you were at approximately?
approximately milepost 14.
Is that in Butler County?
Yes.
Okay. And when you were, say, traveling eastbound, were you in a vehicle of some kind?
Yes, I was on a marked patrol car.
Okay. Could you please describe the surroundings of the area as you recall them at the time?
It's a rural highway. It's a divided 4-lane highway.
Okay. So when you say divided 4-lane highway, would you consider K-254 at this location to be a multi-lane highway?
Yes.
Okay. How many lanes, if you recall?
2 in each direction.
Okay. And what are these 2 directions that you're referring to?
Eastbound and westbound.
Okay. At this location, are the eastbound and westbound lanes of K-254 separated by any open areas or landmarks?
It's separated by a grass median.
Okay. At this location, is K-254 open to public use?
Yes.
Okay. And would you describe K-254 at this location as more curving, or is it more straight?
There are straight areas and curved areas.
Okay. Do you recall this area specifically?
I don't recall.
Okay. Trooper, are you familiar with KSA 43104?
Yes.
And what does that require drivers in Kansas to present to law enforcement upon demand?
Proof of liability insurance.
And is that an optional request to the best of your knowledge?
No, it is not.
Okay. So is it your testimony today that the mandate about drivers in Kansas providing liability insurance is mandatory to all drivers?
Correct.
Okay. Your Honor, at this time, I respectfully request the court take judicial notice of KSA 43104.
So taken.
Trooper, do you consider yourself capable of identifying traffic violations when you see them?
Yes.
Besides your approximately 7 years of experience that you had referred to, do you have any other past experiences or special training that enables you to identify traffic violations on site?
No, just my training.
Okay. Do you have any continuing education requirements that you're expected to meet in your capacity as a law enforcement officer?
Yes.
Could you please describe these continuing education requirements for the court?
40 hours annually of additional training.
Okay. And are you current on your continuing education requirements at this time?
Yes.
On November 9th, 2024, at approximately 9:13 p.m., did you personally see any acts that you consider traffic violations?
Yes.
What did you see?
I had a minivan pass me. I was traveling in the right lane. He was traveling in the left lane and came up behind me and passed with his bright lights on.
Okay. Now, how did you observe this minivan if it was 9:13 p.m. in November?
Coming up behind me in the mirrors.
Okay. And is it your testimony that when you observed this minivan, I think you said its bright lights were activated?
Correct.
Okay. And where are these bright lights? Where were these bright lights located on this minivan?
To the front.
Okay. And were your patrol lights activated on your vehicle at the time that this occurred?
My driving lights were, my emergency lights were not.
Okay. So your driving lights were activated at the time?
Correct.
Okay. And these driving lights, where are they located on your patrol vehicle?
Tail lights to the rear and headlights to the front.
Okay. Do you recall the model, the make and year of this minivan that you observed?
It was a Chrysler Town and Country Pacifica, and it was a 2017.
Okay. And do you recall the color of this particular Chrysler?
I believe it was maroon.
Okay. Did you ever conduct a traffic stop on this Chrysler?
Yes.
Where did this traffic stop take place?
Shortly after I saw the violation. I don't recall exactly what milepost it was at.
Okay. When you observed this violation, to the best of your knowledge, was the Chrysler still in Butler County?
Yes.
Okay. Approximately how far from the county line were you at the time, if you recall?
I'm unsure about that. It was well within the county.
Okay. Once you conducted the stop, did you personally speak to the driver of the Chrysler?
Yes.
Do you see the driver of the Chrysler present in the Zoom conference?
Yes.
Could you please point the driver out and give a brief description for the court?
He's on the video for court security 3. It looks like a white background, some black object in the top left. He's got gray hair on the sides and bald on top, wearing a black shirt.
Your Honor, let the record reflect that the witness has identified the defendant.
It shall so reflect.
Trooper, did the defendant ever provide you with any official identification?
Driver's license.
Okay. And do you recall what state this driver's license was out of?
Kansas.
Okay. Did you ever ask the defendant whether they had proof of insurance on the Chrysler?
Yes.
How many times, if you recall?
I don't recall.
Okay. Did the defendant ever provide you with proof of insurance on the Chrysler during the stop?
No, he never provided me a proof of insurance on the stop. I believe he said that it was on his desk or his table at home.
Okay. Did the defendant ever provide you with proof of insurance on the Chrysler at any time after the stop?
Not to my recollection, no.
Okay. Did you ever write the defendant a citation for a violation of KSA 43104?
Yes.
Okay. Barring any redirect, no further questions, Your Honor.
All right, Mr. Patel, you can ask questions of the officer based on his testimony. It is not your chance yet to testify as to what you have to say, but if you have questions and only questions about his testimony, you can ask Trooper Herber at this time. Do you have questions?
I really don't have any questions, but yeah, but I had the proof of insurance.
All right, we'll give you a chance to present that. But if you don't have any questions of the trooper, the state will move to its next witness.
Thank you, Your Honor. If I may proceed.
Please do.
Your Honor, the state calls Gina Panatex to the stand.
Please raise your right hand. Do you solemnly swear the testimony you're about to give shall be the truth, the whole truth, and nothing but the truth, so help you God?
I do.
Very well. Please proceed, Mr. Regier.
Would you please state your name for the record?
Gina Panatex,
And where are you employed?
State Farm Insurance,
Okay. And in your capacity with State Farm Insurance, what is your professional title?
Underwriting Team Manager.
Okay. Are you a records custodian for State Farm Mutual Automobile Insurance Company?
Yes.
Okay. And how long have you worked as a records custodian for State Farm Mutual Automobile Insurance Company?
I've been with the company 36 years, so about 26 years in the leadership capacity.
Okay. And are you familiar with the records of State Farm Mutual Automobile Insurance Company in your ordinary course of business?
Yes.
Okay. Your Honor, at this time, I respectfully request leave of the court to share my screen.
Leave is granted.
Thank you, Your Honor. Ms. Panatex, do you see the document on the screen?
Yes, I do.
Do you know what kind of document this is?
Yes, this is to certify that the request that they asked was to verify that the coverage was in force at that time.
Okay.
Yes.
And are you familiar with these types of documents in your regular course of business?
Yes.
Okay. What is the title of this document?
Certified policy record.
Okay. Do you see a stamp for State Farm Mutual Automobile Insurance Company on this page?
At the top of the letterhead.
Okay. And when you say letterhood, is this do you consider this type of document an ordinary business record?
Yes.
Okay. Scrolling down a little bit, do you see a signature on this page?
Yes.
Okay. Do you see the name and the professional title of the signer of this document?
Yes.
Okay. What is the name and professional title of the signer of this document?
Underwriting team manager,
Okay. And the name?
Gina Panatex.
Okay. Is that your name and professional title?
Yes.
And is that your signature?
Yes.
Your Honor, at this time, the state moves to admit the defendant's State Farm Mutual Automobile Insurance Company certified policy record as State's Exhibit 1.
Any objection to that? Hearing none, State's Exhibit 1 will be admitted.
Ms. Panatex, do you see a date at the bottom of your signature line on this document?
Yes.
What is that date?
April 9th, 2025.
Okay. And this April 9th, 2025 date, is that before or after November 9th, 2024?
After.
Okay. Scrolling up slightly. Ms. Panatex, does this document identify the policy number of any State Farm Mutual Automobile Insurance policy?
Yes.
Okay. What is this policy number as indicated on the document?
It is 318-5921 C01-16A.
Okay. Does this document identify the full name of any State Farm Mutual Automobile Insurance policyholder?
Yes.
Okay. And what is that policy holder's name?
Indravatan Patel.
Okay. To the best of your knowledge, is your insurance agency holders of any other insurance policies involving this individual?
I'm not aware of that. I don't have record of that.
Okay. Just a few more questions, Ms. Panatex. Do you see the paragraph beginning with the phrase "the policy"?
Let's see. Say that again. I'm looking at it.
Ms. Panatex, on this document, do you see the paragraph beginning with the phrase "the policy"?
I'm looking for that. Okay. Yes, there it is. The policy.
Okay.
Was canceled.
Would you please read this paragraph for the court?
Yes, this policy was canceled effective September 1st, 2024.
Okay. And this September 1st, 2024 cancellation date, is that before or after November 9, 2024?
Before.
Okay. Ms. Panatex, is it your testimony today that that this particular insurance policy, as evidenced by the certified policy record, was canceled before the November 9, 2024 date and was confirmed by you after the November 9th, 2024 date?
Correct.
Barter and redirect, no further questions, Your Honor.
Thank you. Now, Mr. Patel, if you have questions of this witness about her testimony, you can ask them at this time.
Yes, Your Honor, when the renewal came.
Objection, Your Honor, testifying on cross.
You'll get a chance to testify later, sir. This is if you have any questions of this witness, questions that she can answer for you. Oh, okay. Well, I was hoping that the agent was going to be in the court. Well,
instead,
you could have.
She's not here.
Did you subpoena her?
No.
Well, then she probably wouldn't know to be here. But this is an official records custodian of your insurance agent's company. If you have any questions for her.
Well, as soon as I got the notice from State Farm,
Objection,
I-
Your Honor, testifying on cross.
You can ask her about the notice, but don't tell her what you did unless it's to ask her if you called or if you did what you said. You can ask her questions, but you're not to testify yet. Do you understand? Do I maybe need to explain a little bit the difference?
yes,
between the-
please.
All right, a question is you can ask her what she did, or if she knows what you did, but you can't tell her, because that's a statement like you would make when it's your turn to testify. Like Mr. Regier was saying, do you see that? What does it say? What is this document? Those would be the kind of questions that he asked. And then if you want to follow up with questions, you can do that.
Yeah, that's correct. Correct statement
Okay.
from her.
All right. So you don't have any questions from her?
No.
All right. Then I don't really want to excuse you yet, Miss Panatex. You may come up later in this case. So if you could stay just a little longer.
I will.
Thank you. Mr. Regier, any further evidence?
Your Honor, as a preliminary matter, does the court wish the state to stop sharing its screen at this time?
That would be, well, yes.
Thank you, Your Honor. At this time, the state has no further witnesses.
All right, state rests.
The state does so rest, Your Honor.
All right, Mr. Patel, the state says they've presented all the evidence they're going to, and now if you want to present any evidence you can, now would be a time. If you want to make statements, you can do that. But I do have to give you an oath. You don't have to make statements if you don't want to, but you can if you want, or you can call other witnesses if you want.
Well, I don't have any witnesses.
All right, do you want to testify on your own behalf? Again, you don't have to. Okay, then please raise your right hand. Do you solemnly swear the testimony you're about to give shall be the truth, the whole truth, and nothing but the truth, so help you God?
Yes, I do.
Very well, thank you, sir. Please proceed to tell me your name.
I'm Indravardhan C. Patel. I'm from 1111 East Central Avenue in El Dorado. I've lived there for 47 years.
All right, and you're the defendant charged with driving without liability insurance in this case?
Yes.
All right, so you appear to agree that you were driving on November 9th of 2024. Is that true?
That's correct.
And were you at the location the officer said you were?
Yes.
Okay, but you have entered a plea that you're not guilty. You want to tell me why you're not guilty? Or anything you want me to say? It's whatever you want me to hear, anything you want to say.
Yes, I had the copy of the insurance with me, and initially I talked to my agent, Valerie Bean, and I told her that how come the insurance went so high up? It was nearly $134 extra from the previous year or previous 6 months. So I was not very happy about that, and I consulted with her over the phone, and she said she's going to
Objection,
look
Your
into
Honor. Hearsay.
We can't get into what she said unless she's here today. You can say what you told her, but not what she said.
I'm telling you what I told her over the phone.
Okay, just stop,
And
but don't tell me what she said.
okay. And no, the thing is, she, on over the phone, she says, I'll look into it.
Objection, Your Honor. Hearsay.
All right, so she told you something over the phone, and then what did you do?
And she never called me back on this
Okay,
issue. Okay.
now when did you have that call? Was that
And-
before? Was that before or after November 9th of 24?
Before.
Okay, go ahead.
And then And after all this happened, the stop and the officer gave me a ticket. I went again to her office personally, into her office, and tried to talk to her about renewal and new rate and all that. But she was busy that night, that evening around, I think around 3:30 or so. She was being busy. So she told me that, look, I am
Objection,
not.
Your Honor, hearsay.
Hearsay, yeah, it is a hearsay, but I'm telling you what experience I had with her.
She was not able to look into what you wanted that night, so did you leave?
No, listen, Judge, that she told me that, look, I'm very
Honor.
busy, whatever she's
I'm
doing.
going to allow it to appoint Mr. Regier. Go ahead, sir.
Your Honor, the state would lodge a continuing objection to hearsay on the record at this time.
I will so note.
Thank you, Your Honor.
Let him go a little further.
Okay, and then because she was busy, she couldn't do anything that evening or that afternoon. And she told me she was going to call me back next day. I said, okay, then I'll wait for her call, and she might do something about the insurance, you know. And I've been with State Farm for a long time.
Hang on, sir.
Okay.
Wait a minute. So this time you're talking to her, was that after you got the ticket?
That's correct.
Okay. And you
That's
went in there to do what? What was your reason for going in there?
Going to either correct the amount I was supposed to pay, and I was willing to renew the insurance and all that. And she told, because she was busy, she could not do anything that evening or that afternoon. And then she told me that, look, Mr. Patel, I'll call you tomorrow, or next day, and she never called me. So because she never called me, I waited for a couple of days. I thought she would maybe be busy or whatever. And I waited and waited, and she never called me. So I thought I better start looking for insurance elsewhere. And that's what happened. I started looking, and I got about 5 places I went to with David Matthews, who does Progressive, and another company I went to is American National, and then I went to Jack Insurance Company.
Your Honor, objection, relevance.
Finally, I found out.
Your Honor, the state is requesting a ruling.
Stop. Okay, stop. Okay. The issue for me to decide today, Mr. Patel, is whether you had valid active insurance at the time the officer stopped you on November 9th, 2024. Whether you went out and got insurance after the fact is what Mr. Regier just called not relevant. That doesn't help me, the decision. The decision
before
has to
Judge,
be November 9th.
but before that, I did call her, and she never called me back.
All right, so she did not call you back, and you never did come to terms with what you should pay for your insurance? Is that what you're testifying to?
Yes.
Okay. And
it was $134 more than previous 6 months, which is very high for me. On one vehicle, I hardly drive, I hardly had any accidents or nothing, no claims, nothing. And she kept telling me that the insurance will be reduced the next time you come. But instead of reducing, it went up.
Okay.
By $134.
All right, but again, keep your focus on
And
whether or not.
that was my objection to her. And I called her, I said, why you increase so much, you know? And she had no answer for it. And she says, okay, I'll look into it, and never call me back. What she looked into it. And then the second time I went I personally went to her office and trying to defend my insurance rate, you know. but she didn't do. And again, same time she was busy, and she told me that, look,
right.
I'm very
Well, I've
busy
heard
right now.
all of
I
that,
can't do
sir.
anything, and I'm going to call you next day. And she never called me next day, and never called or heard from her at all.
Was she
Till
with,
today, she has
was
not
she,
called me.
was she with State Farm Insurance?
State Farm Insurance, yes. And I've been in the insurance with her for a long time on
Okay,
record, and not a single claim, and hardly drive the vehicle.
all right, Mr.
You won't believe this, Judge. There is a 2017 vehicle. Is only that time it was about 18,000 miles. That's it.
Your Honor,
Since 2017,
Well,
I hardly drive. No
Mr.
claims,
Patel, I
nothing.
need to shut you down there a minute.
Okay.
Mr. Regier may have questions. Mr. Regier, any questions?
no questions, Your Honor, although if this court is going to continue to allow this line of questioning, the state would further allow a continuing objection on the grounds of relevance in this matter.
Sustained.
Thank you, Your Honor.
Mr. Patel, I'm hearing, was there anything else you wanted to offer, sir? Any evidence?
Yes, can you imagine? I've been here in this city for 47 years. How can you believe that I can have no insurance? But this agent, Valerie Bean, she let me down by not renewing and not telling me. Okay. She kept telling me I'll look into it, but no answer from her. I've been trying. 47 years. I've had so many vehicles for my daughters, for my wife, and everybody else.
Well, sir, I don't want to be
I've had insurance and
I'm gonna
never failed to pay.
All right, and I understand that, sir, and I'm gonna have to stop you there. Because we do have some others that are set for trial too, and I've heard your position, and it sounds like we're just going over it again. So if you have no other evidence, Mr. Regier, have you any other evidence, any questions of him?
No further questions, Your Honor.
All right, so now I need everybody to stop talking and let me talk for a minute uninterrupted. What I have heard from the evidence is that you were stopped by Trooper Herber on the highway in Butler County, November 9th, 2024. When he asked for your liability insurance, you did not have it because your insurance agent had let you down. You'd been with her for many years. You'd always paid your insurance. You'd had a lot of coverage or policies because of your daughters, your wife, and yourself. But when you got your bill before November 9th, it seemed unusually high. You went into the insurance company and asked them, why are they raising it? The lady said she'd get back to you, and she didn't. And so you never got around to paying your insurance. In other words, renewing it, because you were waiting on her to get back with you and see if the amount was right or if it should be lowered or could be lowered. In the meantime, you're driving around without renewing your insurance, and thus you had no insurance. And when Trooper Herber asked for it, you couldn't produce it because you didn't have it. And then you went back to your insurance agent, and she still didn't give you a satisfactory answer. But by then, it was basically too late. You had been driving without insurance. So I do have to find you guilty beyond a reasonable doubt. And I'm going to order a $300 fine with 108 court costs. I'm going to order a 120-day suspended sentence. You won't have to serve that if you comply with a 6-month non-reporting probation. Now, you won't have to see a probation officer, but you have 2 things you have to do if you don't want your probation revoked and you don't want to serve your jail sentence. 1, you have to violate no laws for the next 6 months. Doesn't sound like that's going to be an issue. It sounds like you try very hard to follow the rules and the law. The other is you have to pay the 408. Do you need some time to pay that, Mr. Patel?
Well, why charge me, Judge?
Because the law says if you drive without insurance,
it's
a minimum fine of $300 and court costs of $108. I could go up to $600, but I'm not gonna do that. So $408 you can,
That's,
you can
that's a lot.
appeal.
That's a
That's a lot.
This is worse than the insurance itself.
Well, that's what the Kansas legislature who made this law, that's what they set it at, and I have to follow it, and that's what Mr. Regier more times than not recommends. So that's why I'm thinking that would be a reasonable amount today, the minimum 300. I have to order the court costs of 108. I can give you, would 30 days be enough to get it paid? 60 days?
But Judge, I tried to call her and she never returned my calls.
I know, but he
Uh,
wasn't the one driving the
while
car.
while the insurance was still valid.
Okay, you do have up to 14 days to appeal my decision to the Court of Appeals. If you do, you have to put up a $408 cash bond when you file your appeal. If you don't appeal, you have 14 days to get this paid unless you tell me you need more time.
Yeah, of course, this is ridiculous, ma'am.
30
This
days?
is going to cost me, everything is going to so high. I was trying to avoid $134 extra charge. Now you're charging me $400. I mean,
Well, I'm not gonna keep battling with you,
it's,
sir. I will give you more time if you need more than 14 days. You need more than 14 days to pay?
I'll take as much time as you give me.
All right,
Because
I'll give you 30
I don't know.
days.
I don't want to pay anything. I'm not supposed to
I know
pay.
you don't, and if you don't pay, your probation could be revoked and you could spend 120 days in the county jail. If you don't want to spend 120 days in the county jail, pay it and don't violate
Why?
any more laws.
A decent
And
man like me, why should I spend time in jail, ma'am?
you can talk to an attorney about that, just as I gave you the opportunity to hire an attorney before, sir. As they say, I don't make the laws, I'm just required to enforce them, and that's what I'm trying to do. Mr. Regier, in the interest of time, I did not ask you recommendations. I trust that what I did sentence
Can you
is,
please lower the cost?
I cannot lower them anymore, but is there anything further, Mr. Regier, you have that you would like to make a record of?
Your Honor, besides thanking both Trooper Herbert and Ms. Panatex for honoring their subpoenas, the state has nothing further in this matter.
And even this man who's talking to you, I called him on Thursday. He never returned my calls, just like the State Farm agent.
Well,
Two
he
times,
doesn't
even yesterday I called.
he's
He never returned my
prosecuting you.
calls.
Keep in mind, he's prosecuting you. He's not your attorney. So he's
No, I have
probably
to
not
talk to
going
him.
to contact you. All right, I will let you go at this time. This case is in recess. Anyone here on this case alone is excused.
Can you give me what did you do? I didn't understand.
All right, listen to what I
Can you?
did. Quit talking and listen to what I did, and then
Yeah, please tell me one more time what I have to do. This is not right.
Stop talking.
I've
All
done
right.
nothing wrong.
All right, if you want my answer, stop talking. Otherwise, I'm going to adjourn right now. The fine is the minimum allowed by law of $300. The court costs that I'm required to assess are $108. So you owe a total of $408. You have 30 days to pay that. You have a suspended 120-day sentence that you will not have to serve as long as you pay this and violate no laws for the next 6 months. If you want to appeal it, you have to do that on your own through the Kansas Court of Appeals. If you appeal, the clerk has to assess or charge a appeal bond, a supersedious bond of $408 cash when they accept your appeal. Mr. Regier will put all of that in a journal entry, and you can get a copy of that from the clerk of the district court in a few days. Now, if there's nothing further, we are in recess. You are excused to leave these proceedings, Mr. Patel, Ms. Panatex, and Trooper Herbert. Thank you all.
So how many days I have?
30 days to pay.
30 days.
Thank you, Your
And-
Honor.
And,
Mr.
and
Regier.
before I let you all go, I just happen to think, Jenna, do I need to assess witness fees and do I need to assess witness fees as court costs too?
I'm not sure, Your Honor, but I can find out really quick if you want me to.
Sure.
Your Honor, I reached out to Michelle and she's saying that we do not need to assess those in the court cost.
All right. So everyone is excused from the case today. Thank you all. You may go.
Thank you, Your
And,
Honor.
you're welcome. Thank you.
Thank you, Your Honor.
Thank you. Thank you. You may go, sir. And now, that will bring us up to Tommy Robertson on the record in 2023 TR 1915, State of Kansas versus Tommy Joe Robertson. Jared Regier for the state. Mr. Robertson.
Every day in the USA, people find themselves in court.
What's that? The what? Oh, and I should have known better for Amazon, but they told me pick rocks, but I had, really specific. All right, there you go. Thank you. You're welcome. All right, we are on the record of the matter of the City of Wyandotte versus Edward Dahl, 25349 A and B.
Good morning, Your Honor. Your Honor, John Goldport, P 30758 on behalf of Mr. Dahl. Mr. Dahl, would you please put your name on the record?
Edward Michael Dahl III.
All right, good morning, both of you. Mr. Dahl, you've been here before.
Yes.
Yes. Okay, and so council today's date scheduled for the arraignment pretrial in this matter, and he asked to the arraignment.
Stand new to the charge, waiver form, and of those charges, ask for a plea of not guilty.
All right, for waiver formal reading and for plea of not guilty for the purpose of the arraignment, and asked to the pretrial counsel.
Your Honor, discuss this matter with Mr. Dahl as well as with the prosecuting attorney. It's my understanding that in return for a plea of guilty to no operator's license on possession and a plea to responsible for the expired plate, the original charges of driving while license suspended, as well as the no insurance, would be dismissed. I've explained to him his constitutional rights. He understands those constitutional rights. He understands that by entering into these plea agreement that he will be waiving certain of those rights. Also, Your Honor, he understands the sanctions with respect to these driving while license suspended or the no operator's license on possession. And at this time, he wishes to avail himself of that plea opportunity. There are no immigration issues, Your Honor.
Okay, sir, please raise your right hand. You solemnly swear or affirm the testimony about to give in this matter be the truth, the whole truth, and nothing but the truth.
Yes, Your Honor.
And you've gone over your advice of rights with your attorney, correct?
Yes, Your Honor.
You also have heard the plea that your attorney placed on the record. You may lower your hand.
Yes, Your Honor.
And as to the amended charge of no operator's license on person, how do you plead?
Guilty, Your Honor.
As to the count of expired plate, how do you plead? Responsible or not responsible?
Responsible.
And you've gone over your advice of rights and you understand all those rights, correct?
Yes, Your Honor.
And you also understand you'll be waiving some of those rights by continuing with your plea.
Yes, Your Honor.
And you understand the possible penalty as a result of your plea, whether in this court, any other court or administrative agency.
Yes, Your Honor.
Knowing all that, you want to continue with your plea.
Yes, Your Honor.
Has anybody promised you anything, threatened you, or coerced you in any way for you to enter into a plea?
No, Your Honor.
And any immigration issues?
No, Your Honor.
Counsel, if you can please party your client.
Thank you. Mr. Dahl, on March 14th of 2025, were you operating a motor vehicle in the city of Wyandotte?
Yes, sir.
And at that point in time, at some point in time, did you come in contact with the Wyandotte police officers?
Yes, sir.
And when they asked you to provide them with a valid operator's license, you were unable to do so. Is that correct?
Yes, sir.
And that's because you didn't have a valid operator's license on you at that time. Is that correct?
Yes, sir.
And also the vehicle that you were driving had expired plates on it. Is that correct?
Yes,
So
sir.
you're pleading responsible to that as well.
Yes, I am.
Defense is satisfied, Your Honor.
The court is also satisfied the plea is knowing, voluntary, and factually accurate. The court will accept your plea to the amended charge and as to the expired plate. And